Good afternoon. Welcome to this bill hearing for the House Health Committee. I'm Chair Heather Bagnall with our amazing Vice Chair Cullison. I ask for your patience if we encounter any technical or streaming issues. This hearing is being streamed on the Maryland General Assembly YouTube channel. We do have a few virtual witnesses today. Please note that food and beverages are not permitted in the gallery. Delegates may have drinks at their desks as meetings can run quite long and hydration is essential. Please make sure to turn off your phones or turn them to silent at this time. If a member is not present here, please understand that they may be attending other official meetings, they may have hearings in other committees, but they are staying apprised of our proceedings. Please adhere to our usual committee rules of one question and one answer from the panel, not one question and one answer from each panelist, and please keep your questions briefer than the answers. Today we are going to go in this order. All right, I don't see her. House Bill 619, followed by 615, followed by 677, 698, 564, 632, 598, 769, 624, and 679. Sponsors are not time limited, but please keep your testimony reasonable. And all witnesses will have 2 minutes. For the body, for planning purposes, we have 109 witnesses today. So please bear that in mind as you consider whether your question can be answered in the hearing or in subcommittee. With that, I'm going to call on Vice Chair Cullison, if you want to bring your panel up. This is House Bill 619, Interstate Podiatric Medical Licensure Compact. You can get
And Richard Block.
And you can get started when you're ready.
All right. Hopefully that they will come. Good afternoon, Madam Chair, members of the committee. For the record, I'm Bonnie Collins.
Can you grab one of the microphones?
You mean there's no mic here? I'm just Duh. Here we go. Thank you. Good afternoon, Madam Chair.
You were testing me, I know.
Or me.
Seeing if we're paying attention.
Members of the committee, thank you. Delegate Bonnie Cullison here to present House Bill 618, Interstate Podiatric Medical Licensure Compact. This compact, like all the other compacts that we have legislated over the last decade or so, seeks to increase accessibility to podiatric services by establishing a voluntary expedited pathway for podiatrists who are licensed in one member state to have their licensure recognized in another compact state, much like all the other compacts. It does this, and this is a really important concept. It does this without altering the existing Podiatric Medical Practice Act or the authority of the respective state board for each member state. It is an agreement among a minimum of 4 states. We're not there yet. This bill is being presented in 4 states as we speak. And it affirms that podiatry is practiced where the patient is located, ensuring that podiatrists treating Maryland patients remain under the jurisdiction of Maryland regulators. Simply put, this bill addresses Maryland's growing need for podiatrists by modernizing podiatric licensure. The Board of Podiatric Medical Examiners, at the last minute before the Senate hearing, expressed some concerns and opposition to the adoption of this compact. So I'm going to spend my testimony really addressing their concerns. I suspect that many of them are based on misunderstandings and are inconsistent with the experience that we've already had with, like, the physician licensure compact. So there's a concern that we might be there, that podiatric practice and service here in Maryland might be controlled by a super board, and that super board would be in the form of the Compact Commission. That's the commission that oversees the activity of the compact for all of the member states. However, it's administrative. It does not replace or supersede the Maryland board. It does not diminish Maryland authority. It does not weaken licensure standards. and it does not override Maryland disciplinary law. The Maryland Board remains the sole authority that issues Maryland licenses, defines scope of practice, investigates complaints, and disciplines podiatrists practicing in Maryland. The Commission's role is administrative and coordinating, limited to facilitating expedited licensure across state lines, precisely the same structure Maryland has operated for physicians since 2019. Commission rules and bylaws cannot override Maryland statute governing scope of practice, discipline, or professional standards. This is explicitly preserved in the compact. Maryland has participated in the physician licensure compact for over 6 years without any erosion of board autonomy or regulatory authority. We are not lowering our standards of practice. No applicant who does not qualify for licensure under the requirements for a Maryland license will be granted a license. So if someone does not qualify under our current standards, they will not be given a license. That means that every compact license is a Maryland license and is governed by our state laws. The only difference is that the licensing process is expedited for applicants from other states. In order to participate in this process, the podiatrist applicant must already hold an unrestricted license in good standing, meet rigorous education and examination requirements, and have no disqualifying disciplinary history. Maryland retains full authority to investigate, discipline, restrict, suspend, revoke any compact licensee practicing in Maryland. Compact participation does not eliminate background checks, discipline reporting, or moral character requirements enforced through Maryland law and the board. There was some concerns about this notion of a middleman between renewals. That's a role being taken by the commission. The board is suggesting that it may be an unnecessary gatekeeper. However, renewal through the compact is again administrative, designed to ensure continuous eligibility across states, not to replace Maryland oversight. In order to be renewed, a podiatrist must maintain a full, unrestricted license, remain free of serious disciplinary or criminal disqualifications. Maryland retains the ability to impose additional discipline, monitoring, or license action under state law. There was some concern from the board about the financial impact. There's minimal administrative impact on the state board if we decide to do this. Participation by enrollees, by applicants, is absolutely voluntary, and they are responsible for paying the fees to participate. And the fees would cover some of the administrative work of our board. There's no requirement in the compact that a state subsidizes the compact financially in any way. If the board is experiencing fiscal challenges, these are not caused by interstate licensure models. Ultimately, participation by the state in the compact is voluntary. Maryland retains the ability to withdraw if participation ever proves unworkable. So there's concern that going into the compact really doesn't achieve the goal of increasing the number of podiatrists. It is designed to improve access to care, particularly in underserved areas. And I've been told that areas in Western Maryland, Eastern Shore, Northern Maryland are areas that are underserved in these kinds of services. It does not require or predict an artificial increase in licensees. The workforce flexibility benefits patients, hospitals, and practices without compromising standards. Maryland's experience under the Physician Licensure Compact demonstrates that an expedited licensure provides access while maintaining stability. The compact's information sharing provision strengthens patient protection. Required information sharing ensures that discipline follows the practitioners across state lines. So there is always information communicated when someone is not meeting the standards. Joint investigations and enforceable subpoenas are enhance, not weaken, regulatory enforcement. Maryland retains full control over investigations occurring within the state and discipline imposed on Maryland licenses. This is consistent with modern best practices in the health professional regulation. HB 619 is modeled directly on a proven, successful framework already operating in Maryland. The concerns raised by the board are relatively speculative and inconsistent with our experience. For those reasons, and given the information that I've provided above, we believe that this compact accurately meets the standards of practice here in Maryland, and I hope that you will consider that the bill is modeled, in such a way to provide us in Maryland with a proven, successful framework and give it a favorable report. And I am going to turn it over now to my panel. Who would like to go first? You want to go first?
I'll go first.
Okay.
Hello. Dear Madam Chair and members of the committee, my name is Dr. Adam Lilly. I'm the Legislative Chair of the Maryland Podiatric Medical Association, representing over 266 podiatrists. I respectfully submit this testimony in support of House Bill 0619, which would allow Maryland to participate in the Interstate Podiatry Licensure Compact. From a workforce perspective, the field of podiatry is facing significant challenges. National trends show declining enrollment in podiatric medical schools. In Maryland specifically, there is currently only one in-state podiatric residency program, which limits a pipeline of young doctors to remain in the state post-residency. As Maryland's population continues to grow, projections indicate that there will be an insufficient number of podiatrists to meet the patient care needs. For these reasons and more, Maryland needs to attract and bring in more podiatrists into the state. Our goal is to open as many pathways as possible. The Podiatry Compact offers a practical solution by allowing qualified podiatrists from neighboring states and beyond to obtain licensure in Maryland, thereby helping to ensure adequate access to care for Maryland residents. You will find a written testimony highlighting the struggles of providing care in Western Maryland and how access to care is causing residents to travel across state lines for it. While podiatry is regulated differently from state to state, this compact preserves states' rights by maintaining each state's existing licensing board authority. This includes preserving individual state control over scope of practice, definitions of doctor of podiatric medicine, and public safety protections. Podiatric care is essential to every resident in the state. We treat conditions that keep Marylanders on their feet, employed in labor jobs, and maintain independence and a healthy lifestyle. Timely podiatric care is key to the prevention of hospitalizations and amputations, especially in our elderly and diabetic patients. Lack of podiatric services has been shown to result in higher Medicare and Medicaid spending, as well as added strain on hospital services. For these reasons, I respectfully urge a favorable report for House Bill 619. Thank you for your time and consideration.
Good afternoon, Madam Chair, members of the committee, and especially the Vice Chair. I would like to thank you for the opportunity to address you. My name is Richard Block. I'm the Executive Director and General Counsel of the Maryland Podiatric Medical Association. I had prepared testimony, but I think rather than repeating what both of my predecessors have said, I want to emphasize the fact that this bill and the Interstate Compact will have no monetary impact on the current State Board of Podiatric Medical Examiners. The commission, the Interstate Compact is being funded by two different grants of $750,000 each. And that has been confirmed with our representative, Jay LeBeau, who is chairing the Interstate Compact on behalf of the Federation of Podiatric Medical Boards. This bill will simply enact a compact similar to the prior compacts that have been enacted by this legislature, including SIPAC, which I was involved in, and several other compacts. They have not resulted in any diminution of the authority of the respective boards. And as been stated, the requirements for licensure in Maryland remain the same, and the authority of the board over those licenses in Maryland remains the same. The board has said that this is faith-based on the issue in their recent letter, and it's not faith-based. The grants for the money I've just referenced are in place and are being implemented through the FPMB and the commission that's being established. We are one of several states that are in the process of adopting this interstate compact. Maryland getting in on the ground floor would be a tremendous step in favor of the Maryland podiatric community. We ask for a favorable report on House Bill 619. Thank you very much.
Thank you for your testimony. I'm going to open it up for questions from the members. Seeing none, I just wanted to give you an opportunity to respond, Madam Vice Chair, because I see in the letter of concern from the Board of Podiatric Medicine medical examiners, they mentioned that they had concerns about the Board of a report from the Board of Physicians, because they said this is just like the compact for the Board of Physicians, and I don't know if you had seen it, and they were speaking to unwritten, vague, to be determined rules and bylaws, but am I correct that we haven't achieved 4 states, so we would be one of the states that would be working to draft those regs and bylaws should we pass this?
You're correct, Madam Chair, yes, that we would be one of those 4 states. Hopefully, others will sign on during this legislative session and we'll meet that threshold. But as, you know, a beginning member, Maryland would definitely have a place in making decisions on the commission.
Okay, thank you very much. Seeing no further questions from the members, this concludes this hearing on House Bill 619, and we are going to go to House Bill 615, Health Facilities, Confidentiality of Medical Records, Crisis Pregnancy Clinics. Vice Chair Cullison, if you want to bring your panel up, and you can get started when you're ready.
Karen Nelson? Thank you, Madam Chair. Again, I am Bonnie Cullison here to present House Bill 615. And the very first thing that I want to say here is what this bill is not. It is not in any way legitimizing facilities who do medical practices without a license, okay? If there is a facility that is doing sonograms and ultrasounds without a medical license, I'm not legitimizing that at all. I don't speak to that at all in this bill. I am not restricting free speech with this bill. I am not restricting anyone's ability to access these facilities. I am simply protecting personal information. This bill assures us that as a state, we continue to ensure that sensitive information about our residents, particularly related to their most personal decisions around pregnancy and reproduction, are kept confidential. In 2023, we codified the importance of safeguarding sensitive reproductive information and records by creating the definition of legally protected health care in a shielding bill. Additionally, in 2024, we enacted the Online Data Privacy Act, which establishes heightened protection for consumers' health care data, including gender-affirming care and sexual and reproductive health information. That is that is not protected health information subject to HIPAA. All right, so we protected it in our state laws. It is not currently protected under the federal standards of HIPAA. This bill simply furthers what Maryland has already established as information that deserves protection and is not allowed to be shared without the explicit consent of the individual, by extending those protections to cover sensitive information gathered about a person at an unregulated privacy center. These protections are particularly important now when reproductive rights are being litigated across the country. People turn to crisis or unregulated pregnancy centers at some of the most vulnerable moments of their lives, seeking honest information, compassionate support, and privacy. No one who reaches out for help should have their personal data exposed or exploited. Protecting their confidentiality is not optional. It is a basic matter of dignity and safety. Unregulated pregnancy centers often present themselves as providers of free, private services, but behind those assurances, they target vulnerable pregnant people with misleading claims while collecting deeply personal information. The visitors who go to these centers trust them, and that trust is being violated. These centers do offer free, private information and resources. However, their mission is very limited to helping people make a singular choice when it comes to reproductive freedom. Their information is slanted and sometimes misleading. They may present themselves as providing health care, even when there is no licensed practitioner on site. At the same time, they gather personal information about the person. It is imperative that we prevent their confidential information from being shared without their consent. These facilities have received grants, sometimes with federal tax dollars, with limited or no accountability for funds. We have no way of knowing if the confidential information is being protected. It is possible that they're sharing it across state lines where the person could face criminal charges. This bill seeks to maintain that privacy. I'm going to just keep saying it. It's about the privacy and protection of the information. Because they're not healthcare providers, they are currently not subject either to federal HIPAA privacy protection or our Maryland state privacy protections. While some of them claim on their websites that they have been required by law to keep health information protected or certify that they are HIPAA compliant, the reality is that unless they are a licensed medical facility, that is not the case. Despite these claims, they are widely sharing visitor information with their thousands of volunteers, and at least in one case, with the public. Just one example of that is a national network of crisis pregnancy centers put a training video on their website showing how to use the organization's data collection software, and viewers could see the full names of 13 women who visited the center in Louisiana, along with the information about their due date, their last menstrual cycle, and whether or not they were given an ultrasound or pregnancy test. There's even a map showing where each of those women live. Understanding the importance of this bill, we've met with several advocates who are working on technical amendments to ensure that the bill is appropriately focused on the straightforward goal of ensuring that Marylanders' confidential information is protected across organizations. This committee, this legislature, and the voters of this state have consistently reaffirmed their commitment to a person's right to make all healthcare choices, including reproductive care choices. In the current political climate, we as policymakers must defend these rights. Shielding sensitive information is just one of the ways we can do that, and HB 615 is the right vehicle to extend the protections we already have in place. Thank you very much for your consideration, and I humbly ask for a favorable report. And I'll turn it over to, who wants to go first? Go ahead.
Sure, go ahead. I'm happy to go. Good afternoon, everyone. Thank you for allowing me to speak today. My name's Karen Nelson. I'm the president and CEO of Planned Parenthood of Maryland. So, for almost 100 years, we're coming up on our 100th year anniversary in Maryland. Planned Parenthood has been dedicated to serving Marylanders as a healthcare provider. And in providing that care and service, we do it with holding confidentiality and non-judgmental services in very, very, very top regards. We make sure that we're compliant with all of the privacy laws, and we continue to ensure that high-quality care can be delivered safely. Unfortunately, the crisis pregnancy centers, or CPCs, are not held to the same standard. There's a widely held misconception that these centers fill the gap for pregnant people looking for care. These centers are not necessarily located near neighborhood health centers and do not offer the health care and support to pregnant people. There are many organizations, and the delegate talked about this already, that deem the information to be inaccurate and may be biased for pregnant people who attend these centers. But what is really important is that since there is no regulation, there's no way to ensure that the privacy of those who visit these facilities in search of what they believe to be legitimate health services. So there are organizations that have collected information and used the health data without the permission of the folks that came to the CPCs, and it's been allowed to continue. So let me just say I am not supporting this legislation in an effort to do away with CPCs. I'm supporting this legislation. Our organization is supporting this legislation so we can ensure that there's confidentiality across the board. Thank you.
Madam Chairwoman and members of the committee, my name is Gloria Totten. I'm the president and founder of the Public Leadership Institute, which is a national policy and legislator support network. We are a multi-issue organization. I'm here to testify in support of HB 615. I want to say a little bit more about what information they are collecting and restate again that this is about the data privacy collection and keeping that confidential. When clients enter crisis pregnancy centers, they're often asked to fill out intake forms, much like you would do at a regular medical office, except these forms also ask for extensive personal and health information, including history of sexual partners, sexual orientation, citizenship and documentation status, your housing situation, and more. So this goes beyond what is regularly collected. We know that over 80% of centers in Maryland also advertise obstetric ultrasounds indicating that they form medical scans. So they fit squarely within the medical services protection that's needed. However, unlike a traditional medical facility, all of that information is at risk because, as has been stated, CPCs fall into a blind spot for both HIPAA and existing state privacy law. This bill is simply designed to fix that loophole. If you follow the national average of individual CPCs, each seeing about 300 new clients per year, Maryland centers could be collecting the private health information of as many as 10,000 women each year. Further, the information of up to 100,000 prior clients could already be stored and at risk. Even if the pregnancy centers already maintain health information confidentially, it would be appropriate to require them to do so formally under the state medical privacy law. However, there's ample evidence that across the nation, this isn't regularly the case. Such centers frequently violate clients' privacy by placing their personal health information in online databases accessible to their national affiliates, third parties outside the pregnancy center. At times, these centers have even been found to leak clients' private sensitive information publicly.
Can you wrap up your testimony for us?
Any organization that provides medical services or collects medical information should be required to keep it private. HB 615 would ensure that these privacy protections are applied across the board.
Thank you very much for your testimony. Are there any questions from the members for this panel? Delegate Kaufman.
Yes, Delegate Cullison, I wanted to read you a little bit from the Attorney General's letter of support and concept. I was struck by one sentence in particular, and I want to see what your response is. They say granting CPCs the status of healthcare providers could mislead consumers and legitimize organizations that disseminate medically inaccurate information and delay access to legitimate care. And then they also say that your legislation could inadvertently legitimize non-medical organizations. So what is your response to the healthcare, to their comments, and have you had a chance to speak with Ms. Williams in the Attorney General's office?
Thank you, Delegate, for the question. The bill has been significantly amended from its original draft in order to provide, in order to prevent that kind of legitimization of the practices. Here we are speaking, we actually created another section of code that speaks to what we're calling unregulated pregnancy centers and speaks directly to the data itself. But I am more than willing to work with the Attorney General's office to see if there's language that his office needs in order to make that even more clear.
Thank you, Madam Chair.
Thank you very much. Delegate Morgan.
Thank you, Madam Chair. Thank you for the presentation. Excuse me. I missed that part where you said there was another state where they were actually showing a map of some of the people that went to a crisis pregnancy center. But do you have any evidence that this is happening in Maryland at all?
I mean, I think what we're interested in is making sure that medical information on whether you're in a medical facility or not in a medical facility is protected. And we are interested in ensuring that pregnant people and women that go to, whether it be a CPC or whether it go to Planned Parenthood, that you're going to have protected health information.
Thank you. So do you have any information on how many of these crisis pregnancy centers we have in the state of Maryland versus how many Planned Parenthoods there are in the state of Maryland?
We do have that information, and I can provide that to you in writing.
Okay,
Yeah.
that'd be great.
There are 39 in Maryland.
39 crisis pregnancy
39
centers?
in Maryland, 80% of which advertise medicalized services.
Okay, but most of those are nonprofits, right? Not receiving any taxpayer funding at all?
As the delegate said in her testimony, there has been some federal funding that has gone, but otherwise, no.
Okay, thank you. Thank you, Madam Chair.
Delegate Chalet.
Thank you. You said, following up on Delegate Morgan, 38 crisis pregnancy centers and how many Planned Parenthoods?
39 crisis pregnancy centers in Maryland.
We have 9 Planned Parenthood centers and telehealth services.
In this state? Okay.
Yes.
But my question was for Delegate Cullison. In your testimony, you said that crisis pregnancy centers make misleading claims. Can you name some of those?
Claims about talk about the difficulty with, or the potential challenges of having abortion care, of how there are ways that they can not have an abortion so that there's lots of access to other services and options that they don't then absolutely follow up on. So, they are guiding the people in a particular direction. They're not giving them unbiased information on either side.
So you said I was having trouble following you. Their misleading claims are that, can you summarize again?
So they would present abortion as something that is not reasonable or viable or something that the person should actually, an option the person should actually consider.
So crisis pregnancy
follow
centers.
up?
I was just trying to get her to, crisis pregnancy centers' misleading claims are that abortions may have side effects.
Negative
And
impacts.
because of that, you think that's misleading?
I think it's guiding them in one way as opposed to helping the person make a personal decision.
Yeah,
Yeah.
thank you.
Seeing no further questions, this concludes the testimony of this panel. I have one favorable and one unfavorable panel. So if I can call Robin Elliott.
Good afternoon. Robin Elliott here today on behalf of the Women's Law Center of Maryland and the American College of Nurse Midwives, the Maryland affiliate. In support of the bill, we have been working with Delegate Cullison and the other stakeholders in figuring out how to hone the bill so it really accomplishes what Delegate Cullison intends. There is a gap in privacy laws, and this bill seeks to fill it. It's very important that health information provided in any setting, that we look to ways that that health information is vulnerable, and this bill closes one of those important gaps. Thank you very much.
Thank you for your testimony. Are there any questions for this witness from our members? Seeing none, thank you very much for your testimony today. We have one unfavorable, Christine Crone. You can begin your testimony when you're ready.
Good afternoon, members of the committee. My name is Christine Crone, and I'm here on behalf of the Maryland section of the American College of Obstetricians and Gynecologists. Thank you to the sponsor for bringing this bill forward with the stated intent of protecting the private information of clients who visit unregulated pregnancy centers. We also appreciate the willingness of the stakeholders to work on the amendments, and Maryland ACOG participated in these discussions. However, even with forthcoming amendments, Maryland ACOG must respectfully oppose. Maryland ACOG absolutely supports safeguarding individuals' private health information. No one's personal data should be shared without their consent. At the same time, we strongly believe that House Bill 615 will not achieve the goals you're seeking to accomplish, and we believe that additional time is needed for more meaningful discussions. Maryland would be the first state in the nation to enact legislation of this type. That alone suggests a need for additional time to carefully refine the approach to ensure it's legally durable and effective. Other states have pursued laws aimed at advertising or practices of unregulated pregnancy centers, and those efforts have in several instances faced legal challenges, including challenges at the federal level on the basis of constitutional protections for speech. Unregulated pregnancy centers often operate in ways that allow them to avoid existing medical and consumer protection oversight. Because of that, Maryland ACOG believes that the language in House Bill 615, even as amended, is unlikely to meaningfully protect the public or prevent harms we seek to address. For these reasons, we urge the committee to allow more time to develop a solution that protects personal health information, withstands constitutional scrutiny, does not inadvertently legitimize unregulated pregnancy centers, and avoids unintended consequences. In the interim, Maryland ACOG stands ready to support efforts focused on accurate evidence-based public education. Thank you for your consideration. We urge an unfavorable report.
Thank you for your testimony. Are there any questions from the members for this witness? Seeing none, thank you very much for your testimony today. This concludes the hearing on House Bill 615. We're now going to go to House Bill 677. Do we have Delegate Congolo? Oh, okay. Reduction Facilities and Veteran Service Organizations Hydrolyzed and Soil Remains Immunity. You can go ahead and bring your panel, and you can begin your testimony when you're ready.
Good afternoon, Madam Chairwoman and members of the committee. For the record, I'm Julie Butler, and I'm here on behalf of Delegate LaToya Congolo to present House Bill 677, Reduction Facilities and Veteran Service Organizations Hydrolyzed and Soil Remains. This bill is a cross-file to Senator Simon Ayers' Senate Bill 42 and has received bipartisan support. I also want to share that it has the support of the Maryland Veterans Caucus. This simple legislation is a necessary update to our current laws. Maryland already follows funeral homes and crematories to facilitate the disposition of unclaimed veterans through cremation. However, the law doesn't recognize newer environmentally friendly methods of disposition, specifically soil disposition or water disposition, scientifically known as natural organic reduction and hydrolyzed reduction. Simply put, we're asking that our law is updated to include cremation, water, and soil disposition. This bill ensures that every veteran, regardless of the method of reduction they or their family chooses, is treated with dignity they earn through their service. It protects the operators and organizations working to honor that service, ensuring no veteran is left behind due to legal technicalities. We want to support those who have served our country and ensure their final wishes are honored. I urge a favorable report on House Bill 677.
Madam Chair, members of the committee, my name is David Lutzow, Senior Master Sergeant, Air Force retired, and also a Maryland Military Coalition Director. We have strong support for this bill, and we ask for a favorable report from this committee. Like his companion bill that was talked about from Senator Simon Ayers, 677 addresses an additional issue. Individuals who are acting in good faith cannot be held civilly liable as the registered reduction operators. This is important because the registered reduction operators are not listed or identified in Maryland Business Regulations Section 5803, nor the Health Occupations Section 7406, leaving them open for potential liability claims. This is why this bill is so important. A favorable report from this committee. Again, no person, organization, or company should be held liable for acting in good faith in relating to the disposition of unclaimed veterans' remains or eligible members from their family. For these reasons, the Maryland Military Coalition requests a favorable report from this committee and would like to thank the delegate for sponsoring this legislation.
Thank you for your testimony. Is Walter Nathan Malloy Jr. here? Oh, I have you on the sponsor panel as well. Is that correct? Mm-hmm. Okay, you can go ahead and offer your testimony.
Good afternoon, members of the committee. My name is Walter Nathan Malloy Jr. I'm the attorney and lobbyist for the Maryland State Funeral Directors Association, and we're supporting Bill 677. Thank you.
Very efficient testimony. We like that. Are there any questions for this from the members for this panel? Seeing none, thank you very much for your testimony today. This concludes the hearing on House Bill 677, and we are now going to go to House Bill 698. This is State Board of Morticians and Funeral Directors Board Operations and Regulation of Crematories and Reduction Facilities, and we welcome back Delegate Bhandari to our committee. Delegate Bhandari, you can, if you want to. So you are your panel, correct?
Yes.
As our now speaker says, you are enough. You can start your testimony whenever you're ready.
Okay. Good afternoon, Chair Bagnall. So proud to call you Chair. Madam Vice Chair not here, and distinguished member of the Health Committee. For the record, I'm Delegate Bhandari, representing District 8, together with our wonderful Delegate Ross, and testifying on House Bill 698, State Board of Mortician and Funeral Directors Board Operation Reduction Facility. If the committee recall last year briefing, there was a silence in this room, a silence so heavy. it spoke louder than words. It was the silence of grief, the silence of broken trust, and that silence demanded this bill and they demanded the action. Not only as a legislator, but as a son and a husband and a father. I understand the profound pain of entrusting the loved ones to others. Since taking office, I've stood beside nearly 450 families during funerals. I've seen their vulnerabilities and I have felt their trust. And I'm deeply grateful to many funeral homes across our state that serve families with professionalism, compassion, and care. The vast majority do this sacred work with honor. But when even one establishment cuts corner or fails grieving families, it takes confidence in the entire system, and we question their character, we question their confidence, and we question their commitment. This is why this bill matters. When a family walks out of funeral home, they should leave with peace, not question. House Bill 698 strengthens oversight, clarifies authority, and ensures ethical standard under the State Board of Medicine Funeral Directors and Crematories. It provides accountability, clear registration requirement, and professional standard to protect public trust. This is not about bureaucracy, it is about restoring confidence. Human remains are not commodities. They represent someone's parents, someone's child, someone's spouse, someone's whole world. Last year, the House passed this carefully worked legislation. We spent hours and hours and hours in committee and subcommittee. We listened, we refined it. This year, I'm especially grateful to Finance Chair, Madam Chair Bidel, for her leadership as the cross-filer of this bill and for helping move this hopefully important work together and forward. I know not everyone agrees with every provision of this bill. I respect that. I remain open to listening and working together to strengthen this legislation. But we must never compromise on dignity and public trust. Again, I say, but we never compromise on dignity and public trust. We cannot change what some families have endured, but we can honor them by ensuring that no Maryland family is ever left in the dark again. I would like to thank Madam Speaker Penny Melnick and Governor Westmore on this, working on these issues. Equally grateful to all our delegates, Kathy Saliga, Delegate Hutchinson, and everyone on this committee for working so hard on this bill. In death, dignity must never be optional. For those reasons, I respectfully urge a favorable report. And thank you, Madam Chair.
Thank you for your testimony, and I think we all recall the challenges we experienced, so thank you for your continued work on this issue. Do we have questions from the members? Delegate Hutchinson.
Madam Chair, Delegate, thank you so much for bringing this back. I remember that story, I think it was down in Charles County, that was just horrific for us, and you prompted you to put this in a late bill last year, correct?
True.
Did we just run out, is that what happened? You didn't get a Senate, we just ran out of time, and you're bringing it back in its same posture this year?
We worked during the interim. I had a meeting with the Senate Chair, Madam Bidel, and they work on the Senate side. And thank you, Delegate. And we are open to work with the board. Has some concern and they have some suggestions. We'll be working with the board with the technicalities. And one thing, this bill looks so bulky because there is the business regulation article regarding the crematories currently overseen by OCO. So don't surprise, this bill is so thick.
Great. Well, thanks for your diligence on this. Appreciate it.
Are there any other questions from the members? I just wanted to give you an opportunity. I know the board is coming up after you, and they have some recommendations on amendments, but there's also a letter of information from Maryland Judiciary and from, amendments from the Funeral Consumers Alliance of Maryland and Environs. Have you had an opportunity to speak with them, and can you just speak to those conversations?
Definitely. We'll be working together with all those stakeholders.
Thank you very much. Thank you for your testimony. We are now going to we have a favorable with amendments, and it's Albert Bloomfield and Charlotte Hoffman. You can get started with your testimony when you're ready.
Chair, Vice Chair, and members of the committee, thank you for this opportunity to testify. My name is Albert Bloomfield, and I'm appearing today on behalf of the Board of Morticians and Funeral Directors in support of House Bill 698 with amendments. The board appreciates the substantial work reflected in this legislation. House Bill 698 modernizes and strengthens the statutory framework governing our board, particularly with respect to crematories and reduction facilities. The board strongly supports provisions that clarify statutory authority, establish clear reinstatement pathways when no unlawful practice has occurred, increase civil penalties to better reflect the seriousness of violations involving human remains, and provide authority to seek injunctive relief and receivership in serious cases that threaten public health and consumer protection. These provisions significantly enhance the board's ability to protect the public while maintaining due process. However, we have concerns regarding the proposed requirements for crematories and reduction facility operators to demonstrate financial stability. The bill does not define that term or provide objective criteria. As drafted, this provision would require the board to assess and interpret financial statements and determine whether an applicant meets a subjective financial threshold. The board is not structured, staffed, or resourced to conduct in-depth financial evaluations. Without clear statutory benchmarks, this requirement may lead to inconsistent decision-making and potential legal challenges. If this provision remains, we respectfully ask to define financial stability and identify specific documentation requirements. The board also believes that the expansion of regulatory authority contemplated in this bill must be accompanied by acknowledgement of inspection staffing needs. Effective enforcement requirements requires sufficient personnel. For these reasons, we support it, but there not only are the list of the board's amendments important, but those who oppose also have legitimate concerns that the board also shares.
Thank you, Chair, members of the committee. Charlotte Persephone Hoffman, here in my capacity as First Vice President of the Board of Morticians and Funeral Directors. First off, thank you all for your work last year and this year on this bill. As Delegate Hutchinson said, we largely ran out of time at the end of session in order to get it through the Senate. It was HB 1555 last year. So we have a number of specific proposals on the language that's been added since the 1555 period, most of which we like, but there's a few things that we wanted to specifically address. So first, we have concerns regarding the language in section 7-405 that would authorize crematory and reduction facility operators who are not licensed morticians or funeral directors to engage in making pre-need contracts with consumers. Pre-need contracting has historically been closely regulated due to its financial and consumer protection implications. So we wanted to raise that issue with you so that you knew that expanding the authority to people who are licensed as crematory operators could raise potential issues. Second, we believe that the bill represents a significant policy shift and that it needs to we need to have further discussion with stakeholders before some of these changes are codified. There's also language clarifying in our amendments, clarifying that we do not want to operate as a mediator in private disputes. So currently, there's language that would suggest that where complaints come to us, it would be our job to try to resolve that as a mediator with the complainant and the respondent. This is sort of outside of our complaints process, so I'm happy to talk more about that in questions. And then finally, while there is the proposal to change our name, there would be significant costs associated with that, so we are opposed to that. Thank you very much, and we are happy to answer your questions.
Thank you very much for your testimony, and I also just want to say thank you for your continued work. I recall that when we were dealing with this, you were quite new to the job, so thank you for your continued efforts. Are there any questions from the members? Delegate Martinez.
Thank you, Madam Chair. And thank you all for your work as well. I just had a question for Charlotte. What legislative district do you live in?
I live in the best legislative district in the state, District 22.
Thank you. That is so.
Apologies to all the other legislative districts.
Delegate Chalega.
Thank you, Madam Chair. Thanks for being here. The issue of cremation as it's being expanded to include
Alkaline hydrolysis?
And natural organic reduction.
those two things,
Yeah.
thank you. So you said something about pre-need. I picked that up in the bill, thank you. Can you help us understand the difference between Office of Cemetery Oversight and you guys with regards to this? Is there a difference of language? I believe there's some confusion. If you can help us with that. And would this bill fix it, or do we need something else?
This bill would fix a lot of it, yeah. So currently crematories are regulated either by the Board of Morticians and Funeral Directors or by the Office of Cemetery Oversight. And we regulate, I believe, 63 of them. Does that sound right? Roughly 63. Whereas the Office of Cemetery Oversight has about a handful. That's 4 or 5. The question of which of our agencies is responsible for it depends on whether the owner of the crematory is a licensee under the Board of Morticians and Funeral Directors. So if it is a crematory that's owned or operated by a mortician as like a side business from a funeral home, then we regulate it. If it's owned by people who own a cemetery, then currently the Office of Cemetery Oversight regulates it. This has caused a fair bit of confusion in the past as to who actually has oversight over individual things. And it's led to some oddities in the ways that our regulations are different. So this bill would address a lot of that by shifting that handful of crematories that are under OCO to the Board of Morticians. So we would be in charge of all of them. That would allow us to have consistent regulations for all of them, consistent inspections, consistent, expectations of what should be done. And it will also have one agency through which other organs of the government will come when they hear that there's a potential issue with the crematorium. So, if the Department of Health hears about something, they know to come to us rather than have to look up the ownership structure of the particular crematorium. Now, as for the questions about alkaline hydrolysis and natural organic reduction, those are alternative processes for the disposement of human remains other than cremation. So alkaline hydrolysis rather than cremation, you would dissolve a body in an alkaline solution over a number of hours, and then you would have like the bones at the end, which would then be crushed in the same manner with bones with cremation. Natural organic reduction, on the other hand, is basically human composting. Both of these were permitted in Maryland under a statute a few years ago. I'm forgetting exactly how long ago it was. We have been in the process of drafting regulations with OCO as to how those industries will actually operate in Maryland. This bill would transfer both of those also to the board. I will tell you that the difficulty of writing identical regulations between two different organizations of the state, the Office of Cemetery Oversight, which is under the Department of Labor, and the Board of Morticians and Funeral Directors, which is not technically under the Department of Health, but they handle all of our stuff. It is incredibly complicated because there's two different sets of lawyers pushing in two different directions. And we recently had an issue where, OCO was being told by, their higher ups, we need to get these regulations out. And so they actually submitted their draft regulations before ours were ready to go out. This would simplify all of that, make it a lot easier for, honestly, all of you to oversee how this works. I think I answered your question probably in far more detail than you wanted.
I understood that those regulations were promulgated. They're maybe on the register somewhere.
They are in the process.
So it probably needs to pause so that all this can be lined up or fix it with this bill.
So
you can't have two different regulations
So the
for the same
regulation,
process.
sorry, I didn't mean to interrupt you.
Go
The
ahead.
regulations are currently effectively identical. There's a few little things or references to the board or to the office. Ours have been submitted. They should be, I forget precisely where they are in the process, but they'll be under review. So we should have those regulations, shortly. This bill wouldn't go into effect until October 1st. So we'll probably see those regulations in effect prior to us inheriting OCO's oversight. Now, will we likely come back later to clean up some of the issues in language in the regulations? There's a decent chance, but that's a question for later.
Thank you for indulging us.
No, I think we all had the same questions, so thank you. Delegate Hill.
Thank you, and thank you both for being here. There is a letter in our file that you may not have seen from Hartzler's Funeral Home. They're located in Carroll County and Frederick counties. And they have a couple of concerns that I'd like you to address. They say that they want to see alkaline hydrolysis removed from the definition of crematory, and want to know that you're good with that because this will confuse the consumer. They say that the bill expands the law that allows standalone crematories and natural reduction facilities to sell pre-need, not just licensed funeral directors, morticians, and surviving spouses, and that's contrary to the current law. And they think that would be a problem for the funeral service profession and makes disposal service fighting for business, and that's an issue. And then they also say it will require crematories and affiliated companies to file financial statements with the Board of Morticians disclosing confidential financial information. Do you have a response to those three concerns?
So I was going to say, I believe a lot of those came as part of the cemetery regulations that the OCO simply moved from the cemetery regulations and moved into this bill. And so I think that goes to what Charlotte said in terms of us having the ability as one body, as a board, to look at those regulations along with the legislature to have them make sense. But we shared, I think, all of those same points earlier.
So you would not say that you're fine with an amendment to remove these things. You're saying you would want to have further discussion about whether they should be removed?
So the second and third actually are in our proposed amendments. And the first, which was, sorry, remind me really fast.
The first one was about that the definition should not include.
Oh, the definition of alkaline hydrolysis being under crematory. So the issue there is that was how the law was drafted by the Maryland General Assembly several years ago. So there's been some uncomfortableness within the board, within the profession about them being lumped together. But that's sort of a vestige of that original legislation. We would be in support of separating those out. I don't think that was specifically included in our amendments, though.
I would definitely agree with them that historically, when people hear the word cremation, they think fire cremation. And I think there's going to be an education and a ramp up to people understanding what alkaline hydrolysis actually is and the process. And so having it as its own definition is probably important.
So if I may follow? So you will be talking with the sponsor to get all those amendments to
We'd
us.
love
They're
to.
a little bit more than what you've already offered, right?
Absolutely.
Okay, thank you. Thank you, Madam Chair.
And you know our conference room is always available, as does the sponsor, as we often go in there and work things out. Are there any further questions for this panel? Seeing none, thank you very much for your testimony, and thank you for continuing to work with the bill's sponsor. We do have an unfavorable panel. If I can call out John Mitchell and Walter Nathan Malloy Jr. Oh, I'm sorry, and Daniel Simmons as well. Simons.
I'm John, actually go by Jack Mitchell. I am a sixth-generation funeral director in Baltimore, past president of the Maryland Funeral Directors Association, and I recently had the privilege of serving as the president of the National Funeral Directors Association. My family owns Delaney Valley Memorial Gardens, and we have a crematory there. So we are very experienced in all facets of death care. And this bill, on the surface, we're speaking unfavorable, not really on the primary intent of the bill, the issue of bringing the regulation of crematories that are at cemeteries over to the State Board of Morticians. I don't see as problematic for Maryland consumers in and of itself. But it has more to do with, it is a 56-page bill, and really some of the issues that have already been brought up here. Those Hartzlers in Carroll County, they must be sharp people because they wrote everything I was going to say. But yes, there's certainly an issue with the notion of crematory operators being able to take care of pre-need cremations with families. We have crematory operators that work for us. They took a class to learn how to operate a machine, that machine being a retort, and learn the science of it, whereas funeral directors, we went to school, served apprenticeships, passed board exams. We take continuing education because we wanted to take care of families going through those most difficult moments of their lives. So our crematory operators are not qualified to do that, so I wouldn't want to see that happening. And some of that comes, it seems like some of the language that's being brought into the mortician side was kind of copy and paste that I think Nathan's going to speak more on that. Coming from the crematory and cemetery side, there would now be language in Title VII under the Board of Morticians that has to do with not recycling graves and that kind of thing. So there's just enough language in it that we feel like should be cleaned up. Thank you.
Okay. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Daniel Simons. I'm a licensed funeral director, certified crematory operator, and current president of the Maryland State Funeral Directors Association. I respectfully appear before you in opposition of 698 as drafted. To be clear, we are neutral on transferring regulatory authority for crematories from the Office of Cemetery Oversight to the Board of Morticians and Funeral Directors. That change alone is not a concern. The problem lies in the additional provisions included in this bill. First, the bill includes alkaline hydrolysis in the definition of crematory. Alkaline hydrolysis is a separate and distinct process from flame cremation. Placing it under the same definition will confuse consumers and create regulatory ambiguity. In Maryland, if Maryland chooses to regulate, or I should say, as Maryland chooses to regulate alkaline hydrolysis, it should be addressed separately and clearly classified under reduction facilities, not folded into the crematory definition. Second, and more concerning, the bill expands pre-need sales authority to standalone crematories and natural organic reduction facilities. Pre-need contracts are not simple retail transactions. They involve fiduciary obligations, trust funding requirements, regulatory compliance, and consumer safeguards developed over decades. Under current law, only licensed funeral directors and morticians can engage in the process of making pre-need funeral arrangements for good reason. Allowing standalone disposition facilities to sell pre-need contracts shifts funeral service from professional care to a commodity. When, where, and how to safeguard consumer funds paid in advance to reduction facilities adds a whole nother layer of complexity. Finally, requiring CPA-certified financial statements from crematories and affiliated companies is truly just unnecessary and intrusive. House Bill 698 is drafted, destabilizes the professional framework, and that protects Maryland consumers. Thank you.
Good afternoon, ladies and gentlemen of the committee. Madam Chair, Madam Vice Chair, my name is Walter Nathan Lloyd Jr. I'm an adjunct professor of mortuary law at the Community College of Baltimore County. I'm a licensed attorney, and I'm a licensed mortician, and I'm the lobbyist and attorney for the Maryland State Funeral Directors Association. There's certain representations that were made this afternoon that I would like to clarify. This is a completely different bill from the bill last year, 1555. There are very few vestiges from Bill 1555 in this bill. I met with the sponsor several times in the interim, and not once did he mention that they were working or he was working with the Senate on drafting this bill. I came to this committee last year and begged and pleaded with the committee that you include the Maryland State Funeral Directors Association in the discussion about bills pertaining to funeral service. I just learned of this bill in mid-January when I was attending an OCO hearing. I did receive a call from Delegate Bendari after that saying, "Oh, did you see the bill?" I said, "What bill?" He said, "The bill that came out in the Senate, and they're asking me to sponsor." I'm going to refrain from saying the rest of what he told me, but this bill is problematic. The bill that came out of this committee last year went to subcommittee, and in subcommittee, we agreed on certain language that would go in the bill that went to the floor. The language that we agreed on was different than the language that went to the floor, and I called various members of this committee and raised my concerns and was told, "Oh, well, you need to go to the Senate now and address that." When the Senate version hearing was held, we addressed it in the Senate, and I believe that that's the reason why the bill never made it. Yes, it probably ran out of time, and it was good that it did run out of time. House Bill 698 is extremely problematic because of the copying and pasting of Title V business regulations, and we ask that you issue an unfavorable report as well. Thank you.
Thank you for your testimony. Are there questions from the members for this panel? Delegate Shalega.
Thank you. Thank you all for being here. Good to see you, Mr. Mitchell. Thanks for your wonderful service to Will Sauerbray and Martha Klima last year. It was really nice. Nathan, in your opinion, what do we need to address this, irrespective of this bill? Last year, we worked together very hard. It was disappointing to see the way that bill, transgressed, came out, or not transgressed, but how it transpired, it came out of here, went to the Senate. I shared your frustrations with that, but, and maybe we should take this offline because we have a ton of witnesses today, but I would love to know how you think we need to fix this system, and, and again, if it's too detailed right here, we could work offline, but maybe a mile-high view of that.
It's extremely detailed. However, I agree with the board. The regulations require that the Board of Morticians and the Office of Cemetery Oversight currently promulgate identical regulations. The Board of Morticians is more than likely tired of arguing with the OCO about what the regulations should be pertaining to both to cemeteries that have crematories and morticians operators who have crematories. So more than likely needs to be removed from OCO and transferred. Everything else that's in this bill is problematic because it cuts and pastes, or copies and pastes, certain provisions from Title V, and I'll just give you two examples. My colleagues mentioned them. The regulation of recycled graves is not under the purview of the Board of Morticians. That's verbatim from the cemetery regulations in Title V. There's also mention of an advisory council that will be reported to by the board regarding an annual report. However, there is no advisory council to the Board of Morticians. There is, surprisingly, an advisory council to the Office of Cemetery Oversight. And that advisory council of Office of Cemetery Oversight has 11 members, I believe, that advises the director of the Office of Cemetery Oversight on policy. So there are many other points of reference in this bill that need to be changed. Many have mentioned the definition of crematory. Many have mentioned the pre-need issue of selling of pre-need by crematories that have unnecessarily expanded, in fact, made it illegal. I believe the expansion of crematories to sell pre-need says, provide any goods and services, including, and I quote, any form of preservation and disposition that a mortician normally provides in the ordinary course of business. You mean to tell me you want a crematory operator who took a one-day course to provide preservation and disposition that a mortician who's gone to school for 3 years of training and labs and embalming to provide the same service? No. Problem is, they just inserted these provisions in the current legislation or the current bill version of Title VII and thought it would be okay. We've got to stop doing this. We've got to make sense of what we're submitting as bills in order to avoid the long drawn-out debates, in committee. You know, I got the 20 points in my written comments. After a while, I stopped. It was just ad nauseum. It got to be too much. So, in my opinion, if you're not going to throw out everything else except moving the cemeteries over to the board, the bill shouldn't pass. It shouldn't go beyond the committee. There should be probably a work group or a study or task force to sit down and have meaningful, intelligent conversations about how to improve funeral service. I offered that last year. I'm offering it again this year, and I encourage the committee to take me up on it. We can bring professionals together to decide what is and what is not good for funeral service for the future. Thank you very much.
Thank you very much for your comments and for your work. Seeing no other questions, I will say that you have a really great bill sponsor who I encourage you to work with, and this committee. You have dedicated members that I know are willing to work. And the sponsor in the Senate is the chair of the committee. So I know that she is very reasonable to work with as well. I believe the hearing on this bill in the Senate is tomorrow. So I'm going to strongly encourage everyone to talk between today and tomorrow and consider what your approach is going to be in the Senate, because you've got a lot of people here that are willing to do this work.
Thank you.
Thank you.
Thank you very much for your testimony today. This concludes the bill hearing on House Bill 698. We are now going to move to House Bill 564, which is Business Regulation, Pet Cremation and Burial Services Requirements, Pet Cremation and Burial Services Consumer Protection Act. Delegate Allen, if you want to bring your panel, and you can get started as soon as you're ready.
Yes, ma'am. Thank you, Madam Chair. Bet you guys didn't know it was District 8 Day in the committee today. All right, Madam Chair, members of the committee. For the record, my name is Nick Allen. I'm here today to testify in support of my bill, House Bill 564, the Pet Cremation and Burial Services Consumer Protection Act. So the aim of this bill is rather simple. We're trying to establish additional consumer protections in the area of pet cremation and burial services. Anyone who knows me will tell you how much I love animals, especially our pets. I'm actually wearing my tie today in honor of our two black rescue dogs at home. And for many of us, our pets aren't just animals, they're part of our family. And when one of our members of our family die, we grieve for them like anyone else. And during this incredibly sad and vulnerable time, we also have a responsibility to ensure their remains are handled in a dignified way. Again, just as we would with any other loved one. And we often turn to businesses who specialize in these services. I simply cannot imagine losing a furry family member and then days or weeks later finding out that what I thought were their remains turn out to be just sand or some other building material. And yet this happened just last year in Baltimore County to multiple families. And I simply cannot imagine the devastation they must have felt or how violated they must still feel. As a corollary to this, I'll also point out that the people who did this pled guilty just, I think, yesterday in court and are facing serious jail time as a result. So you will soon hear from some of our friends, and they'll share their personal stories about this. But I want to talk about what my bill does and how it seeks to ensure this never happens to anyone else in the state of Maryland. The bill mandates that all pet cremation businesses must provide a written description of their services to the owners of the deceased pet, as well as any veterinarian or any other business who refers business to them, as well as the Maryland Department of Agriculture. The description must include a detailed explanation of those services that they provide, including whether the cremation is private, if it's individual, if it's individual partitioned, or if it's a communal cremation. There are several other disclosure requirements in the bill as well. Additionally, the bill specifies that any storage of pet remains must be done in a dignified way. There are also additional record-keeping requirements for the cremation businesses, including a logbook that includes records going back at least 5 years, and they must ensure the security and confidentiality of all personally identifiable information in those records. Finally, the bill includes additional enforcement provisions that allows the Office of Cemetery Oversight and the OCO to refer violations to the Attorney General or to the appropriate state's attorney for prosecution. In closing, I just want to say that I first learned about this issue and this news story, frankly, from a constituent. I had multiple constituents reach out to my office to bring it to my attention and to ask me to do something about it. So as a pet lover, as someone who just loves animals, I'm incredibly proud to be heeding the call of my constituents and to do this work. I'll now turn it over to the rest of my panel, but I appreciate you all taking the time to listen to me, and I look forward to answering all of your questions, and I respectfully ask for a favorable report.
Go ahead. Hello, esteemed committee, Vice Chair Cullison, and the other members. I am so excited to be in front of you for the first time in my role. My name is Stacy Volodin. I am the Maryland State Director for Humane World for Animals, formerly known as the Humane Society of the United States. I am here to respectfully request your support for House Bill 564. For millions of Americans, as we all know, and particularly Marylanders, the pets are our beloved companions. When families are grieving, they should not expect anything other than dignity, honesty, and compassion from those who serve them, and one of the final acts they will do out of love for their pets. Over the past year, as the sponsor noted, we have learned of this occurrence with the Catonsville business. It has occurred in other neighboring states as well, very similar situations. This is something that no grieving family should be made to go through, and I do not want to speak for the victims. You will hear from 3 here today. But this case was not just fraud, it was a profound betrayal of the families in their most vulnerable times. Again, you will hear from victims later. My organization firmly supports this bill in its current form because it establishes licensing standards. It prevents fraud by requiring documentation, a serious gap that occurred in the Catonsville situation. And most importantly, at its core, it's a consumer protection bill. And that is something Maryland is remarkable in passing consumer protection work. This bill puts common sense, long overdue safeguards into law. It restores trust, the public trust in this industry overall, and it ensures the accountability and honors the bond that families have with their animals. On behalf of Humane World for Animals and our supporters, I respectfully urge a favorable report.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Miles Hughes, and I'm an animal enforcement officer over at Baltimore City Animal Control. I'm here today on behalf of Baltimore City Administration in support of House Bill 564. This bill establishes requirements for anyone who sells pet cremation services, and it creates consumer protections for families who use them. You may wonder why we need legislation for something like this. Unfortunately, I can tell you exactly why. Recently, our office, in conjunction with the Baltimore County Police Department, uncovered a case of an individual who is systematically defrauding more than 100 grieving families who believed they were receiving their pets' cremated remains. Instead of providing the service he promised, he dumped all the animals on the side of the road or left them rotting in the back of a hearse, stacked on top of one another. By the time we found them, many of these remains were unidentifiable, reduced to only bones and fur. What he returned to these families as ashes was nothing more than sand and concrete. These families were not just financially exploited, they were emotionally devastated. The duty and necessity to notify the pet owners that they were victims remains one of the most heartrending conversations I've ever had. This appalling case happened because there is a clear gap in our system. Currently, the pet aftercare industry operates with no oversight or uniform standards. This bill would change that by creating consumer protections so something like this does not happen again. This bill does not create unreasonable burdens, it creates protections that would have prevented this harm and will prevent it from happening again. On behalf of the Baltimore City Administration, I respectfully urge a favorable report of House Bill 564. Thank you for your time.
Are there questions of any witnesses, the sponsor and either of his two witnesses? Chair, seeing none, we thank you. There are other witnesses present or signed up.
Thank you.
Thank you.
Nicole Pickens, Joy Schooner, and Riley Thomas.
Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Nikki Pickens. I am here today on behalf of myself and many other Maryland families whose trust was deeply violated. On February 7, 2025, my beloved cat Norby passed away. Like the rest of my pets who crossed over the Rainbow Bridge, my family chose cremation so he could come home to us with dignity. That never happened. Instead of cremains, families were given bags containing sand, cement, fertilizer, seashells. At least 38 deceased pets were found abandoned, left in the back of a hearse, and several on the side of the road. Many more have never been recovered and returned and remain missing to this day. I created a Facebook group in support of over 80 victims so they could have a safe place to grieve, vent, and feel less alone. Losing a pet is already heartbreaking enough. Being forced to live with the uncertainty of not knowing what happened with their helpless bodies after trusting someone with their care is devastating beyond words. Our pets are not just animals. They are family. They provide unconditional love, emotional comfort, and for some people, they're their only source of companionship. Treating them as mere property minimizes the deep bond that we share and the harm that caused when that bond was violated. House Bill 564 is necessary to ensure accountability, transparency, and dignity in pet aftercare. No family should ever have to endure this type of betrayal again. I urge you to support House Bill 564 for our pets, for our families, and for the respect they deserve. Thank you.
Thank you very much. Appreciate your testimony. We have two virtual testifiers. Lisa Radov is on the screen now. Lisa.
Good afternoon, Delegate Rosenberg. To everyone else on the House Health Committee, thank you for the opportunity to testify here in support of HB 564. You've heard a lot of heart-wrenching testimony about this, and I am here as President and Chair of Maryland Votes for Animals to say that our members strongly support this legislation. I myself lost my dear cat of 17 and a half years and fortunately did have a good experience in terms of cremation. He's with me right here. And for those of you who have lost pets and this happened to, I mean, our hearts go out to you. The death of a beloved pet is a profoundly emotional experience. For many families, especially for children, I saw this with my grandchildren, it was their first encounter with loss. During such a vulnerable time, pet owners place deep trust in the businesses that handle their companions' final remains. HB 564 establishes clear, enforceable consumer protection standards for registered cemeterians, cemetery operators, and permit holders offering pet cremation services. Maryland already holds human funeral homes and crematoriums to strict regulatory standards through the Department of Labor and the Maryland State Board of Morticians and Funeral Directors. Businesses entrusted with the remains of beloved pets should be held to comparable standards. Our pets are members of our family. Other states, including New York and Nevada, have enacted laws regulating pet cremation services. And Pennsylvania, because of similar terrible incidences with pet owners not getting their pets' remains back to them after a loss, has introduced similar legislation in response to these troubling practices. Maryland pet owners deserve peace of mind. I would like to thank Delegate Allen for sponsoring HB 564 and respectfully urge a favorable report. Thank you.
Thank you. Jessica Benson, virtual. Pardon? Not in the waiting room. Anyone else in the committee who would, ma'am, please, go ahead, I'm sorry.
No worries. Good afternoon, sir, Vice Chair, and members of the committee. My name is Joyce Schoonover, and I am here today to urge a favorable report on House Bill 564. Currently, Maryland law treats pet remains with less oversight than a used car sale. This lack of accountability creates an environment where families already on an emotional roller coaster of grief are left vulnerable to exploitation. I know this trauma firsthand because of what happened to my cat, Garfield. On New Year's Day, 2025, I had to make the hardest decision a pet owner faces. Garfield was 17, blind, deaf, and the last of my 3 fur babies was ready to join his brothers and sisters at the Rainbow Bridge. After entrusting Garfield to a cremation service, it was only through a police investigation 3 months later that I learned the truth. I was given a box that did not contain my sweet baby. It was filled with concrete and sand particles. My heart shattered into a million pieces. Garfield's remains were found by police stuffed in the back of a hearse, where he was one of 38 pets discovered during their search. House Bill 564 is a critical step to mandate basic human decency by requiring a chain of custody, consumer rights, and professional accountability. Garfield was not property, he was a family member. No other pet owner should have to learn from a police search that their beloved companion was treated like trash. House Bill 564 ensures that Maryland's pet cremation providers are held to a standard of transparency and respect our companions deserve. I respectfully ask for a favorable report on House Bill 564. Thank you.
Do you know, or does any of the witnesses who've testified, what if any criminal penalty was assessed against the owner of the hearse that had the 30+ animals?
So because a pet is property, he was only charged with fraud and destruction of property. And court was yesterday, where he took a plea deal for 25 years. Because it's
Sponsor,
80,
did
I
you
think it's
wish to add
83.
anything? You've already done it, okay. My mistake, somebody else had testified to yesterday's court. Thank you.
Thank you.
Any other questions from members of the committee? Chair seeing none, is there anyone who wishes to speak in opposition to the bill? Chair seeing none, that concludes the hearing on House Bill 564. Thank you. The next bill is House Bill 632, Certificate of Need Psychiatric Healthcare Facilities and Psychiatric and Mental Health Services Exemption. Delegate Grammer.
Thank you, Mr. Chair. I'd like to call up Jamie Kavanaugh, Chad Reese, and Jessica. Oh, my goodness. Kaspersky, if I could, please. I think Chad and Jessica are remote witnesses. And I'll get started when you're ready. Thank you, Madam Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 632. House Bill 632 removes the need to obtain a certificate of need when opening a psychiatric services or mental health facility in the state of Maryland, and I appreciate the support of the committee members on this bill. The National Health Planning and Resources Development Act of 1974 required states to adopt certificate of need laws. The federal government threatened to withhold Medicare and Medicaid funding of states that didn't comply. The argument that at the time was to control cost and ensure access. After it was found that certificate of need laws actually reduced the availability of services, the mandate was repealed in 1987. The Reagan, Obama, Biden, and Trump administrations have all said the same thing about certificate of need laws. They limit new entrants into the market, reducing competition. They lead to higher prices. They fail to improve quality or lower cost. They encourage lobbying and special interests over patient needs. Certificate of need laws are needlessly preclusive to the needed expansion and delivery of mental health services. Many states have removed certificate of need laws completely. The one issue we hear about in every committee is mental health and the lack of available beds to service the needs of our state. The issue of our day is availability and affordability. House Bill 632 makes a small but clear change to our certificate of need laws by removing psychiatric services from our certificate of need scheme. I sincerely believe that if we take the path taken by other states, we would find expanded access and reduced costs that they have found. As the Maryland Psychiatric Society wrote, put simply, Maryland needs more psychiatric beds, and Maryland needs this bill to facilitate that happening. Thanks for the opportunity to present House Bill 632. I'd be happy to take questions, and I'd ask for a favorable report.
Chair, Vice Chair, members of the committee, my name is Jamie Kavanaugh. I'm Senior State Policy Counsel at the Pacific Legal Foundation. Even though Pacific's in our name, we are a national nonprofit law firm. Most of what we do is litigation, and some of our cases we represent healthcare entrepreneurs who want to open services and cannot do so due to different government barriers. And certificate of need, of course, is one of those barriers. I commend Delegate Grammer for getting more than 40 co-sponsors on this bill. I see significant support for this bill, House Bill 632, and that makes sense. States in the region like New York, Vermont, and DC all made reforms to their certificate of need laws in the last year. In my written testimony, I listed another 7 states that have repealed certificate of need specifically for psychiatric facilities and services since 2019, so you can find that there. And as you may know, Maryland has a severe shortage of psychiatric facilities and services. There's a recent report from a local ABC channel from September 2025 saying that there are over 200 inmates in jail because they have nowhere to go. They're awaiting court-ordered mental health treatment. And that problem happens in emergency departments as well, where patients are often forced to board in emergency departments that don't have the right services for them while they're waiting for an appropriate mental health placement. And this causes backups for other patients who need to use emergency departments. Both practices are very expensive, often being footed, the bills often being footed by the state. And to be clear, certificate of need laws do contribute to this problem. In the words of a professor at Johns Hopkins School of Public Health, Gigi Bay, she said, the cause for Maryland's ER traffic jam is not that we have too many patients going to the ER, but that we allow too few roads to be built. So in other words, using certificate of need laws for decades has caused a bottleneck in the system and is really harming patients today. And the committee can be confident that research shows that repealing certificate of need laws does lead to increased access, increased quality, and decreased costs and spending on healthcare. I'd be happy to stand for any questions and urge a favorable report.
In favor of the bill who are present or who are online?
Chad Reese and Jessica Dobrinsky, please.
Mr. Reese, you are online. Please proceed, as is Ms. Dobrinsky.
Thank you very much, Chair, and I appreciate the opportunity to testify today in support of HB 632. My name is Chad Reese, and I'm a senior policy advisor testifying on behalf of the Institute for Justice. IJ is a nonprofit public interest law firm and advocacy organization that both represents clients in the medical field attempting to work through the barrier that certificate of need laws can present, and also an advocacy organization that conducts significant research and work in states across the country to try to remove those barriers where appropriate. This particular bill would allow for the expansion of services in particularly underserved areas, as the committee has already heard from the two witnesses before me. Con laws hurt Marylanders in particular. Research has overwhelmingly shown these restrictions limit the number of beds available for psychiatric patients, increase costs, and impede the development of new innovative treatment programs as well. One study even found that states with certificate of need laws targeting psychiatric services in particular have up to 20% fewer psychiatric hospitals per 1 million residents and 56% fewer inpatient psychiatric clients per 10,000 residents. That study also found that such certificate of need laws result in hospitals being significantly less likely to accept Medicare payments. This study is not an isolated one. To better understand the existing data, the Institute for Justice reviewed 128 different papers that tested the effects of con laws. These papers contained more than 400 individual statistical tests, and 89% of those tests showed that certificate of need laws lead to negative or neutral results, and negative results are 5 times more common than positive results. That's a lot of numbers to throw at the committee. All I will say in summation is, from a public policy standpoint, you don't often get policies that are this clear-cut. Certificate of need laws, particularly in the psychiatric and mental health space, are bad for affordability and they're bad for access, which makes them bad for all Marylanders. Happy to answer any additional questions that you have and appreciate Delegate Grammer bringing the bill.
Ms. Dobrinsky?
Chair, members of the committee, thank you so much for the opportunity to speak today. My name is Jessica Dobrinsky. I'm a health policy analyst who has studied certificate of need regulation across multiple states for more than 5 years, beginning in my home state of West Virginia. House Bill 632 asks a focused question. Should psychiatric and mental health services require a certificate of need before expanding? Under current Maryland law, expanding these psychiatric capacities can require a separate regulatory approval. This bill does not eliminate oversight, licensure, safety standards, reimbursement rules, and quality regulation. They all remain fully intact. The question is whether requiring providers to prove a need before expanding psychiatric services increases availability or lowers cost. The comparative evidence shows it does neither. Across states, con laws are associated with fewer facilities and fewer outpatient centers. When entry is restricted, capacity grows more slowly. In behavioral health, Maryland's challenge is not excess supply, it is shortage. When expansion requires months of approval, supply cannot respond to demand. In psychiatric care, delay means longer wait lists, emergency department boarding, and untreated illness. Con was intended to control spending, yet comparative research finds con states are associated with higher per capita healthcare spending. For Maryland specifically, estimates suggest per capita healthcare spending is at least $243 higher, and physician spending at least $95 higher compared to non-con states. So that result is predictable. Restricting entry creates scarcity. Scarcity weakens competition. Weaker competition allows costs to rise. House Bill 632 removes one regulatory bottleneck to expand psychiatric capacity. More capacity means shorter waits. More providers means stronger competition. And stronger competition places downward pressure on costs. If the goal is greater availability of psychiatric services and lower behavioral health costs, this bill moves in that direction. Thank you, and I'd be happy to answer any questions.
Thank you, Delegate, for bringing the bill forward. A question for you, or maybe anyone on your panel, and you summed it up in your testimony pretty well, that the federal government removed certificate of need laws like 40 years ago because they didn't achieve the goal of greater access or more affordability. But do you have any statistics on states that have done that, that have remove a certificate of need laws, especially in mental health, because since I've been elected, people have been saying we need more mental health services. We keep putting more money into things like Medicaid, but it doesn't never seem to solve the problem. So do you have any statistics on it expanding access and controlling costs?
I'll defer to the advocates on this one.
Well, as Mr. Reese mentioned in his testimony, there's one paper that shows there's 20% more psychiatric facilities per million residents in states that have already repealed certificate of need. Some states did it, like California repealed certificate of need in the 80s when the federal mandate went away. Other states like Pennsylvania or South Carolina have done it more recently, New Hampshire. South Carolina did it in the last couple of years, and one of the very first projects announced after South Carolina repealed certificate of need, which included for mental health services, was a juvenile mental health hospital. That was one of the very first things that we saw people saying, we're ready to build this and we want to move forward. So there is good evidence that states that have repealed certificate of need do see gains in these areas.
Why do you, can I have a brief follow-up? Thank you. Why do you think it's taking so long for us to get to this bill, and why do you think this barrier has been so hard to remove?
I'm the politician, so I guess I'll speak to the politics. It's a very silly thing that the federal government told us we needed to have certificate of need, and then they told us we needed to get rid of it. But the interest is actually here in the state. And to be respectful, I'll just be frank about it. I've had great discussions with Shepherd Pratt. They are the big shark in the pond, and I think they might be the only shark in the pond. They have over 300 facilities, and certificate of need is very preclusive to getting any kind of competition in this field, in mental health services in Maryland. And, this is a political question. There's a reason there's so many members on this bill. There's a reason there's so many members of this committee and members of both parties on this bill, because people get it. But it's a question of political will. Are we going to make a positive reform despite the institutional players who have a lot of influence here? And, they're good players. I think Shepherd Pratt they benefit our state. I've had members of my family work at Shepherd Pratt. I think them being here helps Marylanders. But I don't think that having competition in that market hurts them. I think it helps them. The old saying, if other people do well, that doesn't mean you're not going to do well. But the question is, we haven't decided to do as red states and blue states have done, and say we're ready for more accessibility and more affordability.
Shocking. Thank you.
Yes.
Delegate, thanks for bringing this bill.
Thank you.
do have a very impressive list of sponsors on here, very bipartisan, and I'm happy to actually be one of them.
Thank you.
But I am a little perplexed because those that are in opposition are typical opponents that I support. Maryland Hospital Association, I received a call from one of my hospitals saying that they are not supportive of this bill. This committee went to the mental health court last year, and every judge looked at us and said, we need more inpatient beds.
Right.
Heard it loud and clear.
Yep.
So before the opposition comes up, I'd like to give you the opportunity to say, what are they going to say, and do you have any thoughts about their opposition on this bill?
Thank you for that, and I'll go further. What I actually like to do is when I come in for bill hearings, I like to listen to the other bill hearings and hear what they have to say. And this is the only issue. You can go to every committee, and they're all talking about mental health beds. They're talking about juvenile beds and judiciary, and they're talking about state facilities and appropriations, and of course you're talking about it here. Everybody's talking about mental health beds. So I think the challenge here is you have these great advocates who've been working with me for years. These are people who just want positive reform. And summarize your question for me one more time. What is the opposition going to say? They're going to say certificate of need is not the problem. And they're going to throw a lot of things at you that are very technical, but the issue really is very, very simple. if you sold cheeseburgers, if you wanted to sell cheeseburgers, and your opposition required you to have a certificate of need to get into the cheeseburger market, and you were going to have to spend several $100,000 in lawyers to get you through the cheeseburger certificate of need process, the question would likely never come, because you would say, I'm not spending that much money just to open a business. And that's the reality of what happens. This certificate of need is antithetical to the idea of capitalism or free markets or access to the market. In what other industry are you required to get permission to challenge the competition and offer a service and offer value to consumers? So they're going to come at you with a lot of very fancy things, but it boils down to, if someone wants to open a juvenile health care facility, as they want to open in Cecil County, should they be able to do that within the regulatory framework to deliver proper health care? And to me, the answer to that question is clearly and simply yes. Absolutely.
And can I add something very briefly? There's also a lot of research.
Question. Delegate Riley.
Thank you, Mr. Chair. Sorry. So whomever best can answer this. So what has been the result of those other states that have passed something like this in the availability and the cost of services? Has it changed any at all?
Yes, when you compare states that have certificate of need with states that don't, about 40% of the US population live in a state with 0 or very limited certificate of need. That makes it really easy for economists to study this issue, and that's why we have such good data on this public policy question. A lot of questions can't be studied in such a straightforward way. Yes, we have, as we heard, over 400 tests that show costs go down, access goes up, quality goes up, outcomes in COVID, during COVID were better in those states. People who were seeking emergency treatment during COVID were 27% more likely to be turned away from a hospital in states that had certificate of need laws. There's very real implications for all of the findings in these papers that show that access increases.
More people getting served.
And costs go down, cost and spending both go down.
Thank you very much, appreciate it. Thank you.
Thank you, Mr. Chair. Thank you, Delegate. And you certainly are right that you hear about our needs around mental health virtually everywhere. They are significant. We deal with it almost every day in this committee. So I just want to speak a little bit about what the role of the CON is, and then, and I'm not going to steal a little bit probably of Dr. Jacobs' testimony. So what the role is to make sure that there's adequate staffing, adequate space, adequate cleanliness, adequate planning, adequate financial infrastructure in order for a facility to be maintained. So this isn't just about, government deciding, who gets to do it and who doesn't. It's about making sure that all of those things that are about patient safety are there. So I'm not sure how that jives with psychiatric beds in Maryland have increased every year over the last couple of years. So the number of beds have actually increased, but only 77% of those beds are staffed. We don't have the staff for the beds that we have. And that presents significant safety issues, particularly with some of this, with this population. So how would you address that?
I can address that, but I feel inclined to defer to Chad or Jessica, who've been very quiet here, if either has a strong answer.
I'll give it a shot, and then happy for Jessica to back cleanup if I miss anything. I think two things come to mind with that question. The first is I think we have to be very clear about delineating what certificate of need regulation does and what the other sort of array of health and safety regulations within this industry do. So I think to Delegate Grammer's earlier points, the certificate of need process is really about who is allowed to participate in this space from the business side. Nothing to my knowledge or understanding about this bill would change anything about who's licensed to provide care, what kinds of requirements must be maintained by facilities, what inspection processes are done by the state. All the health and safety regulations would remain unchanged. This would simply be about allowing new entrants into the market. The other thing I want to note about the bed versus staffing issue in particular is I think this is a very difficult area of healthcare. I don't think anyone would disagree with that. It's difficult to be profitable and to find a way to serve this population in a way that's compassionate and that makes sense and is sustainable. I think that's why we need more entrants into the market. I think if you only have a limited number of folks providing these services in any given jurisdiction or area, they're going to do things a certain way. They may not be innovating in the way that new entrants to the market would be. They may not be able to provide the services specifically to targeted populations that are necessary. So while adding beds is, I think, excellent and important, the way in which you administer services is also important. Now, I can't speak to the specific manner in which those new additional beds are being staffed or how those places are being managed. But I do believe that you would see new and innovative ways to provide those services from other potential entrants that don't have the opportunity to show up and say, hey, we think we can do this in a safe way right now.
May I follow up? Just a follow-up, though, and I appreciate your response, but I'm concerned that if we have a 25% vacancy rate now, and we increase the number of beds, how does that incentivize folks to go to the new facility? And what you've done is you have a net loss in the other facility. So the vacancy rate actually increases in that instance.
I have never heard of a vacancy or a shortage of patients in the mental health field in this state.
Not patient, staff, job vacancies. We've got 25% of our beds unstaffed. There are job opportunities right there that we don't have the staff for.
I would say if you build it, they'll come. I would say if you offer the opportunity and you let the industry expand and you let the wages rise, people will say, wow. I think facilities will say, look, we need to compete for these, we need to compete for the employees in this market. And wages will follow. They prove to follow in every market. And I think if wages did rise as they would rise in this market, I think you'd find more applicants into those markets. But I'll also say everyone is also complaining about a shortage of employees, and I don't think that is cause to not expand access to the market broadly for fear of having to find more employees.
Mr. Chair, just one, I'll say one last thing. We're talking about insurance and Medicaid. That's how these folks are paid. They're paid through insurance, they're paid through Medicaid. The rate of pay is not going to go up significantly simply because it means more taxes, because then we need more money for Medicaid, or the insurance premiums skyrocket. Now, it is a problem, but I just want to be clear that this is not a market-driven kind of process. These are staff this is a staff that is challenging to meet the needs of, or to make sure that we have the staff to meet our needs. So I think I'm worried that if we, you said if you build it, they'll come. We've built it. We've got an extra number of beds. We've got 25% of our beds. We've got it, but they're not coming. So that's my concern here, sir, I think.
Thank you for that question. And I would push back a little on this idea that this isn't a market-driven problem. A lot of the criticism I hear from the Hospital Association or other existing facilities is always a market-driven consideration for the reasons for keeping certificate of need in place. And just because there are vacancies in beds right now, staff vacancies, doesn't mean that the facilities are distributed evenly across the state. There could be areas of the state that don't have a facility, and there could be qualified people there who could work, but they can't geographically get to the 25% of beds that you're seeing right now.
I'm finished, Mr. Chair. Thank you.
Mr. Chairman, that line of questioning kind of piqued my interest a little bit, Delegate, because isn't that part of the capitalist free market system, that if you have competition, not only does prices seem to go down because you have competition, but quality and access also comes up. So you could have, we obviously have plenty of demand for mental health services.
Right.
What we're lacking is entrepreneurs willing to take the risk for supply and to fill that demand.
Right.
And what would your comments be on that as far as free market versus, regulated market and just, limiting competition?
Yeah. So ironically, I had the NAMI folks in my office, and after they told me their interests, I said, I have a bill for you, and I want to see what you think. And man, they had a lot of stories about one particular player, and they said, man, we so agree with you on this issue, and maybe we have an opportunity to talk with them a little bit more. But that is exactly what this bill is about. This bill is about taking down the wall that says you can't participate. That's what certificate of need is. Chad, he pointed out, this is about the business side of healthcare. Certificate of need mandates that you have to get approval to even start to enter the market. Capitalism and free markets are about new ideas and innovative thinking and new ways to do things. Why aren't we giving players an opportunity to challenge really the only player in the state who has complete dominance and has yet to reach underserved parts of this state who don't have any access whatsoever? So I think that's exactly what it's about.
Real quick follow-up, Mr. Chairman. So if you play that out logically, what would be the worst thing that could possibly happen if you had another business coming into this space? What could be the worst thing that could happen?
The worst thing that could happen is they have to follow all the other rules and regulations that healthcare providers have to follow, and they weren't successful. I guess that would be the bad outcome.
And they would hold the responsibility.
And they would carry the load of not being a successful business.
Yeah, thank you. Thank you, Mr. Chairman.
Another possible outcome would be more empty beds. How do you respond to that?
Jessica, do you want to participate on this one?
Yeah, I apologize. I couldn't hear your question. If you could repeat it.
Would there be more empty beds if there was less regulations? What if that was the outcome?
What if there was what? I'm sorry, the audio.
What would if there were more, if the outcome of deregulation would be more empty beds?
I think one thing that we have to keep in mind is that maybe there are some empty beds in areas, but is it concentrated in a particular area? And I think that kind of defeats the purpose of certificate of need, right? As Jamie kind of pointed out, some of these more rural areas that are detached from the city might not have access capabilities. One thing that's a little bit anecdotal, but I think to keep in mind as well, is that certificate of need, of course, is affecting patients, but it's also going to impact the people that are working in these health systems. I have a ton of conversations with people in my home state of West Virginia that actually work in hospital and health systems, particularly out of state, because they don't like the current options that they have either for workforce, right? And so perhaps somebody else is coming in and giving a new innovative model, and they're more willing to work for that too. So there's a lot of flexibility, not just for patients, but also for workforce as well. And so having that flexibility, honestly, having more beds is a great option because it means that there's an influx for whatever reason of people needing to get care, that they have the opportunity to do that.
Thank you very much. I have a question from Delegate Ross.
Thank you, Madam Chair. This is not fancy, it is not long. I'm still hearing from a couple of hospitals that this will decrease access. And for the life of me, I'm trying to understand how. Can you, and you mentioned a moment ago that you have the other states who have removed the certificate, that access has definitely gone up, which follows my logic around this. Can you just, for the record, just totally clear, plainly state, access will definitely go up. There's no likely scenario where access goes down.
Maybe I think the question could be, could Jamie talk about all of the states and tell us if the availability, the access.
If you
is
have
going
that
down.
data, that would be helpful.
Yes, I can share more data with the committee, but I've cited some in my written remarks. So we know that access increases. I want to address, though, what you're asking, the underlying question about what you're asking. I hear this all the time, and the fear is that some facilities will have to close if new facilities open, and that's where we see a decreased access. But luckily, we can look at what's happened in other states, and we know that doesn't happen. If there's 20% more facilities per capita in the states that have already repealed certificate of need laws, then we know the new facilities aren't opening and putting half of the existing facilities out of business. Otherwise, they couldn't have this increase in access. There's one study that looked at this very specifically about if surgery centers open, does that affect rural hospitals? And they found no, the rural hospitals didn't close. That's an example that's used all the time to say rural hospitals have such thin margins that if they lose any of their surgeries, which are profitable procedures for them, they're going to go under. And that hasn't even been borne out. So similarly, in the mental health space, there's no reason to believe, and the evidence supports the fact that there'll be an increase in access in Maryland if you move this bill forward.
Very good, yeah. Thank you. Thank you.
Thank you. And I'm sorry for my absence. I was in another meeting. So forgive me if you've already answered this question. But Delegate Grammer, can you tell us how this bill is different from the bill that you brought before, that we did the work group on, that we made the determination that this was not that this was not what was creating a backlog? Has this bill been altered in any way?
The bill has not been altered. We've requested a redraft, and to the best of my knowledge, I've looked through it. It appears to be the same bill. I will say I had some of the panelists here with us today, and we did have that work group, and I thought we won that argument. That was a great work group to have an opportunity to talk through.
Thank you very much. Are there any other questions for this panel? Delegate Gazzoni.
Yeah, and I too apologize. I was presenting a bill in Ways and Means, so didn't hear the beginning of your conversation. I'm curious about how, or I guess maybe not really clear, about how this may affect our current providers, particularly those who take a lot of, who have sort of maybe a mixed population at this point, but would end up, it seems in this scenario, with many more Medicaid recipients and/or not enough to be able to maintain their viability as a location. So I think it goes a little bit to what Delegate Ross was asking. And obviously those patients are going to end up going to the ED as an example, which as we all know is the most expensive pathway. So if you could just sort of talk about that balance. And maybe that goes a little bit to, I've heard you mention a new business model or an innovative way of doing things, and I'm not clear at all what that might be. So if you can kind of wrap that up, that'd be great. Thank you.
Yeah, thank you for the question. I mean, yes, the patients are going to the emergency department right now or sitting in jails. That was part of my testimony earlier, that unfortunately we hear about that growing problem, and that's very expensive. Again, I think this is similar to Delegate Ross's question, that the evidence shows, even when you're looking at rural hospitals, and that's important because rural hospitals typically handle a high percentage of government-insured patients, so that's a very good indicator here for any facility that has a high number of Medicare or Medicaid patients, that even when new facilities, certificate of need goes away and new facilities open around rural hospitals, those hospitals don't close. That's a very good indicator that the same would be true for mental health facilities. And again, I've had economists explain this to me a couple times, and it took me a long time to understand how important this statistic is. But the fact that states that have already repealed certificate of need laws have more beds and more services available and more mental health hospitals available really discounts all of these arguments that the other facilities close when a new one opens. No, new ones open and they all stay open, or else they wouldn't have more facilities per capita or more beds per capita as well. And this research repeats itself over and over when you're looking at different types of facilities, imaging services, hospitals, emergency departments, psychiatric facilities. It replicates, across different areas of healthcare, and that's again really important to economists because they tell me, one study by itself, that's not convincing one way or the other. But when we have hundreds of studies that lead to the same result, we can be very confident that what we're replicating in the studies with certificate of need is true in the real world.
I'm sorry, can I just loop back around this sort of innovative methods that I've heard people talk about. I have no clue what that looks like. So if you could talk about that.
Well, I have a great example for you. I represented clients in Kentucky who wanted to open a home health agency for the Nepali-speaking community. The local hospital said we have enough home health services in the area, but none of the certificate of need process took into account cultural competency. They said, but our community is Nepali-speaking, we're refugees, our aged population can't find services in the language that they understand. And the hospital association said it's enough that home health aides use an app on Google for Google Translate. And we all know our grandparents could never communicate about their health needs through an app on Google. So, I think that's an example of an innovative service that isn't something that we've never seen before, but it's something that's sorely needed, that there are entrepreneurs who want to provide niche services. And those are the exact type of entrepreneurs who are locked out of the market because they're very small providers, right? You need a lot of money, you need a lot of capital to go through the certificate of need process and hopefully get a certificate of need. But when you're a small startup that wants to care for a small population or offer something that is needed for, part of the population, and it's culturally based, culturally competent, you often can't do that in states with these laws.
Thank you for that response. I guess I would just point out that a home health agency is fairly different than a psychiatric hospital.
Delegate Hill.
Thank you, Madam Chair. Quick question. Can you explain to us what is the certificate of need process that a facility would need to go through? You said it's onerous and expensive. What's the process?
The process involves filling out an application, explaining the project that you want to provide, but the difficult part is when there's a public hearing. So your direct competitors are involved in your application process. So I'm applying to open a new mental health facility. The existing facilities get to weigh in and say all the reasons why I shouldn't be allowed to open. And then if there is a public hearing on an application, this is when you need to hire attorneys and be represented by counsel in a hearing that functions like a court. You're taking witness statements, you're taking evidence, and using that to decide whether or not to grant the application. There's often an appeal process involved as well that goes to actual court. So this can be not just costly, but also it can take years to resolve.
May I follow up? So you're describing in Maryland, because I thought it was primarily an administrative process where you look at the capacity and whether the needs are being made and the wait list, and you're describing something, it always involves a court process? It's not that the adjudicating...
It goes through the HPSCS.
Right.
And, the way I think about it is a lot of like a developer. Developers, if they want to develop, the first thing to do is hire lawyers because the system is going to have a lot of, checks and balances and crossing T's and dotting of I's. Well, folks trying to come into this market in Maryland, they know we can't even talk about health care, we can't talk about mental health services. First thing we're talking about is certificate of need. So if you talk to if you talk to the agency and you can actually look at these cases and you can get a purview of how it goes, and it's pretty much exclusively competition coming in and shooting down their application. And from the examples I've seen, it's the big players, University of Maryland, Shepherd Pratt, the folks that have the majority of the market.
May I follow up? Okay. So, but what's the criteria? I mean, I think there's an assumption here that the criteria is, do you have empty beds? Is this a community that is having a hard time getting the care? You're saying there are other criteria that, in other words, if I'm a big player, you're a small player, and your argument is you're not meeting the need, it doesn't matter how big I am, right? I can say your argument is you're not meeting the need, there is a need. We need to understand why that's not the process, or if that's not the process. Can you help?
What is the criteria? Who knows? You know, I couldn't actually ascertain when researching the process last year and speaking with the agency, it's a bit nonsensical. There's certainly challenges, there's certainly a lot of paperwork, but it seems to be kind of a who you know, who can I lobby personally, what's the bureaucracy, and hiring attorneys to facilitate all that. So I don't even know if I were to personally try to open one of these healthcare facilities, what goal I'm even shooting for here in trying to, you know, trying to facilitate a proper certificate of need for one of these beds.
Okay, thank you. Thank you, Madam.
Delegate Hill, I think that there is perhaps an answer to your question on the next panel. Seeing no further questions, I just have a couple questions. Delegate Grammer, because we did do a work group on this, we did explore it, and you seem to indicate that you really would like to explore you know, certificate of need writ large, that it wasn't specific to this, but looking at specific certificate of need. Did you put in that bill, as I requested, to consider certificate of need, or is this the only bill on CON that you put in?
So this is, I think this is such a huge question. I think starting with mental health is a great starting place. I think everybody understands the need. I think the information that we have, which is pretty much every study that we have, as you've heard from the testimony today, is pretty clear that bringing down certificate of need both increases access and creates a better affordability.
Okay, thank you. So to be clear, this is the only bill, despite the fact that that we already did a work group on it. And Ms. Kavanaugh, the Pacific Legal Foundation, that works on deregulation legislation and litigation. Is that correct? That you have active litigation in multiple states on certificate need and other regulatory burden?
Yes, that's correct.
Okay, thank you very much. Are there any other questions for this panel? Seeing none, thank you very much for your testimony.
Thank you.
We do have an unfavorable panel. We have Douglas Jacobs, Lucian Parsley, Winnie Hawk, Damian Lang, and Michael Johansson. Oh, Winnie. I know Winnie.
That's okay.
And you can get started whenever you're ready. In whatever order you choose.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Doug Jacobs, Executive Director of the Maryland Healthcare Commission, also a practicing primary care doctor. MHCC respectfully opposes House Bill 632. The previous panel, a lot of the folks were not from Maryland, and I think there's some really important Maryland considerations to take into account. For psychiatric services, CON regulations ensure appropriate patient safeguards, including private rooms or semi-private rooms, age-appropriate separation and programming, admission of involuntary patients, participation in Medicare and Medicaid, and eliminating CON removes these important protections. Maryland needs more behavioral health services, but eliminating CON is not the solution. First, we know from stakeholders, associations, agencies, and organizations that the primary constraint today is staffing, not licensed bed capacity. Since 2019, psychiatric bed capacity has increased significantly. However, only about 85% of licensed beds at acute care hospitals are staffed, and less in acute psychiatric hospitals are staffed. And Maryland is nearly 50% short of the behavioral health workforce it needs to meet that demand. Eliminating the CON may increase licensed bed on paper, but it won't produce the workforce needed to operate them. Number three, the CON process has not been a barrier to expanding psychiatric services in Maryland. Since 2015, MHCC has approved multiple new or replacement psychiatric hospitals and numerous expansions across the state. Only one psychiatric project has been denied due to financial infeasibility. And in addition, we've already significantly streamlined our CON process to accelerate reviews, reduce delays. There's currently no backlog in the CON applications. Number four, the bill creates a significant loophole that we would most certainly need to come back to fix. Hospitals could add psychiatric beds without a CON review and then go right away and change those psychiatric beds to another different type of bed that is more favorably reimbursed. And this effectively navigates around state oversight, and it actually undermines the Maryland total cost of care model as a result. And so, in short, House Bill 632 is not the solution for the challenges we face, and we urge an unfavorable report.
Good afternoon. Lucienne Parsley, Disability Rights Maryland. We are the Protection and Advocacy Center for People with Disabilities for the state of Maryland, here to express our concerns about House Bill 632. My organization is tasked with monitoring facilities and institutions that provide care to children and adults with mental health disabilities, and we also investigate instances of abuse and neglect. The certificate of need process, in our view, is essential to ensuring that psychiatric facilities operating in Maryland can provide equitable, high-quality care. It provides the public with advance notice about applications to open new psychiatric facilities, allowing investigation into history, capacity, and expertise of the applicants. Across the country, for-profit corporations, often held by private equity, have come under scrutiny for their abusive and unscrupulous activities, often in the name of cost-saving measures. Because of this, the Government Accounting Office issued a 2024 report involving abuse of children in mental health and with mental health disabilities placed in residential care facilities. It specifically called out services run by for-profit corporations and private equity. In our view, lower cost is not the only goal here, nor is the institutionalization of every child when services could be provided in the community. And that's exactly what we've found, having reviewed hundreds of thousands of pages now of children in overstay in hospitals and emergency rooms, many of whom their treating professionals say do not need institutional care. They could be provided in the community when those community services just do not exist. Several of these companies, these for-profit companies, have operated in Maryland in the past, allowing new companies to open facilities in Maryland without undergoing public and government scrutiny would deny monitoring agencies and the public the ability to adequately vet corporations and raise objections. Thank you.
Good afternoon. Chair Bagnall, Vice Chair Colson, members of the Health Committee. My name is Damian Lang. I'm the Director of Government Relations at Sheppard Pratt, and thank you for the opportunity to testify on behalf of Sheppard Pratt today in opposition of HB 632. I want to start off by saying that Delegate Grammer suggested that CON laws are outdated barriers and that removing them will automatically increase psychiatric bed capacity. Respectfully, that oversimplifies Maryland's situation. Yes, Maryland needs more psychiatric beds. We agree on that. But the evidence shows that the primary constraints are reimbursement rates and workforce shortages, not certificate of need. Psychiatric units require high staffing ratios, 24/7 clinical coverage, and specialized teams. Medicaid reimbursement often fails to cover the true cost of care. Hospitals across Maryland already absorb significant losses on psychiatric services. Removing CON does not create psychiatrists, nurses, or technicians. It does not raise Medicaid rates. It does not solve the financial viability of the problem that we're talking about. We've already seen CON-approved bed expansions where some beds remain unstaffed because the workforce simply is not there. I also want to address the suggestion that this is about protecting a monopoly. Respectfully, this is not about protecting market share. If psychiatric services were highly profitable, we would not be testifying about chronic financial losses and workforce shortages. Our concern is protecting the stability of Maryland's safety net system, particularly for Medicaid and high acuity patients. Without system oversight, new entrants may target commercially insured, lower acuity patients, while safety net hospitals continue to shoulder Medicaid and high acuity care. That weakens the very providers who are currently managing emergency department boarding and court-ordered admissions. We all recognize the crisis of individuals waiting in jails and emergency departments, but that crisis is driven by insufficient reimbursement, workforce scarcity, and gaps in community capacity, not by the existence of the CON process. For these reasons, we respectfully urge an unfavorable report. Thank you.
Thank you, Madam Chair, Vice Chair, and members. Winnie Hawk here on behalf of the Maryland Healthcare Commission, respectfully in opposition. I have no testimony to add, but I'm just simply here as the Center Director that oversees Certificate of Need to answer questions. Thank you.
Thank you very much. And I just want to set the record straight because I called Michael Johansson in error to this panel. So he is not absent and he's in the room. So I didn't want to send him to panic either. Are there any questions from the members for this panel? Delegate Hill.
Thank you, Madam Chair. I'm going to follow up on your suggestion and ask, can someone explain the certificate of need process as with respect to psychiatric hospitals, the cost and what's required and what the criteria are?
I can start.
Okay.
Yeah. I'll start, but when you... Okay, so we make the process really transparent. We have the application online. It's administrative. Folks fill out the application either to add beds or to create a new inpatient psychiatric facility. We have a specified time frame that we have to come to a solution. And actually, we significantly streamline that time frame. So if we don't meet it, it's deemed approved. The previous panel said that there's public hearings where folks have contentions. That's actually not true in Maryland. We significantly streamlined the ability for competitors to have a say in the process to make it as streamlined as possible. We also, as a result, because this is all administrative, we don't have a backlog of cases that are awaiting CON approval. We've got through them all. And the ones in the CON process too, we haven't seen that the process itself that I just described is the barrier.
May I ask? Yes, please. Thank you. So the other parts of the question were the cost and what are the criteria? So is it as simple as saying there are patients who need beds and you can't supply them, or is there some other criteria that would allow you to determine there is a need?
I'll take that question. There is no cost. There's no application cost. It's simply, often an applicant may choose to hire a consultant to hold their hand or to take them through the process, but there is no cost that the state makes in terms of an application fee. In terms of the criteria, the state health plan, there are 15 different chapters, state health plan chapters. There's one for acute psychiatric beds. We look at need. We look at quality. We look at the impact to other providers. We require coverage of underserved populations in sliding scale, as well as Medicaid patients. We require involuntary patients. So all of those, you go through, you look at the geographic aspect of it. So access is important as it relates to geographic distribution. But I have to say, we do take the applications as they come. It's not as though we don't seek, so we'll often post need projections for different services, and it may project need in different geographic areas, but we sit back and we hope that people will apply for those geographic areas. So geographic access is another component.
May I ask another? It's on the same topic. All right, thank you. So you said need, you said if they can meet certain criteria. So it's not need as we're thinking about it, which is that do we need the beds? Because you also said, do you take this kind of patient and will you provide this kind of service? So it's not need in that simple way. And you talked about competition in the area.
Go ahead. So it is need in terms of whether there is a need for acute inpatient psychiatric beds. And we continuously re-review that process, come out with new projections. There's these other components of the state health plan chapter. It's transparent. We do it via regulation. We have work groups with various stakeholders and coming out with those regulations. And we match up every CON application with that state health plan and are trying to make sure that we promote and protect the health and safety of Marylanders in that process.
Thank you, Madam Chair.
Delegate Morgan.
Thank you, Madam Chair. So I believe probably for the gentleman on my left, from Shepherd Pratt. Thank you guys for testifying. I do have some clarifying questions though, because collectively the panel testified for, there's no backlog in certificate of need or organizations applying for that. But there is still a need for beds, and the limiting factor in that is Medicaid reimbursement and staff. I heard that right. Yes. So my question is, why are you testifying against the bill? I mean, shouldn't you be lobbying for more Medicaid reimbursement and more, in order to hire more staff? Why is the bill the limiting factor?
That's a good question. We are asking for increases in rates. That's critical. I will say, though, that this bill particularly, if it passes, would be extremely detrimental to the existing behavioral health system that we have. To just articulate this Medicaid reimbursement part, typically we're being reimbursed about $420 for a patient 24-hour stay, something like that. The actual cost of care to that patient is upwards of $700. So we as a nonprofit eat those costs because we want to provide the best care that we can to those patients. The concern that we have is that 70% of our patients fall under that bucket of Medicaid. The 30% of patients that are under private insurance are what enable us to keep our doors open. Psychiatric services are unique in that we don't really have the kind of lucrative services where we have a lot of options for cross-subsidization. And hypothetically, if a for-profit provider came in that was not treating Medicaid patients, the nonprofits would assume the bulk of the burden of those uninsured folks coming in to seek their care and lose the only revenue stream that is accessible to them, which would result in nonprofits scaling down their operations or shutting down ultimately, reducing access in the long term. That's the main reason why we're opposing this bill, is that we want to keep access available to folks and prevent this system from only being catered to the private insured.
So, brief follow-up there. So that's interesting. So if we allow more competition to come in, you're afraid that the for-profit entities would just take the people that pay, and then y'all would be forced to take the people where the reimbursement isn't high, and you'll have to scale back.
Correct.
Is that basically?
Part of the certificate of need process is that providers are required to take a certain amount of Medicaid, Medicare, and uninsured patients.
So we just recently passed an energy bill, HB 1, that cracked down on CEO pay at companies like BGE. And I think it was drawn at about $270,000, $290,000. Shepherd Pratt made about $500 million last year, with the CEO making $1.5 million. What would you say if something like came about that to deal with in healthcare would be, extrapolating that same logic to other industries like that? Do you think that would be detrimental for healthcare and result in Shepherd Pratt being able to see less patients and have less beds?
I would have to take a look at that. I wouldn't be able to address that clearly in terms of what those hypotheticals might actually be. But Shepherd Pratt is a very large organization with over 5,000 employees, and our profit margins are insignificant.
Okay.
We're operating as best as we can with the funds that we do receive, and we'd have to take a look at that.
Okay, thank you for your testimony. It was very.
Delegate Shalega.
Thank you, Madam Chair. It'll be short. I know we have a lot of witnesses left today. This would be for Winnie. So you made it kind of sound like the CON process was short and not cumbersome, and maybe I misunderstood that. But it's my understanding when I represented Harford County that this, moving that hospital and that whole CON process with that ambulatory or the urgent care facility, I'm not using the right word, that was moved down to Aberdeen, took years and cost hundreds of thousands of dollars. Just a quick answer.
I would say since then, I wasn't with the commission at that time, but since I've been with the commission, in 2023, we updated our certificate of need procedural regulations, and we've streamlined the process. I don't know the specifics of that project, but it was a big project, and I think that there was also a lot of community opposition. There was a lot of community, I think there was a lot of back and forth, but one of the key changes that we've made, for example, is when we receive a certificate of need application, the first thing that staff does is review the application to see if it's complete. Can we docket this application and move it along? It's not docketed until it's deemed to be complete. And before the streamline of the regulations, completeness could go back and forth for 2 and 3 years, multiple times. Now, there's one shot at the apple after an application comes in. So that has significantly expedited that process. And as an example, I think you can look in our files, Shore, the most recent hospital project that we've approved was Shore in Easton, and that took 1 year.
And how many hundreds of thousands?
I would have to look, I don't have that, but I can get that information for you.
Okay, thank you.
Yeah, we can get that information and share it with the committee. Thank you very much. Seeing no further questions for this panel, this concludes the hearing on House Bill 632. Thank you very much for your testimony. We are now going to move to House Bill 598. This is physicians licensing internationally trained physicians. Delegate Hill, if you want to approach the table and bring your panel, and you can get started when you're ready.
I think there are some folks. I think you want all the folks up here.
Delegate Hill, I've got Jane Cranky not as a.
Then I'll do it on my own.
Okay.
I'll do it on my own.
All right. You are enough.
Thank you. All right. Good afternoon, Madam Chair, Madam Vice Chair, and committee members. I'm Terry Hill, and I'm here to present House Bill 598, Physicians Licensing Internationally Trained Physicians. For those of you who have been on the committee for a few years, you may recall that in 2024, I introduced a bill that would have created an alternative pathway for physicians who are in our communities who have done residency training in other countries that they have successfully completed and have practiced for at least 5 years to be able to get a Maryland license without having to repeat the residency program, which is, for the most part, what is required currently in Maryland. I say for the most part because there is an exception. We do have a process that we refer to as conceded eminence, whereby our major medical school teaching institution hospitals can request licensure for someone from another country who can be qualified as having exceptional or having known to have exceptional ability either by reputation or because they have international renown or something like that. So there is that process. But for those people to be licensed, they have to be affiliated with that sponsoring institution, and that doesn't really address our needs. So we presented that bill. The chair at the time, now speaker, directed MedChi, which was in support, but not necessarily with the process the bill suggested, and the Board of Physicians, which was in support, but not necessarily with the process that the bill presented, to get together with me and to workshop it. And we did that during that interim. We came back last year with a bill that is very similar to what you have before you, and having come to a consensus with various stakeholders about what our goals are and what we thought we could do safely and well, both with the goals of assuring that any physician who was licensed in Maryland is a physician of quality and understands the standard of care and will be practicing in a safe manner. That because there was a movement around the country to look at ways and set up systems to do the vetting to ensure that residency programs are substantively equivalent to our own, and to look at how to be able to look to see if people who are licensed in other countries whether their licensing requires are substantially similar, and whether we can actually assess whether they're in good standing. That those processes are in the working, and so what the bill last year said is, okay, Board of Physicians, you understand what needs to be done. We're going to give you the task of getting it done and to come back and to, through regulations, come up with the system. We passed that out of this committee, we passed it out of the House, and it ran out of time in the Senate. So this year, we're bringing it back. There have been some modifications. There was some reluctance with the bill last year where the Board of Physicians said that they supported the bill, but they said it would be a very costly thing for them to do. And it's really the fiscal note that was presented last year that stopped it in the Senate, although we got the waiver here in the House, because as we all know in this committee, the Board of Physicians is a special funded board, which means that even if this process were costly, they have the ability to charge the physicians who will be requesting it whatever the fees would be necessary to cover those costs. So we've come back with the bill. We have a cross-file this year. And if you look in your package, you'll see there are a number of groups that are in support of the bill, but also have amendments to address some of their particular concerns. So we have met with those folks as recently as Monday, and we have amendments that we think will not only address the good suggestions that were made, but other concerns. We believe it will bring the fiscal note down to a very reasonable level, because I think we've addressed the concerns of the board in terms of what their responsibilities would be. And I think most importantly, as part of those discussions and negotiations, the University of Maryland Medical School preliminarily has agreed to work with the other similar institutions and those institutions that have teaching residency programs to come up with a process so that when the physicians who are granted this limited license to practice finish with their 3 years, we can actually have an evaluative process to assure that they understand the standard of care before they move on to full licensure. That was the piece that had been missing before. We thought that we would be able to work around that. Some of the amendments that talk about they should be, this should only be granted to folks who have a job offer that is in a teaching institution, et cetera. We don't think we have to do that, because there's going to be a process to evaluate them, and there's going to be appropriate supervision. So we think that the amendments will allow for the board to set up 2 processes, one for physicians who have a job offer, whether they're being recruited to compete with physicians who are being recruited by Virginia and West Virginia and other places. I think that was important for some of the stakeholders that they be able to compete. So it would change the imminent or the conceded imminence process to make it more workable, and at the same time fulfill the initial goal, which was to take physicians who we know are already in our communities, who have, through their training and experience, exactly what we would want to have in physicians treating us, our family members, and our constituents. And with that, I would ask for a favorable report, and those amendments will be forthcoming shortly.
Thank you very much for your testimony and for your work. Are there any questions from the members for this witness, for the sponsor? Seeing none, thank you very much. We do have a favorable panel and a favorable with amendments and no unfavorable. So our favorable panel is Jane Cranky. If you want to come up and you can begin your testimony when you're ready.
Great. Thank you, Chair Bagnall and members of the committee. I'll be really quick. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association. Just wanted to echo the thanks to Delegate Hill for really being a champion on this issue. And just, it's really important for our members to remove these barriers for these internationally trained physicians. Just really appreciate the work, and we're here in strong support. We ask for a favorable report.
Thank you for your very efficient testimony. Do we have any questions for this witness? Seeing none, thank you very much for being here. I now have a favorable with amendment, which is Michael Tran, Harry Ajrawat, and Steve Wise. You can come up and, all right, we'll let the, all right, so for the record, Mr. Wise is over in the Senate, but MedChi is in support. As they have said, yes, they are favorable with amendments. There are amendments in the package, and the bill sponsor is working with MedChi on those amendments. And with that, you can start your testimony.
Good afternoon, Madam Chair and the committee members. For the record, my name is Harry Ajrawat. I'm the chair of the Maryland Board of Physicians. First, the board wants to thank Delegate Hill for her hard work and leadership on this issue. The board is in support of House Bill 598, Physician Licensing Internationally Trained Physicians. However, the board is proposing an amendment that preserves the intent and the spirit of the original bill while making the bill more feasible and accessible to the intended population of the internationally trained physicians. Through internal research by the board staff, multiple meetings, conversation with the Federation of State Medical Boards and other states that have they proposed or implemented similar legislation, the board has considered all approaches and feels that the proposed amendments would address all concerns. First was the fiscal impact, which we talked about. There is no comprehensive accrediting body for international postgraduate medical training. ACGME International is limited in scope, and the World Federation of Medical Education has not yet implemented any accreditation system. As drafted, the bill would require the board to rely on contracted evaluation to access training equivalency, resulting in significant fiscal impact of approximately $150,000 annually. While the original bill incorporates many work groups and commission recommendations, the current eligibility criteria are overly restrictive and may significantly limit participation by internationally trained physicians. In the board's proposed amendment, we recommend replacing certain requirements such as the state domicile, the USMLE, with the in-state employment-based supervised practice model, which would expand access while ensuring physicians remain in Maryland and practice safely. The board's proposed amendment maintains patient safety and qualification equivalency. Applicants must meet a rigorous baseline standard, including ECFMG certification and passage of USMLE 1 and 2. Supervised in-state employment combined with USMLE 3 and facility attestation for independent practice ensures competency comparable to US-trained physicians. For this reason, I urge favorable report on House Bill 598 with amendments. Thank you.
Thank you very much for your testimony. And for the body, I wanted to let him finish articulating the amendments for the record. Go ahead, Mr. Tran.
Good afternoon, Madam Chair, committee members. For the record, Michael Tran with the Maryland Board of Physicians. First, just want to thank Delegate Hill for your leadership, your experience, knowledge, and dedication to kind of getting this done. Dr. Ajrawat kind of went over our amendments. I'll kind of just focus on a few points. I think we're all in agreement here. There's been a lot of work that's gone into this. I think we're almost there. I think what we need to figure out is kind of the bottom line requirements for these folks. And I think what the board is suggesting here is we're okay with removing some of these requirements because some of them are duplicative, such as the state domiciled and the USMLE 1 and 2, which are already a part of ECFMG certification. What we think is the most important part of this bill is supervision and employment. I think the number is 17 out of 18 states states that have already done this, they have supervision and/or employment in their state laws. We, the board, we can kind of verify and process applications, accreditations, and all those documentations. But what we can't do is kind of oversee that hands-on training and experience that these folks have. And we believe that is a very important safeguard when it comes to this legislation. Because ACGME-I or other accrediting bodies aren't similar, or aren't equivalent, but substantially similar, we can't really say that they're the same. Because of that, we think that the safeguards of having supervised employment or some safeguard there that I think the hospitals and a lot of other stakeholders are supportive of is going to be the most important part and kind of get this off the ground and moving. But with that being said, that's kind of like the gist of all this conversation, but there definitely is still work needed to be done, but I think we're all kind of moving forward in the right direction with this. Thank you.
Thank you very much for your testimony. Are there questions for this panel from the members? Seeing none, thank you very much. Please continue to work. It seems like we're moving in the right direction on what will really be a significant addition to our workforce efforts. This concludes the bill hearing on House Bill 598. We are now going to move to House Bill 769. This is State Board of Social Work Examiners Conditional License to Practice Social Work Revisions. Delegate Woods, welcome back to our committee. Do we have Delegate Woods here? I don't see her here. No. All right, I don't see Delegate Woods. So we will go to House Bill 624 to give Delegate Woods some time to get here. Oh, Delegate Woods has just arrived. All right. Welcome back to our committee. It is good to see you. So now there are a number of witnesses on this bill. So to be balanced, we're going to do the sponsor panel, and then we're going to go back and forth between favorables and unfavorables. Delegate Woods, if you would like to bring your sponsor panel up. I have James Coons, Kaylee Powell, Felicia Ross, Rachel Doyle for your sponsor panel. Is that correct? And when you're ready, you can begin your testimony.
Good afternoon, good afternoon, good afternoon, Chair Bagnall, Vice Chair Cullison, and esteemed members of my first love, of the Health Committee. I am so glad to be before you today. For the record, I'm Delegate Jamila Woods, here to request a favorable report on House Bill 769, legislation to update Maryland's social work licensure process by revising the conditional license pathway for bachelor's and master's level social workers. I'm offering sponsor amendments in concept to further clarify the structure of the bill and to more accurately describe the model as practice-based licensure. These amendments make technical and conforming changes, including establishing a clearly defined practice-based pathway alongside existing statutory authority, aligning terminology, and providing additional implementation and reporting clarity for the board. The amendments do not alter the intent of the legislation, which remains focused on creating a supervised, accountable pathway into the workforce while maintaining public protection. Maryland is experiencing serious workforce shortages in behavioral health and social services, and social workers are essential across hospitals, schools, community providers, child and family services, aging services, and reentry programs. At the same time, we see qualified graduates delayed or pushed out of Maryland because the current pathway into the profession is too narrow and for many unnecessarily restrictive. HB 769 responds to the reality in front of us. We need to protect the public while also ensuring our state can retain and deploy a well-trained workforce. House Bill 769 makes three core improvements. First, it modernizes the conditional licensure statute So it is not tied only to an exam unavailability scenario. Under current law, conditional licensing was treated as an emergency workaround when an exam could not be offered. This bill instead makes conditional licensure a defined entry pathway for initial applicants who have already met Maryland's education experience requirements and are otherwise fully qualified except for the exam requirement. Second, HB 879 reinforces public protection through clear guardrails. A conditional license holder may practice only within the scope of the license category issued, bachelor or master, and must practice under a board-approved supervisor. The bill also places shared responsibility on both the conditional license holder and the supervising social worker to comply with supervision and conditional licensure expiration requirements. Meaning conditional license is time limited, it must be set by the board for at least 12 months and no more than 24 months. It cannot be renewed, and it terminates automatically upon expiration or once the individual qualifies for and receives full licensure. Third, the bill establishes two clear accountable pathways from conditional licensure to full licensure. A conditional license holder can obtain full licensure by either achieving a satisfactory exam score or by completing at least 1,500 hours of supervised practice during the conditional period, verified by a board-approved supervisor and evaluated under standards established by the board. Importantly, the bill requires the board to adopt regulations that set minimum supervision requirements, reporting procedures, and standards for evaluating supervised practice. Those standards must be developed in consultation with an accredited institution that offers both a BSW and MSW program, ensuring the oversight is anchored in accredited social work education and professional expectations. Stakeholders emphasize the importance of clarity, strong supervision and requirements, and avoiding a two-tiered system. HB 769 is designed to do exactly that. It does not create a lesser license for a backdoor around competence. It creates a structured, supervised, time-limited pathway for initial applicants who have already completed rigorous educational accredited programs and field education, and it relies on board regulation to ensure consistent standards, documentation, and oversight. Finally, HB 879 strengthens legislative oversight and transparency. Beginning in 2026, the board must report annually on the number of conditional licenses issued, the number of conditional license holders who obtain full licensures, and recommendations to improve implementation and impact on the healthcare workforce. That reporting requirement ensures the General Assembly can closely monitor outcomes and make adjustments if needed. House Bill 769 is a practical, responsible workforce bill. It provides public safety through supervision and board regulation while helping Maryland retain qualified social work graduates and fill urgent vacancies across our health and human services system. For these reasons, I respectfully urge a favorable report on House Bill 769. Thank you.
Thank you. I'm a little short, apologize. Good afternoon, Chair Bagnall, Vice Chair Cullison, and members of the committee. My name is Felicia Ross. I'm a licensed clinical social worker. I'm the president of SWARE, Social Workers for Equity and Anti-Racism. I was also the NAACP appointee to the work group on social worker requirements for licensure. During our deliberations, only 4 of 23 members voted against alternative pathways, the 2 ASWB representatives and the 2 board representatives. ASWB generates approximately $21 million annually from exam fees, and the board is a partner of the ASWB. HB 769 does not lower standards, as you just heard, or remove protections, as you also just heard from the sponsor. It still requires a CSWE accredited MSW, 1,500 hours of supervised clinical practice, board oversight, and background checks. Supervised practice measures real competence. For example, can a social worker assess a client, develop a treatment plan, navigate ethical decisions, provide safe, effective, especially culturally competent care. An exam has never been proven to predict these outcomes. The evidence, however, does support alternative pathways. We know in Illinois, it increased its workforce sevenfold with no documented safety issues. In Rhode Island, it doubled its workforce without increased complaints. And in Utah's 2025 audit, it shows workforce growth about 28% after removing the exam, and none of these states reported harm. This bill does not conflict with the Social Work Compact. The Compact explicitly allows each state to determine its own in-state licensure requirements. Only those seeking multi-state practice must pass the ASWB exam. Ironically, the Compact itself creates the two-tier system that opponents claim to oppose. I digress. Maryland needs over 2,000 social workers by 2028, yet 70% of our graduates are leaving the state or the field entirely as a result of the one path that we have currently. Our communities are going without care while qualified professionals are blocked by this exam that never proved that it can measure competence or protects the public. HB 769 creates an evidence-based pathway that other states have proven works, and I respectfully urge a favorable vote. Thank you so much for your time, and happy Black History Month.
Good afternoon, everyone. My name is Kaylee Powell, and I'm here today in support of House Bill 769 because the current licensure system creates barriers that disproportionately impact Black social workers like myself and threaten Maryland's ability to meet the needs of our communities. I am a Master of Social Work student from Baltimore, Maryland, and I recently graduated from Salisbury University and the University of Maryland Eastern Shore with bachelor degrees in both social work and sociology, earning a 4.0 at both institutions. And yet, I am concerned that I may be held back from practicing social work due to the licensing exam. I want to serve Maryland in many capacities, particularly with children and families who have been historically underserved by our systems. My commitment to this work is grounded in lived experience, academic training, and a deep understanding of the communities that I serve cannot be measured on a multiple choice exam. This bill creates an alternative pathway to licensure that values demonstrated competence, supervised practice, and ethical service, rather than the reliance on a singular exam. By doing so, it ensures that capable, well-trained social workers are not excluded from the profession due to barriers unrelated to their ability to practice effectively. To be clear, the issue is not that women of color are pursuing social work are failing to serve their communities, promote social justice, or recognize the dignity and worth of a person. Rather, the issue lies with the exam itself. An assessment format that reduces a nuanced profession to a multiple-choice exam cannot accurately measure a lived experience, ethical judgment, cultural humility, or the values that guide real-world practice. I plan to graduate this May with my Master of Social Work, and I've never lived outside of Maryland. But if this bill does not pass and I become unable to be licensed here, I will likely need to begin my career in a more accessible jurisdiction such as Washington, D.C. or Virginia, simply to earn a livable wage. If you issue a favorable report and this alternative pathway becomes law, Maryland could follow the example of Washington, D.C., which increased its master-level workforce in 18% in just over 2 months, or Illinois, which doubled its workforce in 2 years without an increase in sanctions. These policies do work, and they do not compromise public safety. Thank you for your time.
Good afternoon. My name is Jim Kuntz. I'm professor and chair of the social work department at McDaniel College, though I'm testifying on my own behalf today. I've taught undergraduate and graduate social work courses for over 30 years at McDaniel, University of Maryland, at Columbia University, and the University of Michigan. And at all those schools and over all those years, I've worked alongside dedicated social work faculty and social work supervisors to provide the education, the training, the experience, and the vetting to ensure that graduating students would be competent social work professionals. So I'm here to speak as someone who has been teaching students, including some of whom have the exam has been a barrier to entering the profession. I'd like to talk about Manny Wilkerson, who's given me permission to do so. I met Manny when he was considering transferring to McDaniel to study social work and was immediately impressed with his academic record, his commitment to helping people, his embrace of social work values. I remember thinking that he had a lot of potential and was thrilled when he decided to come to McDaniel. I also remember, by the way, meeting his mother and stepfather and how proud they were of him. He fulfilled that potential at McDaniel. He excelled in the classroom and at his senior field placement, consisting of 400 hours of practice under the direct supervision of a social work professional. Our faculty and his field instructor were so impressed with his ability and competence that we recommended, and his graduate social work program agreed that he be accepted directly into the second year of a 2-year MSW program. He excelled there as well, and upon graduation, he received 9 job offers. All of them were contingent on obtaining licensure. And that's when things started to change. He took the exam 3 times without passing. The last time he would have passed had he gotten just 1 more question right. The job offers were rescinded, and Manny faced a tough choice to accept a job that didn't require licensure or to leave the profession, a choice that was made tougher because he needed to support his family after his stepfather passed away. His story actually ended well. He was eventually hired in a position that paid him less, but allowed him to work under the condition that he obtained his license within 2 years, and 1 year later, he passed the exam. But as a social work educator, it breaks my heart and also frustrates me to hear the stories of social work graduates who are as dedicated and skilled as Manny, but who give up or consider moving to one of the other states that offer an alternative pathway, which is what this bill would do. So I urge that you give it a favorable report. Thank you.
More folks that you expected on your panel? Oh, I'm sorry, we missed you. Thank you.
Hi, Vice Chair Colson and members of the House Health Committee. My name is Rachel Doyle, and I respectfully request your favorable vote on HB 769. I'm a lifelong Maryland resident, yet I have been licensed in Washington, D.C. for nearly 15 years. As you've heard today, D.C. has recently implemented its own alternative pathway, and it has increased its workforce by 18% in just over 2 months. Importantly, 58% of individuals using this pathway are Maryland residents. These are not outsiders. These are our neighbors, our graduates, and our future workforce, people who want to serve Maryland but are forced to begin their social work careers elsewhere because of barriers that do not reflect their actual competence. When professionals establish their careers in another jurisdiction, many do not return. I should know, I'm one of them. As a clinical supervisor and internship field instructor, I directly evaluate clinical competence in real-world settings. You may hear claims that these candidates are somehow less qualified or represent a risk to the public, but I can tell you that the licensing exam has never told me who will be a strong, ethical, or effective social worker. Education, supervision, and demonstrated practice do. This is exactly what this bill preserves. You may also hear assertions from people affiliated with the ASWB about public protection through exams. What you will not hear is peer-reviewed evidence, statistical analyses proving reliability or validity, nor the true public harm of workforce shortages. These shortages harm the public every day through delayed, expensive, and reactive care, and families who are unable to access services when they need them the most. While other jurisdictions are actively welcoming this workforce, Maryland continues to lose them. I'm not only a social worker and a Maryland resident, but a member of a family that has relied on social workers during difficult times. I intimately understand the challenges of the shortages in our communities. We need more qualified professionals. They are already here and ready to serve, and we need them to stay. You've even been hearing about them in other bills before you today. Thank you, and I look forward to your favorable report.
Thank you very much for your testimony. Are there any questions from the members for this panel? Vice Chair Cullison.
Thank you, Madam Chair. I think this is for Ms. Ross. You gave the figure 70%, I think this is what I heard, so I need to confirm.
Sure.
70% of our graduates, our masters, MSWs, who graduate from Maryland colleges are leaving Maryland to go elsewhere.
Yes.
And and you know, how is that? How do we keep that data?
So when in 2024, and I have it here, I know the Maryland, I think it's the Maryland Department of Health, they did a study, and so that is where I got that data for in 2024.
The Maryland, so
The Maryland Behavioral Workforce, thank you.
The Maryland Behavioral
Workforce in 2024 did a study.
Even better.
Yeah.
Thank you very much.
You're so welcome.
Yes, exactly. The needs assessment for the workforce fund.
Yes.
Thank you very much.
No, thank you.
Delegate Hill.
Thank you. I'd like to direct my question to the professor. I'm sorry, I don't. Yeah. The example you gave, Manny, I think was his name, he failed 3 times. After doing clinical work for a couple of years, he passed. As just one example, what was the difference between the first 3 times he took the exam and the 4th time?
You know, that's a great question, and I asked him that, and he said nothing had changed. Actually, each time he took the exam, he did slightly better. He came within 1 question last, and then he said the next year, he said, I was no different a person. I just happened to pass it the last time I took it.
All right, thank you.
Yep.
Delegate Hutchinson.
Chair, so Delegate, thanks for bringing the bill back. I remember you and I having a conversation in the back room 1 or 2 years ago about this bill, and you talked about the test being biased. And you gave me a really great example of a question and how it can be biased and how it might be answered by a different student. Are you just saying we're not going to have the exam, or are you now saying that we're looking to correct it so that eliminates the biases that we talked about 2 years ago?
Yes. So first of all, no, we are not saying at all that the exam will be eliminated. We're saying you can get a conditional license, okay? And so that gives you an opportunity to continue to do the work because of the great need. However, that license will expire at some point between 12 and 24 months, that conditional licensure. And just to reiterate your question, yes, I told you that. And just for the sake of the committee, if you all don't know that, I was a person who was hired with a conditional license to do social work and did it and eventually passed my exam. But the issue was, again, my work didn't change. What I was doing didn't change. And my licensure was at a graduate level, and they still had me working with, I was the head of a red team in Washington, D.C., where I was actually providing guidance and supervision to attorneys, clinical social workers, and all of those. And I was a licensed graduate social worker. And so, again, the work that you do is so important and so needed, and there are so many people who are capable of doing that. So no, we're not saying at all that we're wiping out the licensure. What we're saying is that we're trying to fill a desperate need right now, and that there are qualified people who are available to do it. I live in Maryland and was licensed in Washington, D.C. also to bypass, the fact that I knew both from I went to school, I got the degrees, but I also had the lived experience. I grew up in foster care. And so I brought a lot to the table just because of my own lived experience. And sometimes we don't take that into consideration.
Thanks for clarifying that. Appreciate it.
My pleasure. Thank you.
Thank you, Madam Chair.
Thank you. I see no other questions from this panel. I just want to say thank you again for bringing the bill back and bringing it back better. And to the body, I believe that workforce, that behavioral health workforce needs assessment also said that we were at about 50% of where we would need to be by 2030.
Yes. Yep.
Thank you very much.
you.
We have one, I'm going to go ahead and call a favorable, and then we'll do favorable with amendments and an unfavorable to just try to be balanced. So Charlotte Hoffman.
Thank you, Chair, Vice Chair, members of the committee. Charlotte Persephone Hoffman again. This time I am testifying on behalf of Trans Maryland, and not, to be clear, the Board of Morticians. I thought about having two hats that I would physically change, but I decided that might violate the decorum rules. So we are strongly in favor of this bill because it is vitally important that marginalized communities, when they are trying to access assistance through social workers, that they have available to them people who look like them, have had experiences like them, understand what they're going through. And as we've heard from the first panel, there are far too many barriers in place for the licensure of social workers in Maryland at the moment. So we see the most marginalized folks as the ones that are pushed out of the profession here, pushed to other states, and what we're left with is a mass of social workers in Maryland that are not as representative of the community as they should be. There are also significant issues with the licensure exam, which Delegate Hutchison referenced a moment ago. And those have been known for at least a decade. And the National Association, which drafts the exam, has not remedied the situation. So they've had a decade to fix it. And they're going to come in a few minutes and talk about how it's absolutely necessary. But the systemic racism in that test is still there in the same way it was 10 years ago. So this is not a situation where, we just need to give them more time to fix it. because they've had time and they haven't done so. Instead, we need to look at an alternative way to allow Marylanders who are studying social work to actually practice in this state. Thank you.
Thank you for your testimony. Do we have any questions for this witness from the members? Seeing none, thank you very much for being here. I now have a favorable with amendments panel. So if I can bring Sharon Powdrill, Karen Richards, and Daphne McClellan to the table, and you can get started as soon as you are ready.
Good afternoon, members of the committee. My name is Sharon Powdrill, and I'm a guardianship caseworker, and I am here on behalf of ASME Local 112 members with the Department of Social Services. I am in favor of the bill. I am here to offer an amendment establish additional alternative pathways through the conditional license. Many of our local 112 ASME members have been with the agency for over 10 years and have experience in the field of social work. They are very good at providing the best practices for our clients. However, the licensure process has been a barrier for some. We have had some of our members who have taken the licensure exam 10 times and have been unsuccessful. We encourage you to give consideration to adding the amendment for conditional license so that who currently hold a social work degree with the experience can be licensed as a social worker. The applicants would need either to have 10 years experience or 2 years experience plus a related degree, BSW or MSW in social work in order to qualify for grandfathering. Thank you. We urge the committee to use a favorable report on House Bill 769 with this amendment.
Thank you, Madam Chair, Vice Chair, and members of the House Health Committee. My name is Karen Richards, and I am the Executive Director of the Maryland Board of Social Work Examiners. The Board of Social Work Examiners, like other health occupation boards, has a mission to protect the public, set professional standards for licensure, and impose discipline as necessary for violations of statutes and regulations. Our board aims to ensure the following: public safeguards through regulation, career mobility through the Interstate Social Work Compact, high professional standards for entry to practice, and responsive customer service to current and potential social work license holders. As of February 6, 2026, Maryland has 20,339 active licensed social workers in the state. That being said, the board does recognize for some there are barriers to licensure, and we support efforts to reduce those barriers, including changes to the exam, limits to the number of times an applicant can retest, and considering alternative pathways. The board maintains that applicants should choose their path to licensure. Taking the LBSW and the LMSW level exam as laid out in our current statutes should always be an option for social work school graduates. This bill offers an alternative to the exam for LBSW and LMSW licensure. And as we consider these changes in using the exam as a measure of competence for entry to practice, we must be mindful that lowering standards does have the possibility of mainly affecting those clients with fewer options. Higher socioeconomic status clients will always have access to selective providers beyond social workers for their health care. We do ask that you have a vote of favorable and consider our proposed amendments as outlined in our position paper. And we did have a meeting with the co-sponsor of the Senate bill, and we were able to find several areas of common ground. Thank you.
Good afternoon, Chairwoman Bagnell and members of the committee. I'm Dr. Daphne McClellan. I'm representing the National Association of Social Workers Maryland chapter. I am their legislative co-chair. We support House Bill 769 with amendments. We believe that it is an important step toward increasing Maryland's social work workforce while continuing to protect the public. NASW believes the current licensure requirements create barriers that limit who is able to enter and remain in the social work profession. Some of the people who've been having difficulties with the test are persons of color, older applicants, individuals for whom English is not a first language, and those who are hearing impaired. These differences reflect structural barriers that reduce access to licensure and shrink the workforce in Maryland. Based on House Bill 769 as introduced, NASW Maryland supports some changes to strengthen and clarify the bill. We recommend clearly stating whether conditional licensure is intended to be an ongoing alternative pathway rather than only an emergency measure. We also recommend specifying which license levels are eligible, such as the LBSW and LMSW, and clarifying that it does not apply to independent clinical licensure, the LCSWC. We believe the required 1,500 hours of supervised experience should be tied to competency-based standards and supervision, which will ensure consistency, protect supervisors, and maintain public trust. We feel that there is a serious workforce shortage in Maryland, and therefore we do support this alternative pathway. We have seen the amendments that have been submitted by the Board of Social Work Examiners, and we believe that working with them and with the sponsor, we can come up with we can ensure that this legislation is clear, effective, and equitable, and we encourage your support. Thank you.
Thank you very much for your testimony. Are there questions from the members for this panel? Seeing none, thank you very much. We are going to now bring an unfavorable panel. So if I could bring Dion Bushrod, Cody Corselius, Stacy Hardy Chandler, and Phinia Reed. And you can start your testimony when you're ready.
Thank you very much. Distinguished Chair, my name is Dr. Stacy Hardy Chandler, and 40 years ago, this upcoming fall, I walked into my first social work class and discovered not only a career, but my professional purpose and passion. That's why after years of providing direct services, then on faculty, and later in senior management, it is important for me to come before you to testify in opposition of HB 769 as both a licensed clinical social worker and as the Chief Executive Officer of the Association of Social Work Boards. We support social work status as a profession in a time when our standing is once again in question. We have long fought to be recognized as a regulated profession on par with other licensed health professions. Across all healthcare professions, that status is earned through education, supervised experience, and yes, an independent competency assessment, which serves as a hallmark for demonstrating baseline applied knowledge. As we struggle for our reputation and credibility, social workers should not be held to standards lower than those of other healthcare fields. As I've heard in testimony today, listed among other vetting qualifications. I'm here today because the social work licensure examination is strong, well-designed, and essential component to public protection. The exam is developed by practicing social workers for future practicing social workers. The hundreds of volunteer subject matter experts representing diverse practice settings, regions, and lived experience write, review, and validate exam content to ensure it reflects real-world, first-day-on-the-job practice. As a result, the exam is psychometrically validated to national testing standards, continuously evaluated for fairness with layers of anti-bias safeguards, grounded firmly in current practice, and legally defensible as a uniform measure of minimum competence. ASWB welcomes continued collaboration with the General Assembly, the Maryland Board of Social Work Examiners, and the social work community to address workforce challenges without dismantling standards. For these reasons, I respectfully urge the committee to issue an unfavorable report, and I welcome your questions about ASWB and its exams. Thank you.
Okay. Vice Chair, members of the committee, good afternoon. My name is Dion Brown Bushrod. I was born and raised in Baltimore. I live in District 10. After attending Maryland public institutions from high school, City Forever, to graduate school, I was licensed as a graduate social worker and then on to a clinical social worker, and I've been licensed since 1996. I've worked in adult psychiatric services, the city school system, Maryland Health Department, child welfare, juvenile services, all with vulnerable populations in direct care and leadership roles. For more than 20 years, I maintained a private practice accepting public and commercial insurance, primarily attending to the mental health needs of Black women experiencing intimate partner violence. Part of their abuse system was being in workplaces where they had abusive supervisors who would discourage, derail, and demean their success. So for every client who was told that they couldn't meet standards because of their lived experience, the color of their skin, I oppose House Bill 769 because it suggests supervision can replace the social work licensing exam. If my entry into this profession depended on a supervisor's opinion, I would not be here with you today. I've experienced countless racism and classism. I offer a recent example. Just before I testified before Senate Finance last week, my current employment with ASWB was singled out by the bill sponsor in a way that implied that my thoughts were shaped by my employer rather than my own critical thinking. Now, I don't raise this as a personal grievance, but as an illustration. Human assumptions and perceptions can influence judgment, access to success. So delegates, if a client questions a social worker's qualifications, should the state rely only on supervisory opinions or on an objective standardized safeguard? Especially with that 2023 health assessment that showed that Maryland is experiencing a workforce shortage, none of those professions are reducing qualifications, getting rid of the exams. For these reasons, I respectfully urge the committee to oppose House Bill 769.
Good afternoon. My name is Benia Reed. I'm a Maryland licensed clinical social worker, and for nearly 2 decades, I have served as a consultant with the Association of Social Work Boards as an item writer, an exam committee member. I co-chaired the exam committee. I've been a consultant to item writers, and I'm currently a form review volunteer. I'm speaking on my own behalf in opposition to House Bill 769 as written. I believe deeply in equity and in public protection. We must address disparities in our profession. However, this bill is a blunt tool to a complex issue. I have 4 main points to address. Number 1, the bill assumes eliminating the licensing exam will solve workforce shortages, yet it doesn't clearly define which shortage it is addressing. Whether it's DCF staffing, rural access, supervision bottlenecks, reimbursement barriers, or retention, a statewide elimination of the exam is not a targeted reform. Licensure standards should not be broadly altered without a clearly defined policy objective. Number 2, the Social Work Compact currently requires exam-based licensure. Eliminating the exam jeopardizes Maryland's full participation and reduces portability and earning potential for Maryland social workers. We should not isolate our workforce. Number 3, pass rate disparities are deeply concerning, but eliminating the exam does not address educational inequities, unequal field placements, financial barriers to exam prep, or supervision access. The exam functions as a thermometer. It reflects inequities that exist long before test day for candidates. Removing the thermometer does not resolve these inequities. Real solutions include paid field placements, supervision stipends, exam fee assistance, and structured mentorship support. Number 4, if Maryland determines that an alternate workforce pathway is necessary, the responsible approach is to create a distinct and separate credential with a defined scope and supervision requirements rather than lowering standards for licensed social workers statewide. Other states have done this successfully, for example, West Virginia and the Massachusetts model. I talked about these and some ideas in my submitted written testimony. HB 769 risk weakening licensure clarity, confusing the public, and jeopardizing compact participation. Maryland can expand opportunity without diluting professional standards. For these reasons, I respectfully urge an unfavorable report on House Bill 769 as written. Thank you.
Thank you for your testimony. Before we open it up to questions, is there a Cody Corselius here? Okay. Are questions from the members? I have Delegate Alston.
Thank you, Madam Chair. There are a number of people who've been grandfathered into clinical licensure, and there's really no documentation of any harmfulness to practice. Do you have any examples where people who've been grandfathered in have experienced any problems with their clinical licensures?
So I don't have specific examples of that. I'd give the example of a driver's license. We know that people can
I'm talking about the clinic. I'm talking about the license we're here for today, not other examples.
Okay.
Respectfully.
I hear you. I am not personally aware of any examples of that.
Thank you.
Delegate Hill.
Thank you. We heard that the national, those administering the national exam know that there are problems and haven't fixed it in over 10 years. You have stated that you're aware of the discrepancies, and this is to whoever would like to answer in terms of who's able to pass. I guess my question is this: is it your opinion that if there's a disparity in the ability to pass, and the problem isn't with the exam, do you think the problem is that there are university courses that aren't up to standard? That, in other words, are the examinees not passing because they weren't taught well and the courses aren't being taught well? Or is it a problem with the exam? Or is there some third reason?
There is not a problem with the exam. There are people like my colleague here who work very diligently on assuring that the exam is fair. There are multiple embedded anti-bias safeguards in the exam process, and it's written and supported by practicing social workers. I think it's a problem that is widespread. I can't point to specific courses, but I will say that we as a social work community, if we work together, we can understand some of the reasons why for some graduates of certain programs, those disparities do not exist, and for other programs, they're very wide. I think the question we should be asking is, what are those programs who do not have disparities doing that's different? And we need to generously share that information across the educational system. So it does require further research. It does require further working together, but people passed, and we need to understand the factors or what they have access to that helps them do that.
All right, thank you.
Delegate Martinez.
Thank you, Madam Chair. And I appreciate everyone for being here. I will say before I get to my question, you all's testimony sounded like it was for a different bill. We clearly know there's an issue. The test, in my opinion, is not what it should be, or we would have more clinicians that match the makeup of our state. We're a state that's 30% African-American, and that's not the percentage of this field, let alone that we know the need. And so my question is it that the test is perfect, or is it that we just don't have folks in our state prepared or have the merit to pass it? I think it's fabulous that you all have done what is necessary, and I applaud you for that. But there's a lot of people that are at this barrier that continuously hit this wall, or we wouldn't have this bill. And so what is that issue that you see?
Yeah, I think it starts up the pipeline. One of the things that we hear, and we hear a lot from the community, we listen to the social work community. We have people who share with us that they heard about licensure from the very beginning. Before they step foot in class, they have licensed faculty members who talk about it, who normalize it, who embed it in their teaching process, and it's a part of their experience all along. We hear other people who are told explicitly, you cannot pass, or people who have gone through their entire educational program and have not discussed licensure or what happens after graduation. So I think that there is a lot of variety out there, even within accredited programs. And again, I think the more information you get directly to students and work along with faculty, I think you're going to see those widen in terms of people being able to be prepared for the exam.
Yeah. Just so I'm clear, your answer to me is lack of outreach?
I think that there does need to be more education about the licensure exams, yes.
Got it. Thank you.
Vice Chair Cullison.
Oh, thank you, Madam Chair. You mind if I do two? One is it your premise that every state that has eliminated the test as a barrier has lowered their standards and those people in those states are getting less service from their social workers?
I think that all three of the elements, education, supervision, and the exam, all complement each other in increasing the likelihood that people are going to practice safely and practice in alignment with what we expect for social workers. So yes, it is my position that the elimination of the examination on its face lowers standards.
Thank you. So there, I just read there's 170 questions on the test. If you don't answer 113 of them right, you fail the test. So it's your statement that those 113 questions should be the absolute barrier to practice, even though the first two things that you've mentioned have been met by the applicant. Their education, because they're not going to be accepted here in Maryland if their education has not been comprehensive and met all the requirements. And supervision, they have supervision in their coursework. So those two are met. The exam, I'm a former educator, and I understand the purpose of exams, and I understand the concept of summative exams, and my contention is that, and you can feel free to disagree with me, but there are summative exams at the end of the educational program, and they're passing those. So I've been trying to find some recent data on your website, and I can't. The most recent data I have is from 2022, and it clearly demonstrates racial disparities in the test. And I'm curious as to why, after the ASWB published the fact that they had racial disparities in their test results, that they haven't continued to monitor it, or at least not put it on your website. I know it's a lot, but go for it.
I'd like to speak on a little bit of that. So since the data release, and if you read the data release, there's also information that the gentleman here referenced and talked about in terms of the graduate schools and how those students coming from certain schools and programs and universities are or are not doing, and how they are or are not performing. So that's one big area that does need to be looked at. But since the data release in 2022, we have amended the exam in many ways. We've gone from 4 questions to 3 questions, and we have done we have taken the reading level of the exam down to a 10th grade reading level, which meets all national standards for exams as well. So there are multiple things that we've done. We have practice items on the exam that are not scored, and those items go through rigorous psychometric testing. When those items come back as showing some type of bias to the exam committee, and we are a 100% diverse committee looking at the exam, those items get deleted. They are not revised, they're not looked at, they absolutely come off of the exam. So there are multiple things that we have done differently since the data release.
Where's the data? Where's the follow-up to say, look, we did these things, so we wanted to fix the problem, but I don't see
that new exam just went online in 2024, I believe.
Can I follow up, or? Okay. Yeah. So some of the things that she mentioned, they were not in response to the data. Those are parts of what we have to do as an association overseeing this process. So that's one piece of it. I would recommend not confusing outcomes with origins. So there are disparities, just like there are health disparities. And you don't get rid of the medical test because there are disparities among various demographics. You go back to social determinants of health. Similarly, there are disparities, but I dispute the view that the cause is the exam. The cause is all of the things that come before the exam, navigating these systems. So the source is not the exam. The exam is the thing that is telling us that we have some things to work on, and that's what we're willing to do.
I would agree that the exam is not the source of the racial disparity. What it's doing is showing us that there's racial disparities, and we need to respond to it. And by just making the test the absolute barrier, you're not responding to it. That's my concern. Thank you, Madam Chair, for letting me rant.
Thank you, Madam Vice Chair. To the body, Madam Vice Chair worked on this issue for a number of years, so that's the reason I'm giving some leeway. Seeing no further questions, we do have a question. Delegate Riley.
Thank you, Madam Chair. So it sounds like this bill was put in because of the exam. They think there's issues with the exam, they can't pass it, so then there's an alternative pathway that we're creating in this particular bill. Can you tell me, are there any other healthcare professions that we've eliminated an exam? And if they do take exams, according to I just got my chat GTP. So anyway, I can't find any other profession that doesn't require an exam. And of course, this committee knows that there's work shortage in every profession, but yet we don't have them coming in here and saying, hey, we have to eliminate the exam. If you're aware of one, let me know. And if we do, in your opinion, will this offering this second phase or second option for social workers, do you think it will, I don't know, maybe downgrade the professionalism of a social worker that is already licensed?
So there's a lot there. Go ahead.
For fun, I did research the health occupations under Department of Health. It's about 21 fellow health occupation, and I did not find where standards are being reduced. The exam qualification is being eliminated. The concern as a Maryland licensee, having been a social worker in Maryland since 1996, I was around in interdisciplinary teams where the social worker literally carried laundry, right? That we weren't looked at as a viable profession with as many standards as other healthcare occupations. So the concern is reducing the standards then reduces the profession.
Okay.
And it leaves us in a vulnerable place where we're not as competitive. Social workers are already lesser paid than all the other health occupations. What will employers do? If you're lining me up with the licensed professional counselor who's gotten all of these qualifications and I don't have an exam, who's going to get paid more money? Social workers already have to pay, already have to have 3 and 4 jobs to make ends meet. If an employer gets to pick me for, just bluntly, for a cheaper rate, that's what they're going to do.
Thank you very much.
Thank you for the question.
Thank you.
Thank you very much for your testimony. Seeing no further questions. Delegate Alston.
Thank you. The second bite, and especially on a day like today. I have to ask, earlier you talked about some of the biases that we have in our healthcare system, and you insisted that it's not the test. So is it the people that are writing the test that are writing culturally biased questions, and should we have them take our structural racism and implicit bias training classes before they write these tests that Black social workers are not able to pass?
The test is not biased.
The test is not biased? Is
No.
that your contention to us?
Yes.
Despite all of the data that we've been receiving for years on end?
There are disparities. That's something that we completely agree on in terms of passage rates, but the source is not bias in the test. The anti-bias elements start with training of the writers. My colleague can speak to that. It starts with training. It starts with checks and balances throughout the process. It starts with recruiting diverse writers that reflect the social work profession. And then it goes into the psychometric part of it, where, to her point, items that are performing differently for different groups are eliminated. There is no place else in social work where all of these checks and balances exist. And my concern about an alternative pathway is we know that there is bias in supervision. We have an array of supervisors available that are from excellent to signing off hours. That is where bias is introduced.
And you're aware that we have limited licenses in other professions in the healthcare industry, correct? You are aware of that, right?
In terms of other pass rates?
Yes.
I think that you will see disparities in other, maybe to differing degrees, but you will see them in other professions because we're all part of this, this system. And I think access is an issue.
Thank you.
Thank you very much. Seeing no further questions, thank you for your testimony. We're now going to go to a virtual favorable panel. So if we can bring up William Doyle, Amber Flanagan, Matthew DiCarlo, and Nina Bell, and Christy Love, because that's our full panel. I think we said we've got everyone? Okay. So we'll start with William Doyle if you want. Oh. Well, I was going to say, we'll start with Matthew. Here comes everybody. So let's, just so we don't confuse anyone, let's go ahead and start with William Doyle. William, if you can unmute and start your testimony.
I'm sorry, was it me to unmute?
Mr. Doyle, can you unmute and start your testimony? All right, I don't think he hears us. So Mr. DiCarlo, go ahead and unmute and begin your testimony.
Wonderful. Thank you very much. Thank you very much, committee members. I'm a community scholar who participated in comment during the Maryland Work Group on social work licensure requirements. I'm the author of 2 social work research methods textbooks. So today I would like to help you understand more deeply about ASWB examinations and how they violate testing standards. So for the past 4 years, I've researched the Association of Social Work Boards examination program. A couple of quick statistics. ASWB holds about $51 million in the bank. They operate at about a 17% annual profit margin, and 1 in every 3 ASWB exams is a re-examination of somebody who has failed previously. There's a very big body of educated but excluded social workers. So I often hear, why can't we fix the exams? And the answer is that ASWB does not abide by the required testing standards. Psychometricians have gone through painstaking efforts to specify the exact tests you need to do examinations equitably. ASWB ignores those standards. And in fact, they prevented a team that I led from performing them. So in 2023, I partnered with 2 esteemed social work psychometricians to conduct a differential test functioning analysis of ASWB exams. Our project aimed to bring ASWB into compliance with the test standards required by all testing vendors. So there are a bunch of standards, like about a dozen that ASWB doesn't do. The most important one for me to talk about in my limited time is standard 2.14, which specifies that they must use the conditional standard error of measurement. Standard 2.16 talks about this as being important for the trustworthiness of these decisions. And 2.15 says if you have any reason to suspect they might be different for different demographic groups, you must undertake that analysis as soon as feasible. ASWB just ignores these requirements. They are a standard part of policy reporting. You can pull them up for K-12 tests, praxis exams, nursing exams, education licensing exams, like there's a ton of them. And you guys as policymakers have probably read them whether you've clocked them or not. In layman's terms, the conditional standard error of measurement allows us to see how precise the examination is for test takers of true abilities. Essentially, you want an examination that's good at telling whether a middling social worker is going to be safe or not. An examination that was precise for really good or really bad social workers wouldn't be good for licensing exams. Because boards make licensure decisions based on a single point off of a cut score, the precision at the cut score is the most valuable. ASWB does not conduct this required
Can you kindly
test.
wrap up your testimony?
Oh, thank you. Yes, pathways to licensure like those afforded by HB 769 are necessary, and I encourage you guys to have a favorable report.
Thank you for your testimony. If you can stay on until we finish this panel for questions. Nina Bell, can you go ahead and unmute and begin your testimony?
Thank you. Good afternoon, Chair, Vice Chair, and distinguished members of the committee. Today, I'm speaking as a master's level social worker, professor, and current PhD candidate of social work with Morgan State University, with over 20 years of professional experience working with the most oppressed and vulnerable populations. In addition, my undergraduate academic training has also included journalism, media law, and ethics. That education emphasized the dangers of fear-based messaging and the ethical responsibility to avoid misleading or alarmist claims, principles directly relevant to today's policy discussion into the broader field of social work. Recent ASWB communications have characterized our alternative licensure pathways as dangerous, and in some cases, even suggesting that clinical standards would be compromised. Just as yellow journalism or fear-based messaging has no place in journalism, it also has no place in social work and policy development. In its 50-year history as a sole administrator of the exam, ASWB has yet to produce publicly available large-scale longitudinal, peer-reviewed, quantitative, qualitative, or mixed methods research, demonstrating that exam passage is a valid measure of baseline knowledge, professional competence, and public safety, since we're discussing public safety and how dangerous things are. HB 769, along with its cross bill, SB 18, makes no mention of eliminating the exam, nor does it have any mention of creating a two-tier system or bearing impact on clinical licensure, clinical practice, and overall general practice standards. Again, I want to be absolutely clear that this bill simply establishes an alternative pathway, recognizing already accredited education and professional preparation. As we've already heard earlier today, Maryland is already facing a work shortage. This bill creates an alternative licensure pathway, which will minimize the jeopardization that is happening with our workforce stability in this state. This bill again aims to address those gaps. HB 769 is a concrete policy solution that expands employment, retention, and economic stability. For these reasons, I respectfully urge favorable support and passage of this bill. Thank you for your time and your consideration. And happy Black History Month.
Thank you for your testimony. Mr. Doyle, are you able to hear us? All right. Amber Flanagan, if you want to go ahead and unmute and begin your testimony.
Okay, hello members of the House Committee. Happy Black History Month and thank you for the opportunity to speak. I respectfully urge a favorable report on HB 769. I am a Black woman, a master social worker whose experience reflects the real impact of the Maryland's current licensure system. I earned my MSW fully prepared to serve my community, yet I was unable to pass a license exam after 6 attempts, each time missing the score by only a few points. With every attempt, I received no meaningful guidance or feedback, just another bill, another barrier to moving forward. That process was exhausting, emotionally, financially, and professionally. It made me question myself, not because I wasn't capable, but because the system offered no other way to demonstrate competence. As a Black woman, it was especially discouraging to feel shut out of a profession I was trained for and committed to with no clear path forward. That is when I pursued a licensure in Washington, D.C. through their practice-based pathway. Since becoming licensed, I have been thriving. I'm practicing safely and ethically, supported by an amazing supervisor who consistently affirms my skills and the quality of my work. My performance speaks for itself. My pathway is confidential and I am treated like the professional I am. My supervisor has even said how sad it is that Maryland is losing strong social workers because of this barrier. My story represents many others. Students who are afraid that the exam will stop them before they start, practitioners who know they are competent but can't get past an exam, agencies that cannot hire qualified staff, educators who watch their graduates leave the state, and communities, especially Black and underdeserved communities, who feel the impact of the work shortages every day. HB 769 does not lower standards, it recognizes practice, supervision, and real-world competence. It keeps skilled professionals working instead of pushing them out. Maryland invested in my education, but DC is benefiting from my work. Maryland can do better, and HB 769 is a step in the right direction. Thank you for your time and your consideration.
Thank you for your testimony. Christy Love, if you want to go ahead and unmute and begin your testimony.
Hey, good afternoon, Chair and Vice Chair and members of the House Health Committee. My name is Christy Love. I am a social worker and I respectfully request a favorable report on HB 769. I earned my MSW from the Howard University School of Social Work over 15 years ago. I took the licensing exam at least 5 times and missed passing by just a few points each time. Despite strong education and internship experience, my career growth was limited because I did not have the LMSW. That created real professional barriers and honestly a sense of stigma, even though I was fully trained in serving with integrity and competency. Last year, DC approved an educational pathway to licensure. Because of that change, I finally became licensed. Almost immediately, new job opportunities opened to me and my salary improved. Pathways work. They strengthen the workforce without lowering standards. To be clear, this is a pathway to clinical licensure. We're not asking to eliminate the clinical test. We're requesting another pathway for those who have graduated with their BSW and MSW. DC is not alone. Several other states have adopted similar approaches, and notably, more than half of newly licensed social workers in DC are Maryland residents. That should matter to us. Maryland needs more social workers now more than ever. Social workers are not just therapists. And y'all, we do more than child welfare. We serve in hospitals, schools, senior programs, and community settings wherever people need support and protection. I currently work with older adults, helping them maintain social connections, emotional wellness, and independence. I'm a longtime Maryland resident and want to serve here fully, but my best opportunities have been in DC because of access to licensure. HB 769 removes unnecessary barrier and strengthens Maryland's workforce. Thank you for your time, your leadership, and your consideration. Again, I ask for a favorable report.
Thank you for your testimony. William Doyle. Mr. Doyle, are you able to unmute? All right. Well, we will keep Mr. Doyle in the window, and I'll go ahead and open it up for questions from the members. Are there any questions for this panel? Seeing none, I just had one question, and I think it's either for Amber or Christy. I think either of you could answer this. But you spoke to the fact that you were trained, you had an alternate pathway that was opened up. Have you experienced any diminishment of your expertise or professionalism or expectations in your opportunities that have opened up?
For me, no. My supervisor tells me how much I'm amazing, how hard I work. My skills speak for itself.
Thank you very much. And I'm going to give myself leeway to ask a follow-up and ask the same question of Ms. Love.
So again, y'all, I graduated 15 years ago. I've been competent since then. So, but having that opportunity for the educational license in DC, it did open up opportunities. So I'm the same, I'm still competent. But the thing is, it's more respected, unfortunately, right? So that's really, it's letters behind my name, but I already had letters behind my name. So I'm still a great social worker. I was a great social worker before. But for Maryland and for how folks see that it's lowering standards, I've already officially, but I can officially call myself a social worker. So that feels good, but it didn't make a difference as far as my competency.
And that is what I wanted to hear, that you've been in this profession for a long time, but it opened up opportunities, but did not change your level of competency. So thank you very much. Thank you for your testimony today. Oh, I have a question from Delegate Hill.
Thank you, Madam Chair. This is for the gentleman with the open sign behind his head. Do you have any data that you can share with the committee about which programs have higher passage rates and which programs do not, and whether the ones with higher passage rates have prep courses or other things that they do differently that you can share with us? That's all.
So no, I think that argument is a bit of a red herring. So ASWB actually published a study last year where they investigated, like, even if we controlled for all of the individual, family, community level, like workforce inequity issues, Black test takers, Asian test takers, Hispanic test takers would still be 2 to 5 times more likely to fail the clinical exam. And that was the most equitable exam in terms of pass rates. So they're trying to sort of paint or push off onto the education system what is actually the problem inside of the test.
Thank you very much for your testimony. Oh, Delegate Hill, did you have a follow-up question for Ms. Flanagan, who has her hand raised?
Yes, I just wanted to know if she had anything to add.
No, I'm sorry. Will is in the waiting room waiting to be let in.
Ryan says he's joined.
So Mr. Doyle, we have you as joined. Can you, oh no, don't exit, because if you exit, you can't come back. Can you try to unmute? Well, we'll let. If we can figure out the technology, we'll make sure that he has the ability to testify, because you all have been very patient, and we appreciate you being here with us. So, Mr. Doyle, we will keep trying to figure out how to unmute you. In the meantime, we're going to go to an unfavorable virtual panel. So, so hold tight, Mr. Doyle. And if we can bring up Jennifer Henkel, Susanna Sung, Maurette Monson, Frank Williams, Brittany Duke, and Shelley McDowell Porter. So we'll start with Jennifer Henkel. They're coming now, okay. Let's see. And I can't. All right. Ms. Henkel, if you want to go ahead and unmute and begin your testimony.
Thank you. Good evening, Chair Bagnell and distinguished committee members. My name is Jennifer Henkel, and I am the Senior Director of Member Engagement and Regulatory Services at the ASWB. I also have the privilege of serving as the Project Director for the Licensure Portability Grant funded by HRSA, which supports the development and implementation of the Social Work Licensure Compact. Thank you for the opportunity to address you this evening. I know it's been a really long day and long hearing. I'm speaking today in opposition to HB 769. An optional exam requirement risks creating a fragmented licensing system, including public confusion, professional disadvantage, and administrative burdens to the board. ASWB has collaborated for many years with the Council of State Governments, the Department of Defense, and a broad coalition of social work organizations to establish the Social Work Compact. It's a bipartisan initiative to improve licensure portability for social workers across state lines. The compact represents a vital chance to reduce barriers to care, mitigate workforce shortages, and ensure consistent access to qualified professionals, all while safeguarding public safety and trust. We are living in an increasingly globalized society. Telehealth is an amazing modality to provide social work care. However, professional competent care is mandatory to keep clients safe. Maryland, alongside 30 other states, has adopted the compact legislation. Central to the compact and all professional licensure compacts is an exam. The exam requirement is not arbitrary. It ensures licensure maintains consistent meaning and trustworthiness across states. It assures the public that licensed professionals, regardless of where they were originally certified, have met rigorous and uniform standards. I urge the committee to carefully consider the long-term impacts of removing the exam requirement and its potential implications for Maryland. I welcome ongoing collaboration with this committee and stakeholders to promote a robust, portable social work workforce. Thank you for your attention, and I'm available to answer any questions.
Thank you for your testimony. Do we have Susanna Sung? If you can. Okay, so, all right, let the record reflect that Susanna Sung is not in the waiting room. How about Maurette Monson?
Yes, I'm here. Can you hear me?
Yes, go ahead and begin your testimony.
Great, thank you. Hello, Chair Bagnell and members of the committee. My name is Maurette Monson. I'm a social worker, a national disability rights advocate, and former chair of the Utah Social Worker Licensing Board at the time that Utah passed similar legislation. National disability rights advocates such as myself, vehemently oppose any systems, however well-intentioned, that have the net effect of segregating based on intellectual, mental health, or learning disability. National civil rights laws expressly forbid creating separate delivery systems or pathways to employment, and Maryland's own civil rights laws do as well, found in Title 20, Subtitle 6 of the Annotated Code of Maryland. This proposed legislation could arguably be considered discriminatory in light of these already existing state and federal laws prohibiting separate but equal systems for individuals with disabilities who are impacted by their ability to pass an exam. The Americans with Disabilities Act specifies that equality is not determined by how a pathway is obtained or by what it is called, but by the benefits that a person receives by taking such a pathway. We believe the benefits of alternative pathways to social work testing are not equal, and the state of Maryland does not have the power to make sure that they are. I have personally seen those unequal benefits negatively affect social workers with disabilities in my state and others since alternate pathways were passed. Please, we support efforts to broaden the social work pipeline by providing individuals with disabilities the help that they need to take the existing pathway successfully, and the standards of that pathway should not be changed. Increasing the rigor of test preparation so that people with and without disabilities can learn and grow together is a solution that we recommend and support. We do not support a separate pathway. They create opportunities for legalized discrimination, lower performance standards, and ultimately disadvantage populations like ours that are already starting with tremendous disadvantages. The solution that you are looking for should bolster up test preparation supports, mitigate financial obligations, extend timelines for completion.
Can you wrap up your testimony,
utilize
please?
and broaden accommodation requests, and institute systems of continual improvement and refinement for test questions. Thank you for your time and considering the impact this bill will have on disabled populations.
Thank you for your testimony. Do we have Frank Williams? Do we have Frank Williams? Mr. Williams, if you can unmute. He's joining, okay. All right. Mr. Williams, if you can go ahead and unmute and begin your testimony. Mr. Williams, can you unmute and begin your testimony?
Yes, sorry about that. Thank you. In my written testimony, I kind of go into about the work I did in terms of the modular testing, which was an example of ASWB trying to assist with the passing rates, but this conversation is slightly different. And what I want the committee to know is what actually goes into the exam and a couple other things. So in terms of the actual exam itself, it's not per se written by ASWB. They don't create it. It starts with a job analysis that goes out to tens and thousands of social workers who then give all the critical domain areas and subdomains that they believe are critical to the field of social worker. And so to the idea that ASWB is simply capitalizing on this exam just to make a buck, I think that a lot of people are just not aware of the true exam development process. So again, other social workers are identifying these critical areas, and when people are not passing, they have already said that these are the critical areas they need in order to pass. And I think that that cannot be understated for what it is, instead of making it super trivial. To answer the other, one of the gentleman's earlier question about the idea of the conditional educational measurement part. So I deal with a lot of other clients too. And through the accreditation process, the standards that he raised are more for educational testing. When it comes to the reliability of most credentials and licensure exams, what's deemed good enough is just the overall reliability and the reliability around the cut score. And so when I'm assisting clients go through their accreditation process, the accreditors, which a lot of times is the NCCA body, what they're looking for is a reliability. And from a statistical measure, we're looking for something greater than 0.80, which is deemed as acceptable. However, when you look at ASWB's analyses, theirs actually approaches 0.9. So although they're not showing the conditional standard errors of measurement, they actually are showing that their exam is reliable enough to, again, pass what we would normally deem as good enough for an accreditation exam. Thank you.
Thank you for your testimony. And Mr. Williams, I'm afraid I might have missed it. Can you just state the organization that you're with? Because I know that you have expertise in this.
I kind of went right on that. My apologies. I work for PSI, which is a large vendor organization that works alongside PSI, and works alongside ASWB, and I'm also a resident of Baltimore City.
Okay, thank you very much. And I've got Brittany Duke, followed by Shelley McDowell Porter, and I do see Mr. Doyle in the window, so we will come back to you because we're on an unfavorable panel right now. So Brittany Duke, if you want to go ahead and unmute and begin your testimony.
Hi, hello everyone. I'm Brittany Duke. I am a clinical social worker with 10 years of experience. I'm an example that Black social workers can pass the exam. I do believe sometimes additional resources are needed for different communities. To attain my licensure, just like a driver's license, I completed school, took the exams, completed the hours of supervision through employment. Next, I plan to actually obtain additional licensure through the Interstate Compact. I've worked in foster care agencies, hospitals, and associations. But today I'm here not just as a social worker, but as a Maryland resident and client. I am a Black woman patient in the healthcare sector undergoing services where social workers are vital. I have encountered violent crimes and interacted with social workers during recovery. I have received mental health therapy services as well as offered them. Basically, I have helped clients and social workers have helped me. So this bill to me doesn't just impact whether we're taking the exam or not taking the exam. It impacts clients and communities that we serve. I believe social work clients deserve supports that meet standards, not relaxing them, even in the conditional context. Project managers, nurses, doctors, behavioral health therapists, they all complete an exam as well as other criteria for licensure. So why would social workers who work along these professions in all different systems and service all different populations in Maryland not be held to the same examination benchmark? We cannot disapprove a bill because it may meet a need. We have to think about safety, access, and the standard to which that need is being met. I appreciate all the work that you do, but I hope that you vote unfavorable for this bill because it truly relaxes a standard in a profession that provides care and support to Maryland during some of its most vulnerable times.
Thank you for your testimony. I have one more on this panel, and then we'll open it up for questions. Shelley McDowell Porter, if you can unmute and begin your testimony. Okay, let the record reflect, we do not have Shelley McDowell Porter in the waiting room. And let me call one more time, Susanna Sung. Okay, all right, then we will go ahead and open this up for questions. Do we have any questions from the members for this panel? Delegate Hill.
You are, and the other folks have spoken about this bill as if it were eliminating the test. And as I read it, it's almost like it's creating an additional requirement that people who fail the test, instead of being told you can't work, they're being told you have to do an additional year, call it an internship, call it a residency, call it something. And then you have the opportunity to take the test again. Now, it does say that one of the options is that it can be granted, but that can be, addressed. So are you really saying that you think someone who fails the test should not be practicing even in an apprenticeship or internship status where they get an additional time to learn and maybe be coached through the test or other things, which is essentially what this bill does. It gives them a license a limited license, a conditional license to practice. It doesn't say you have the same license as someone who passed the test. So they're not a licensed social worker.
Delegate Hill, did you say that's directed to the last speaker?
The last one.
I believe that was Ms. Duke.
Yeah.
Yes, if I heard you correctly, I would say that is what I'm saying, that a conditional license, especially based on the area where the individual is working, if you're working with, I'll go to the extreme, but if you're working with clients that are, that have, this is the only thing I could think of, but if you're working with rape victims or domestic violence clients or just different traumas that people can experience, I believe that you need the basic foundation of this exam in order to have that license, in order to have, and especially if I think there was conversations earlier about it being confidential, especially if that client isn't aware that that you have a conditional license, that you don't have, that you haven't taken that exam for that next step. I think from a client perspective, not necessarily from a social work perspective, but from a client perspective, yes, I would want that social worker to not just have a conditional license.
All right,
And
thank you.
even I can expand on that too, just because it's sort of a two-edged sword. I'm also a social worker, and even as a social worker, going through the internship and some of the things that I've experienced, having that supervision is great, but that there is bias that shows up in supervision. Unfortunately, we're people, we're human, and so it does show up. And depending on where you are and your own self-awareness and your own ability to advocate, it could still have a negative impact on you.
All right, thank you.
Thank you for your testimony. Delegate Martinez.
Thank you, Madam Chair. I wasn't going to ask this question, but, you know, the gentleman on the panel, Mr. Williams, mentioned that the test questions come from a pool of folks in the field that are asked about what should be relevant to then be examined, right? But then we just talked about supervision causes bias, but yet the test has no bias, but the questions come from people. And so I'm just a little confused how we round this circle. If this test is so perfect, why aren't people that look like you or I passing it here in the state of Maryland? And we have a need, we have a shortage. So yes, we should not necessarily do everything based on what the need is, but there clearly is a half circle here we're trying to round, and you all's testimony isn't helping me logically round that circle. Isn't that so?
Yes, I'm not arguing perfection. I'm really arguing standards and practice in testing. And so I think that the actual fallacy and logic here is that we're trying to say that you have to have one without the other. I think that the argument that I'm hearing is that either we solve the shortage or we keep the standard. And that's not what I'm arguing. I would argue, in fact, that we could do both and that we could do more to support candidates. What didn't come up today was that there is a ton of free prep material that ASWB hands out, and we're not talking about that part either. And so again, if there's a fallacy in the logic, I really do think that we're kind of pitted against each other where we're trying to fit one against the other, which doesn't have to be that way.
Follow-up?
Yeah, thank you, Madam Chair. I think, and this is, I think, to Delegate Hill's point, was trying to pin down if it is that there are materials or things that are needed, I don't think we need a bill to do outreach, right? If the board knows that folks aren't passing, I don't know why there isn't just a natural initiative already being taken if all of these things, because what I'm a legislator, right? Clearly, I'm asking the questions, but I'm simply saying, like, I'm being told all of this stuff exists, yet there's clearly a need and it doesn't seem like it's clicking naturally. And so here we are with a solution, and I'm being told that it's not right. But this bill doesn't eliminate the test. It's simply giving those that have not passed it the first time the opportunity to do so later on. And I just don't understand necessarily why that contention is there if everything is available and great. And, you know, that's the half circle that I have here.
Yeah, and so I mean, I can't speak to as much. I know Dr. Stacy can, but ASWB actually has several initiatives, as you say, like you mentioned earlier. Is it an outreach problem? And actually, ASWB does several things along the lines of outreach in order to get the prep material to people, in order to have various programs to that nature. So those things are in motion.
All right. Oh, Delegate Alston.
I was just curious, does the state of Virginia require this test in order for someone to be a licensed social worker? Whoever can answer it on the panel. Nobody?
I'm not familiar with the state of Virginia's requirements. I'm from Utah, so maybe somebody else knows that.
The gentleman from the testing center that administers the test, do you all administer this test in the state of Virginia?
I do believe so.
Is it required to have a license in the state of Virginia? To do
That I'm
social
not
work?
sure. Every state has different licensure rules and regulations. So I'm unsure what they are from state to state.
The young lady that is Black and passed the test who didn't experience this discrimination that everyone else did, do you know if the state of Virginia requires a license to be a social worker?
No, I just want to clarify. I didn't experience the same type of discrimination, but I am Black and have experienced discrimination. But no, I'm not familiar with Virginia per se. Just more Maryland.
Okay. Thank you for clarifying that, because in listening to the testimony, it was very confusing for me to hear all of these Black people that have experienced racial bias with this test, and to hear people say that it's not so. It makes it very confusing for us as a community to hear those comments. Thank you.
Oh, you're welcome. I do want to clarify. I'm saying that I've experienced discrimination across my lifetime, not just necessarily in taking the test. So I do believe that certain factors helped me in the test, certain factors that were available in my school, certain factors that were available in my community, certain people. I do believe that that is what helped me in this situation. But I also believe that in a lot of different avenues, as far as knowing how to advocate in a hospital or applying to a job. So it just doesn't just apply to the exam. I hope it's clear what I'm saying here.
Thank you very much for your testimony. Delegate Taver.
I'll be quick about this, but I just find very interesting that that there are a few people. I guess I don't know. I think it's the gentleman that administers the test, and the consultant, Mr. Williams, that are working for ASWB. Do you not feel that this is a conflict of interest? And don't you feel that it behooves them for people to fail so that they acquire more money? Don't you think that that too is a conflict of interest?
I don't think that's a conflict of interest. I think that that's that's kind of an off point of why we're here and why specifically I am here, which is to talk about the technical aspects of the exam. I don't see that as a conflict of interest at all.
We'll take it into the subcommittee, but thank you.
Thank you. Vice Chair Cullison.
Thank you, Madam Chair. Mr. Williams, I've got two questions. Is the test a multiple choice test?
Yes, that is correct.
Okay. So actually I have three questions. So do you feel that a multiple choice test accurately tests clinical skills?
I think that what the test does is works alongside the other two aspects, that being education and also the kind of oversight management. I'm kind of mixing it up, but the clinical hours that kind of go into it. But I don't think that either one of those by themselves is good enough to actually give us a good picture of what it takes to be a good social worker. I think you do need all three and not just one at all.
Okay, and how much does it cost to take the test?
That part I'm not exactly sure of.
Does anyone on this panel know? $230. Thank you.
All right, thank you very much. Seeing no further questions from this panel, we have one more favorable, we think. Mr. William Doyle, are you with us? Oh, gosh, it sounds like I'm holding a seance. Mr. Doyle, are you still here?
We're going to give him a moment.
What? Yeah, I'm here. It says the host has disabled my video.
We can hear you. You are with us. It still sounds like a seance. Mr. Doyle, please go ahead and begin your testimony, and thank you for your patience and tenacity.
Well, thank you for your patience with me. Good afternoon, Chair Bagnell and members of the House Health Committee. My name is Will Doyle. I'm a clinical social worker, Maryland resident in District 21, and the Vice President of Housing First at Pathways to Housing DC. I respectfully request a favorable report on HB 769. Maryland is currently facing a mental health workforce shortage and a growing demand for behavioral health services. HB 769 offers a practical and evidence-based solution to address both. The shortage of MSWs is getting worse as they decreased by 4% from 2024 to 2026. Pathways to Housing DC opened in 2004 when we brought the Housing First model to Washington, DC. In 2018, we were thrilled to expand our work into Maryland. Using a client-centered approach, we served Montgomery County residents experiencing homelessness who are living with substance use and co-occurring mental health disorders, particularly those whose needs are not met by existing programs. Since that time, we have significantly expanded outreach and housing services in Montgomery County. This includes serving youth through outreach efforts and operating the only homeless drop-in center for young adults ages 16 to 24 in the county. In doing this work, we have directly witnessed how the barrier of ASWB exams has harmed our staff and clients, compromised our programs, and prevented the full use of available housing resources. As an employer of social workers, we are absolutely thrilled at the potential of hiring qualified professionals through this legislation. HB 769 would allow us to expand services and better meet the needs of Maryland communities. Due to a dramatic increase in need, we are currently working to grow our outpatient mental health clinic. The success of that effort depends entirely on our ability to hire social workers. Each year, we host 3 MSW interns in our Montgomery County programs with the goal of retaining them as employees. Right now, there's a real risk that despite our investment, they will seek licensure and employment in Washington, D.C. instead of Maryland. In just 72 days, 143 Maryland residents have already obtained master's licensure in D.C. through their educational pathway. Passing HB 769 will help ensure that Maryland social workers can remain Maryland social workers and that our investments continue to benefit Maryland communities into the future. Thank you for your time and consideration.
Thank you for your testimony. Are there any questions from our members for this witness? Delegate Hill.
Thank you, Madam Chair. So are you aware, just to get back to some of the points that my colleagues made earlier, are you aware of any efforts by you, your organization, or other folks to actually help people who seem to be at risk of not passing the test to pass, prep courses, outreach, or anything at all to help them to pass the test?
Yeah, I mean, I think anybody I've encountered who's advocating for alternative paths is just as invested in getting new social workers into the field in whatever way. So if their barrier is unpaid internships, if it's passing the exam, certainly sharing resources. I know one person who creates free resources that she shares. So, you know, as long as exam is required, yes, we're absolutely trying to help people to overcome that, but
Right,
also seeking these other alternatives.
Thank you.
All right, seeing no further questions, thank you very much for your testimony and for staying with us. This concludes the hearing on House Bill 769. We are now going to move to House Bill 624, which is Hospitals, Clinical Staffing Committees and Plans Establishment Safe Staffing Act of 2026. Delegate White Holland, if you want to approach the table and bring your panel, and you can begin your testimony when you are ready. And on your sponsor panel, I have Lauren Knoll, Anna Palmisano, Lorraine Ericott, Jamie DeMarco, and Sarah Westrick.
And Madam Chair, one of Riley's friends is approaching their bedtime, and so I would like to have their mom, Lauren Noel, to testify first, so that way she can head home. And I will go shortly after her.
That is absolutely fine.
Advocate here. So.
Hi.
Yes, and who is this?
This is Thomas. He's one, freshly one.
Well, welcome to the committee, Thomas. We're going to have many questions for you.
Thank you.
So you can. Yes,
My
any
name
friend
is
of Ryan's.
Lauren Noel, and I'm a registered nurse with almost 5 years of experience caring for mostly cardiac surgery patients, and I want to express my strong support for HB 624, the Safe Staffing Act. In my years as a nurse, I have personally experienced the consequences of inadequate staffing. I worked in a Maryland hospital during the COVID-19 pandemic. I know what it looks like when hospitals don't prioritize safe staffing. You know who doesn't know what safe staffing looks like? The hospital executives who worked from home during the pandemic. The same ones who told me and my colleagues to reuse our N95 masks for days or weeks. Hospital executives say they support safe staffing through shared governance and staffing committees, but I'm here to tell you that's not what's happening, and it's not working. At one hospital, thanks, the number of patients that a nurse cared for was directly correlated to how many nurses were working that night. 24 patients and 4 nurses, 6 patients per nurse. 24 patients, 6 nurses, 4 patients per nurse. The staffing matrix was not reflective of patient acuity and encouraged the hospital to frequently understaff and max out nurses with 6 patients each. Recently, our hospital's kitchen was understaffed, so our patients' lunch trays came 3 hours late. Understaffed environmental service employees means less people to clean discharged rooms, which prolongs the amount of time a patient can be admitted, which lengthens ER wait times. It all impacts patient care, and that's why all employees deserve a seat at the table when discussing safe staffing in hospitals. When hospitals fail to provide appropriate staffing levels, patient care suffers, medical errors increase, and nurses experience overwhelming stress and burnout. The reality is that nurses are leaving the bedside not because they don't love patient care, but because they are physically and emotionally exhausted from trying to provide quality care under impossible conditions. I urge this committee to pass HB 624 and take a stand for patient safety and healthcare worker well-being. Thank you.
Thank you, Lauren. Appreciate it.
And thank you for your testimony.
All right, thank you, Madam Chair, and good evening. Good evening, everyone. For the record, I am Delegate Jennifer White Holland. Thank you for the opportunity to present HB 624 for your consideration, the Safe Staffing Act now of 2026. In our committee, we often hear how Maryland is leading the way, and unfortunately, our state continues to take the lead in ED wait times. According to the state's Health Services Cost Review Commission, patients are waiting up to 20 hours to receive care at emergency rooms. Becker Review Hospitals ranks Maryland at 46th in the nation for staffed beds. And according to the Maryland Healthcare Workforce Report, 1 in every 4 hospital nursing positions are vacant, and 62% of nurses say they are considering leaving the profession. These unsafe staffing levels lead to medical errors, as we've heard, higher mortality rates, and healthcare worker injuries and burnout. Our state needs solutions that prioritize the well-being of both patients and workers to address long ER wait times caused by unsafe staffing conditions. And so the Safe Staffing Act will ensure that every hospital in Maryland creates staffing committees in which half are direct care workers representing the entire care team. And so this means that nurses, physicians, technicians, support staff, environmental service workers, and dietary aides have a seat at the table to inform staffing decisions and plans. A patient advocate will also have the opportunity to join each committee. Additionally, the Maryland Healthcare Commission has agreed to collect these annual staffing reports and post them on their website. The bill before you today has been on a journey. And so for the last 2 years, the Safe Staffing Act has been amended to meet some of the Maryland Hospital Association's concerns. What started out as a 15-page piece of legislation that included accountability and enforcement mechanisms is now just a few pages worth of legislation that ensures a mandated process and public reporting. We've done our best to meet in the middle, and yet we continue to find ourselves at an impasse, despite us coming to the table each time in good faith with a willingness to collaborate. And so we will be meeting again this year and look forward to continuing these discussions on this proposal. And so this bill seeks to improve quality of patient care and working conditions for the care team and reduce ER wait times. It also fosters collaboration between care workers, management, and patients. Guidelines for forming the committees will be flexible to allow each hospital to create and adjust staffing guidelines based on their unique needs. A diverse care team will encourage problem solving. This bill will also collect and share data on worker retention, challenges, and outcomes of staffing strategies with the Maryland Department of Health and the Maryland Emergency Department Wait Time Reduction Commission. And it will also enhance recruitment and retention of healthcare workers. 9 other states across the country have passed similar legislation to create clinical staffing committees in hospitals. And while research may have limitations to draw conclusions, it has shown to improve worker engagement and workplace conditions in meaningful ways. And so this process helps improve transparency for workers, patients, and policymakers. This bill has been discussed with the Maryland Healthcare Commission, Maryland Department of Health, Maryland Hospital Association, and it has broad support from AARP, NAACP, physicians at MedChi, Marylanders for Patient Rights, 1199 SEIU, Chesapeake Physicians for Social Responsibility, AFT Maryland, Economic Action Maryland, Alzheimer's Association, Progressive Maryland, American Association of University Women Maryland, Free State Justice, Public Justice Center, and our premier nursing organizations who are all represented here today. And so before I hand it off to the rest of my panel, I would like to highlight some of the arguments that may be elevated by the opposition. And so you may hear that this bill mandates staffing ratios and it will negatively impact hospital budgets. But in response to that, this bill will not negatively impact the hospital budget or lead to bed closures because hospital management has the opportunity to amend staffing plans based on feasibility. This bill is flexible guideline that does not mandate ratios. You may also hear that this will cause an administrative burden on hospitals. And as you all may have seen in the recent report from the Maryland Hospital Association's Carrying Around the Clock, a report on clinical staffing in Maryland hospitals, based on their recent survey, many Maryland hospitals already have some form of hospital-wide committees and have shared governance models in place. And so this bill codifies what most hospitals are already doing with shared governance, with additional guidelines for a more inclusive care team representation and reporting to the Maryland Healthcare Commission. Shared governance models are best practice, which is why we're proposing this legislation. Having a separate staffing committee in addition to what some hospitals may already have does not replicate work and instead ensures an effective process with direct care workers at the table. You may also hear that we're already addressing healthcare staffing crisis, and that's enough. But existing state-led commissions have addressed healthcare workforce through loan repayment, sign-on bonuses, and improving the education pipeline, but they have not solved the crisis of understaffing, retention, and worsening quality of care in hospitals. This bill recognizes that those closest to the problem are closest to the solutions. And so we need a process that includes the entire care team. You may also hear references about the Joint Commission report. And so the Joint Commission 4 weeks ago announced that safe staffing is a regulatory priority and will be connected to hospital accreditation. Maryland Safe Staffing Act complements this and will help hospitals meet these staffing standards. The other question that came up in years prior was around state hospitals and why they were not included. So again, state hospitals are much different than private hospitals because of patient acuity and legal requirements on the state regarding staffing and patients served. Including state hospitals would have to be a separate bill. You may then also hear that staffing, again, is not a problem. But the panel that you will hear today represents what a Maryland staffing committee can look like. Panelists will bring the data, also their own lived experience that you recently heard, and these stories that refute the claim and demonstrate the need for sensible legislation. And so this is an opportunity for our state to be a leader and blend the use of staffing committees, staffing plans, and reporting together, which will better position our state to care for those who care so much for others. Overall, this hybrid approach will yield staffing plans that are worker-driven, flexible, and publicly available. This bill will ensure the voices and perspectives of our healthcare workforce are at the decision-making table, make improvements to workplace safety, address staff turnover, and improve how we deliver care. And so I appreciate and thank you for your consideration. I urge a favorable report, and now I'll turn it over to my panel.
First. Madam Chair, Vice Chair, and committee members, I'm Dr. Anna Palmisano. I'm the Director of Marylanders for Patient Rights, the largest patient advocacy coalition in the state with a collective membership of over 1 million. Our coalition has joined with healthcare workers and community organizations in support of the Safe Staffing Act of 2026. Maryland urgently needs to address the hospital staffing crisis. I encourage you to open my written testimony to see a graph on page 2. During discussions on last year's Safe Staffing Bill, Chair Pam Beidel posed the question, how did the ER wait times in the 9 states with safe staffing committees compare to Maryland's ER wait times? As a PhD microbiologist with over 50 years of scientific experience, I have now done that analysis, and my results are shown on that graph on page 2 of my written testimony. I used the ER wait time data from the Centers for Medicare and Medicaid Services for Maryland and for the 9 states with safe staffing committees. These states are diverse both geographically and politically. To look at the rate of change of ER wait times, I chose time points from 2019 and 2024 to avoid any confounding influences of the pandemic. So we looked at changes in ER wait time over those 5 years. The differences between Maryland and the 9 states with safe staffing committees are profound. During the study period, Maryland ER wait time increased by almost an hour. In comparison, the ER wait times in states with safe staffing committees remained low, with 2 states actually decreasing their ER wait times. So these data strongly suggest a positive impact of safe staffing committees on ER wait times. Maryland patients lack reliable, timely emergency care. 9 other states have already passed a Safe Staffing Act, and Maryland should too. I hope you'll provide a favorable report on HB 624. Thank you.
Good evening, Chair Bagnall, Vice Chair Cullison, and members of the House Health Committee. Thank you for the opportunity to speak in support of HB 624, the Safe Staffing Act of 2026. My name is Sarah Westrick. I'm the Advocacy Director for AARP Maryland. We proudly serve approximately 850,000 Marylanders age 50 plus, and we're a member of the Caring Across Maryland Coalition. Our role is to bring the real experiences and priorities of older adults to the policymaking table. AARP supports this bill because it takes a practical, evidence-based approach to addressing chronic understaffing in Maryland hospitals. The bill creates staffing committees in each hospital with equal representation for management and frontline staff. These are the people who know patient needs firsthand, including technicians, nurses, environmental services workers, and others. This approach ensures that the staffing plans are grounded in real-world patient care conditions. It also empowers frontline workers, improving morale and retention, both of which are critical to improving hospital performance. Importantly, this bill does not impose rigid staffing ratios. Instead, it requires hospitals to create evidence-based, unit-specific staffing plans and to update them annually, supported by a process to track and resolve staffing complaints. This ensures that the plans are meaningful, living documents. The bill also includes gradual implementation, giving hospitals the time they need to prepare for success. In short, safe staffing saves lives. Better staffing reduces medical errors, shortens hospital stays, improves patient outcomes, reduces emergency department wait times, and strengthens working conditions for healthcare professionals. With HB 624, Maryland would join other states that have successfully improved outcomes through similar measures. We respectfully request your favorable report on this bill. Thank you for your time and attention.
Good afternoon. I'm Lorraine Arikat with 1199 SEIU, the largest healthcare workers union in the nation. We support SB 411 for worker-driven staffing plans to improve patient and worker safety. The data reveals that 62% of healthcare workers want to leave the field. This is more pronounced in new nurses joining the field who feel conditions are too risky to work understaffed, while seasoned nurses are not sticking around to be mentors because they are burnt out and choosing to leave bedside care or the field entirely because they feel they're ethically not providing the quality care that patients deserve. Short staffing is dangerous for both workers and patients. SB 411 is collaborative, it is flexible, and it's timely. The Maryland Hospital Association agrees that shared governance committees are best practice, and they have worked successfully in Maryland. Many hospitals already have hospital-wide committees and therefore already have the infrastructure to create more inclusive staffing committees that represent the entire care team. Chief nursing officers and hospital executives can only tell one side of the story, and that's why this bill is so important to ensure voices from the entire care team are at the table. Currently, there is no way of tracking effectiveness of staffing strategies. The Commission to Study the Healthcare Workforce Crisis final report and HSCRC's interim report for ED wait time reduction highlights the lack of adequate data in the state for wages, retention, and staffing conditions. This bill would change that. As of 4 weeks ago, the Joint Commission has raised safe staffing as a regulatory priority, and this Safe Staffing Act will help hospitals ensure compliance and ensure state policymakers and regulators have accurate data on staffing at each hospital on an annual basis. This bill allows Maryland to join the ranks of 9 other states who have staffing committees, where they're discussing safe patient loads, patient acuity, hospital throughput, and many other topics to address patient safety and worker conditions. Nurses and staffing committees in New York and Oregon report smarter problem solving and greater worker morale because their voices are making a real difference in patient care and staffing conditions. For those reasons, we ask for a favorable report to give patients and workers a voice at the table. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, thank you for the opportunity to testify. My name is Jamie DeMarco, and I'm here representing the Maryland Nurses Association on behalf of our nurses of all kinds from all across the state. We urge a favorable report with the sponsors' amendments. I first want to say that our national affiliate, the American Nurses Association, has worked very diligently to achieve the great new policies from the Joint Commission that set requirements for hospitals on what they have to meet in order to achieve accreditation. I have personally communicated with the American Nurses Association, and they have confirmed that this bill is entirely compatible with the Joint Commission requirements, and it is my belief that it will help hospitals to implement the requirements needed to be accredited under the new rules from the Joint Commission. I want to appreciate the Vice Chair for pointing me towards a study that was widely cited, which found that, quote, where frontline staff nurses held positions on organizational committees with the power to influence institutional policies and decisions, those hospitals were, quote, significantly less likely to report unfavorable job outcomes and poor ratings of quality and safety. They also found that these hospitals had higher levels of nurse engagement and were associated with higher hospital consumer assessment of healthcare provider and system scores. Simply leads to better outcomes. I want to reiterate that all this bill does is it requires each hospital to make a committee that involves some frontline staff and ask the frontline staff what they think. The hospital can make changes to that planning before submitting it to the state. It simply requires hospitals to ask our members what we think, and we do have valuable insights. I want to emphasize that Maryland Nurses Association has many members throughout the state. We are not a union. We have many members who are not union members. We think our members who are not union members will benefit most from this legislation because right now they have no access to those decision-making processes. We urge a favorable report with the sponsors' amendments. Thank you.
Thank you very much for your testimony. Are there any questions for the sponsor or this panel from our members? All right, seeing none, I just want to say, first of all, thank you very much for bringing the data and for those reports and answering our questions from previous session. And this is just a question to the sponsor, because we've passed this bill twice out of this committee and out of the House. Have we seen, since it hasn't passed, fully, in that time, have we seen significant improvements in ER wait times, throughput, burnout, patient outcomes, or staff retention that would warrant us not moving forward?
So I will say that we are, as a state, we are doing our best to address all of those particular issues. But I would say, in response to that, that we are marking time and still in the same position that we are in, which is why this bill is being put forth as a tool to address not just ED wait times, but also challenges that we are seeing with our workforce, as well as other issues in how we are providing and delivering care.
Thank you very much. Thank you to this panel. Because we do have a number of witnesses tonight, we're going to go to an unfavorable panel so we can be balanced. And thank you all so much for being here tonight, because I know this is a long day. So let me bring Jamie Chiverall, Carrie Mimnaugh, and Christine Frost. And if you can come to the table and I'm going to go back to a favorable and then an unfavorable, so we're alternating. So it's just Jamie, Carrie, and Christine. And you can begin your testimony when you're ready.
Okay. Good evening, Madam Chair and Madam Vice Chair and members of the House Health Committee. My name is Jamie Chiverall. I am a registered nurse of over 20 years, a proud member of the Maryland Nurses Association and the Maryland Organization of Nurse Leaders, and I'm here on behalf of Luminous Health Anne Arundel Medical Center testifying in opposition to House Bill 621. Flexibility is essential because each patient, every nursing unit requires unique needs and brings new clinical situations that require real-time assessment and flexibility. Frontline charge nurses bring that expertise to the staffing decisions. They play a critical role in adjusting staffing up or down based on the immediate needs. For example, most recently we had a complex cancer patient that the charge nurse was able in real time to be able to upstaff to provide one-on-one care for that patient in the end of his life and to also support his family members. A decision that I would not want being made by an EVS worker or a transporter. I want a clinical person making that decision. In addition, in a recent flu surge where patient volumes rose significantly, flexibility allowed us to open over additional care areas when we experienced ED overcrowding. ED overcrowding being a symptom of us not having great resources in the community, long length of stay in our patients, and not being able to get our patients out to post-acute resources in the community, not because the ED is not staffed adequately. In addition, these care areas were staffed by charge nurses, unit educators, and unit directors who came into staffing to support after we assessed the unit needs and reallocated resources. I myself won a Daisy Leader Award during the pandemic for working at the bedside with the nurses that I, as an executive, oversaw. Very proud of that award. In summary, nursing is a business of caring for people, and that commitment requires thoughtful, flexible staffing decisions that reflect the needs of every patient and every nurse. The adaptability empowers frontline leaders, including charge nurses who have the clinical expertise, to respond effectively to real-time conditions and deliver safe, compassionate care across Maryland. For these reasons, I ask for an unfavorable report on House Bill 624.
Thank you for your work and your testimony.
Okay, good evening, Madam Chair, Vice Chair, and members of the House Health Committee. My name is Dr. Carrie Mimnaugh. I am here on behalf of Luminous Health. I've been a nurse for 17 years, working in critical care and emergency medicine. I also currently serve as clinical faculty for our next generation of nurses. I'm here today testifying in opposition to House Bill 462 due to its impact on nursing practices, shared governance, and hospital operations. One of the greatest strengths of our nursing practice is that staffing decisions are not made in isolation. They are driven by the nurses providing the care at the bedside. At one of the busiest emergency departments in our state, our teams were experiencing extraordinary strain, rising patient volumes, prolonged wait times, and increasing burnout. Rather than implementing a top-down directive, bedside nurses stepped forward. They evaluated the workflow barriers, they analyzed staffing patterns, and they developed innovative and practical solutions. Leadership acted quickly to implement their recommendations. The results were measurable and meaningful. The staff morale was improved, throughput improved, we decreased ER wait times, we decreased times waiting from the ED to a bed upstairs. We reported a renewed ability to provide safe and high-quality care. Most importantly, patients experienced better access and safer outcomes. This is what shared governance is. This is what it looks like in action. This is also foundational to magnet-designated organizations, where nurse autonomy and frontline engagement are evidence-based. If we remove or restrict that voice, we risk dismantling a structure that works. The consequences are not going to be theoretical. They will be felt in longer wait times, reduced flexibility during surge, and diminished access to care for our communities. I respectfully but strongly urge you to oppose House Bill 462 and to protect the abilities of our nurses to lead, innovate, and partner in staffing decisions that directly impact patient care. Thank you for your time. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the House Health Committee. I am a nurse with 31 years of experience. My name is Christine Frost. I currently serve as the Chief Nursing Officer at Luminous Health Anne Arundel Medical Center, and I am also the current president of the Maryland Organization of Nurse Leaders. I am testifying on behalf of MONAL in opposition to House Bill 624. MONAL is a nonprofit organization of nurse leaders advancing advocacy, professional practice, and engagement across the state. Accountability for safe, quality staffing already exists at every level of hospital leadership and across all disciplines. Staffing is not an isolated issue. It is a core patient safety priority embedded in hospital operations and leadership evaluation. The Joint Commission accreditation is an objective, comprehensive process that drives quality outcomes and performance improvement. Hospitals certified through Joint Commission accreditation meet or exceed Medicare and Medicaid participation requirements. Effective January 1st, the Joint Commission implemented a national performance goal requiring hospitals to ensure adequate staffing to meet patient needs and deliver safe, high-quality care, making staffing an explicit accreditation priority. This goal elevates staffing to a safety standard, requires direct leadership oversight, establishes accountability through qualified nurse executives across a multidisciplinary care team, because we do not function in isolation as nurses. It is an absolute multidisciplinary care team that provides quality care to our patients. It also provides data-driven staffing decisions based on measurable factors. The framework reinforces existing accountability by embedding safe staffing into the accreditation review process. Staffing is already a patient safety priority. It already requires leadership accountability. It is already data-driven and outcome-focused. The bottom line, the Joint Commission's National Performance Goal formally integrates staffing oversight into accreditation. House Bill 624 is therefore redundant and would create unnecessary burden without improving patient safety outcomes. I respectfully request an unfavorable report. Thank you for your time.
Thank you for your testimony and for your work. Are there any questions for this panel? Delegate White Holland, followed by Vice Chair Collison.
Thank you, Madam Chair, and again, thank you for your testimony. And I would say, in some respect, I think that there are some points in which that we agree upon, right? But I think it would be helpful to understand, and I think in the last statement, it was mentioned that that you see that this bill is redundant. Can you expound upon how you interpret this bill, given how this bill aligns with the Joint Commission's more recent goals around staffing? I see that this bill can, if anything, complement or is in alignment, but can you expound upon or clarify your opposition and really how you interpret this bill and the components therein?
Yep, I mean, in my experience as a bedside nurse, as a leader, as a CNO, we are consumed with safe staffing. It is the work that we do 24/7. We are constantly paying attention to what the staffing requirements are for safety and outcomes to maintain safety not only for our patients but our staff and our staff as well. So we have established unit-based staffing committees. Units self-schedule. There's an entire process that we follow, and all of that is evaluated and administered with the frontline staff as well as leadership. And the Joint Commission performance goal will supplement that, as you indicated, making it part of our accreditation requirement, which means when they come into our facilities, we will need to demonstrate the work that we already do by presenting that to them. And I would expect that if we're unable to present that information, that we will either have the experience of a finding, or we will need to create some action planning and have them come back and revisit us in order to maintain our connection back to Medicare and Medicaid. So I would say that this is a third line of action around staffing when we already have an internal process that we follow, and we will soon have accrediting body that will be coming in and asking us to demonstrate. So this will be a third opportunity that we will need to demonstrate what we already do with staffing. So therefore, I feel that it is very redundant for hospitals to have to demonstrate the same thing 3 times.
If I may, just very quickly, and I believe you all represent Luminous Health, is that correct? So all you're speaking from is Luminous Health's experience and current model, not necessarily reflective of other hospitals. Is that fair to say?
So I am testifying on behalf of the Maryland Organization of Nurse Leaders, so it's really representative of nurse leaders across the state. So it is not limited to Luminous Health. That happens to be my place of employment currently, but certainly have had 30 years of experience in varied settings. Important to note that, but specifically I am representing Mono this evening.
All right, thank you.
Thank you very much, and I'll just give a shout out to Luminous Health as an Anne Arundel representative, and I suspect that our good delegate from the Eastern Shore will fight me on who has the best hospital system. Vice Chair Cullis.
Thank you, Madam Chair. And thank you all for your service, because I am very partial to nurses. So I think I'm equally confused with my colleague over here, the sponsor of the bill, because what you described about the way that things are happening at Luminous, and I did hear, I think, Ms. Frost, you say, we don't work alone, which to me indicate that you are open to the inclusivity of the staff that you are working with. You are all nurse leaders, so I understand that. So I guess I'm not understanding how this is different. It's not an addition. If you're already doing it, if you're already being inclusive in making decisions around staffing based on some standards, how is it different? Yeah.
So I don't necessarily believe it's different. I believe there are some similarities. I think we acknowledged that earlier, that there are. It is, the work that we do internally is focused on staffing. What Joint Commission is going to be asking us to do is to demonstrate that. So I don't necessarily feel that there are not similarities. I believe it just becomes a third way of demonstrating the work that we're already doing. So my perspective is more that there's redundancy and some burden that we will incur as a result of this bill and the ask that will be that will essentially be redundant for the work that we are already doing internally, and we will have to demonstrate externally.
I think I'm done.
Delegate Warman.
I'll go really quickly, and thank you so much for the work that you're doing. It's really, thank you. This is my second year here, so forgive me if I'm So this is the second year that I've heard all of this testimony come through. And in that year, I go to doctors a lot, and I still have doctors. I live close enough to Virginia that I'm able to choose whether to go to Virginia or Maryland for emergency cases. And I've had doctors tell me, blank, blank, go to Virginia. It'll be quicker to be seen and it'll be more effective. But so this is the second year that we're doing this. If things are going so well, why do we still have this panel here before you guys telling us that we very much need this? Thank you.
You want me to take it? So things are improving. I would say the state of healthcare in general, not just in the state of Maryland, is not where it needs to be. I think we can all acknowledge that. The state of Maryland does have the worst ED wait times. That's not just about staffing. That is primary care physician availability. That's subacute rehab availability. That's the mental health crisis that we're in. That's the reality. We, in Luminous Health specifically, we are doing such great things involving our bedside nurses and our patient care techs and our staffing model that we've been able to improve throughput. We're still not where we need to be. We've had a significant improvement. For example, we are only licensed for 378 beds, but today we had 420 patients, and our wait time in the ED topped out at 2 hours today. 2 hours stinks, let's be real, but 2 hours when we are 8% over capacity, that's significant. So my worry is having people who are not nurses telling us how to do this. My nurses are so innovative, they're so creative, and they want to take care of the patients. They don't want patients waiting in that waiting room. And if you have somebody who doesn't have the same mindset, they're going to tell us how to staff. That's my concern.
Seeing no further questions, thank you very much for your testimony. We're now going to go to a favorable panel to be balanced. So I have Brooke Rothheim, Erica Puentes, Gibran Eubanks, and Ruth Carlock. You can come to the table and begin your testimony.
Okay, great. Good evening, Chair Bagnall, Vice Chair Collison, and members of the House Health Committee. My name is Erica Puentes. I'm the Legislative Coordinator for Progressive Maryland. Progressive Maryland is a statewide member-led organization working for a more robust, equitable, and patient-centered healthcare system. We're also proud founding members of the Patient Worker Collaborative, representing over 1 million Marylanders, raising awareness about long ER wait times and hospital staffing shortages. PMD is in strong support of HB 624, and we want to thank the Health Committee and the House of Delegates for passing this bill with overwhelming support for the past 2 years. Our wait time average is more than 4 hours, and in many hospital emergency department, wait times are often between 11 and 15 hours. Maryland has the worst ER wait time record in the country year after year, and like all of you, we regularly hear stories from our members about very long and agonizing wait times in emergency rooms. Because of Maryland's long wait times, our members are often telling us that if they live close to Virginia, they are opting to travel to their hospitals to be seen. At a recent community meeting, a member talked about calling an ambulance, hoping it would increase their chances to be seen and treated more quickly than if they had a family member take them to the ER. And the critical staffing shortage in Maryland hospitals exacerbates the problem. The Safe Staffing Act of 2026 offers an excellent remedy to what is ailing our emergency rooms. Creating safe staffing conditions will help our hospitals recruit and retain the workforce they need and will help to ensure that we have the number of staff beds we need in our ERs. For these reasons, Progressive Maryland respectfully urges the Health Committee to offer a favorable report on HB 624.
Good evening. Thank you, members of the committee. My name is Gibran Eubanks. I'm the political organizer for 1199 SEIU. I urge a favorable report for HB 624 because our members' experiences show that administrative decisions without oversight and worker input can have a major impact on patient care. At hospitals where 1199 represents members, we often hear tragic stories that could have been prevented if it wasn't for the mismanagement of hospitals. Workers have shared stories where patients have committed suicide because there weren't enough workers to conduct the standard 15-minute wellness checks. increased workplace violence where workers have been beaten and physically abused, and cases where workers' mental health face instability due to burnout and fatigue. Poor staffing conditions have proven to be tragic to both workers and patients and are associated with higher mortality rates and longer lengths of stay for patients. It's imperative that when considering what safe staffing looks like, workers have the opportunity to provide their input. We know that it is workers, not management, who can truly determine what safe staffing levels look like in all departments. I sat on the ER wait times task force in Prince George's County, and when considering key factors that contribute to long wait times in the emergency department, short staffing is at the top of the list. Maryland has the second longest ER wait times in the nation, and this isn't just due to shortage of nurses, but for example, when a patient is discharged from the hospital, that room needs to be sanitized. If there's a shortage of environmental service workers, that room is not cleaned in a timely manner, and another patient cannot be admitted to the room. This is just one example of how short staffing in one department can impact the effectiveness of hospitals, how effective hospitals are run. This is why it's crucial that state staffing committees are composed of a diverse care team. When we rely simply on unit-to-unit staffing approaches, as in current practice in some hospitals without HB 624, there's no way of tracking effectiveness of staffing strategies and how this impacts the entire hospital. Lastly, effective staffing plans can be potentially cost-effective for hospitals. We believe that investing in permanent workforce through higher wages and adequate staffing will improve worker retention and quality patient care. If healthcare worker burnout is not addressed, it will be increasingly difficult for patients to get the care they need. Health costs will rise and health disparities will increase. This is far more important than just workers. We're putting Marylanders' health at risk, and it's time we do something about it.
Chair Bagnall, Vice Chair Cullison, and members of the House Health Committee. My name is Dr. Brooke Rossheim, and I'm a Maryland licensed physician specializing in public health and preventive medicine, internal medicine, and geriatrics. Thank you for the opportunity to testify in strong support of HB 624. Maryland has had the longest emergency department wait times in the nation and the fewest ED visits per capita. This indicates that emergency departments are overwhelmed and staffing shortages are a key factor in this crisis. Anecdotally, I've heard how people, frustrated by long wait times, sometimes travel to Virginia to receive timely care. This is not optimal and only adds to the fragmentation of care in an already over-fragmented healthcare system. Long wait times aren't just an inconvenience. Studies have shown that ED overcrowding leads to higher mortality rates, delayed care, and poor patient satisfaction. For patients experiencing critical conditions like heart attacks or strokes, literally every second counts. HB 624 is a thoughtful approach to addressing this. It establishes hospital staffing committees to ensure input from frontline workers, creates annual staffing plans, and promotes transparency. This will help improve patient safety, reduce staff burnout, and ensure that we can provide timely, quality care for Marylanders. Thank you for your time, and I strongly urge this committee to vote favorably on HB 624. Oh, yeah.
Good evening, everyone. My name is Ruth Carlock with from the Brain Injury Association of Maryland. We are submitting the testimony in strong support of House Bill 624. This critical legislation aims to establish staffing standards in Maryland hospitals, ensuring adequate patient care and support for healthcare professionals. The Safe Staffing Act represents a multifaceted strategy to address the issue of hospital wait times by focusing on a collaborative care team approach that remains flexible on how hospitals can manage the crisis and reduce patient risk and wait times. The Brain Injury Association of Maryland has witnessed firsthand the profound impact that staffing shortages and clinical burnout has on patients, particularly those who have sustained brain injuries. Individuals recovering from brain injuries require intense, specialized, and often prolonged rehabilitation services. The success of the recovery heavily depends on consistent, personalized care provided by a dedicated team of healthcare professionals. Right now, 1 in 4 nursing positions are vacant, and the crisis only stands to get worse with an aging nursing and general population with a decreasing graduating rate of new nurses in the state. Numerous studies show the link between the excess nurse to patient ratios, leading to worse patient outcomes and increasing the number of unnecessary deaths, with Health Service Cost Review Commission showing some patients waiting up to 20 hours or leaving the state altogether to receive emergency care. Moreover, the unpredictable nature of brain injuries requires healthcare professionals to exercise a high degree of creativity and adaptability in treatment planning. This demand, coupled with organizational stressors like scheduling pressures and extensive documentation requirements, further contributes to burnout and reduces the time clinicians can devote to direct patient care. Implementing the staffing standards posed in HB 624 would address these critical issues by ensuring adequate staffing levels, reducing clinical burnout, and improving patient outcomes. Investing in appropriate clinical staffing is not only a moral obligation, but also a strategic decision that will benefit Maryland's healthcare systems in the long term. I urge this committee to issue a favorable report on HB 624 and support its passage to ensure the Maryland hospitals uphold the high standards of patient care and workplace safety, as this committee has done for the last several years. Thank you for your consideration.
Thank you for your testimony. I'm going to open it up to questions from the members. I have a question from Delegate Kipke.
Madam Chairman, to the doctor who spoke, do you or have you recently worked in an emergency room?
No.
Okay. The reason I ask is when I speak to people who work in emergency rooms, they don't complain to me about staffing. It is a problem. They complain to me about not having throughput. There's bottlenecks. People are stuck essentially in the emergency department and can't be moved to another setting. In fact, the commission that the state of Maryland put together to look at the issue listed that as the #1 cause of the long wait times. I did a little research to look at the staffing issues in Virginia. They mirror Maryland. Maryland has exactly the same staffing issues. The difference is that Maryland has a global budget system, which limits the budgets in the hospitals that we've enacted in this state. Would you agree that staffing issues might not just be about what this bill intends to seek, but there may be other issues that causes the problem?
Yeah, I mean, I think that's reasonable, but staffing, I mean, I've worked in enough ERs during my career that, you know, even though I haven't had a foot in an ER in the last few years, I've spent years in ERs, and it's a multifaceted problem, but staffing is one of the core things, and you see it throughout many places. Places can't get primary care doctors, staffing. Hospitals can't get nurses, or they have to pay exorbitant rates for nurses because they're not available.
Well, I appreciate that. The question I have is, if Virginia and Maryland have the same staffing problem, but Maryland has this horrific emergency room wait time and Virginia doesn't, could it be something else that's causing this?
Sure.
Thank you.
Seeing no further questions, I just had a question for whoever could answer, because the last panel spoke to the opportunities of working within the unit. And I'm just wondering if staff committees might present an opportunity for some of those innovative ideas to address some of the challenges that are unique to the hospitals in which they're working.
I would say absolutely, right? I think that's why it's important to have, like I spoke to, a diverse care team where you have folks from different departments who can speak to what safe staffing looks like in their specific department and their specific hospital. You know, things are going to vary from hospital to hospital based on, you know, geographics and demographics and things of that nature. So, you know, giving the opportunity to have workers who are on the front lines and understand what the needs of their patients are, specific to what their needs are, I think is going to be really critical to making sure that things run efficiently.
Thank you very much. And seeing no further questions, we are going to go to an unfavorable panel. As I said, we're trying to be balanced. So if I can bring up Andrew Nicholas, Caroline Doyle, Nisa Ernst, and Nhi Nguyen.
And you can get started when you're ready in whatever order you prefer.
All right. Thank you very much, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is Andrew Nicholas, and I'm here representing the Maryland Hospital Association in respectful opposition to House Bill 624. We do have a panel of expert witnesses that include nursing leaders and frontline clinical staff, as well as representatives from the Maryland Emergency Nurses Association. But before I hand it over to them, I just wanted to highlight a couple of things for you. First, you all should have already received a report from MHA on hospital staffing. If you haven't had a chance to take a look at that, I encourage you to do so. There's a lot of good information in there. Speaks to how clinical staffing decisions are made, the current regulatory structure overseeing staffing, and how Maryland hospitals are leaning into staffing issues and shared governance. But importantly, it has commitments from every single MHA member hospital for policies and procedures to support clinical, our frontline clinical staff, and specifically support and engage with frontline clinical staff around staffing decisions. So again, I just encourage you to take a look at that. Two other things I want to mention. First, as was mentioned already, the Joint Commission standards. This is a significant development because it means hospitals will now be inspected by the Joint Commission on staffing policies and adequacy by our accrediting body. And so that is a significant development that occurred over the interim, and you've heard some about that already. My last thing I want to mention is about the state hospitals. So state hospitals are exempt from this bill. However, when it was introduced in 2024, they were still included. And that year, the Department of Health introduced testimony seeking an exemption. And I just want to read from that quickly for you. It says, while the department supports the goals of safe staffing, we are respectfully requesting amendments to exempt the department from this bill. The healthcare system is bound to the Joint Commission and to the Centers for Medicare and Medicaid Services regulations. And to that, I just want to say, me too. All of the same requirements cited by the state apply to your private not-for-profit hospitals. So we are simply requesting the same consideration for the exact same reasons that was given to the state hospital be given to your local hospitals serving your communities. So with that, I just urge an unfavorable report, and I will hand it over to our panelists. I get lucky sometimes.
Good evening, Madam Chair and the entire panel. Thank you for this opportunity to participate in the democracy process. My name is Nisa Ernst. I've been a nurse long enough to remember when we were paper charting. I am in the emergency room greeting you as you come in the door. And I'm here not to discount what a lot of our other partners have discussed, because they are very valuable points. I am here to tell you that along with the Joint Commission bill that you've heard a great deal about, most healthcare workers throughout the United States are subject to about 600 different regulations. That's important. I will tell you from a patient standpoint, I have never had a patient compliment me on my technology. I've never had a patient compliment me on my regulatory compliance. I am subjected to that regulatory compliance, and it is incredibly important because without that regulatory compliance, we cannot maintain a safe environment for our patients. What is important to me as a nurse is to understand the importance of getting the people that are providing the care to spend as much time as they can in front of the patient. The comments that I hear a lot are, I can't find somebody, they're in a meeting, I went to talk to that doctor, he was staring at a computer. You know, again, trying to meet these regulatory requirements. And by the way, I do respect all of the comments that, again, either side has brought forward. But I do want to advocate for the fact that regulatory is extremely important. Adding another committee and another layer of regulatory, I can't see how that is going to support the patient that I'm meeting in the emergency room. And a lot of the discussion that we've had about the emergency room and wait times, it's very complex. Thank you for the opportunity, and I appreciate your thoughtfulness.
Good evening, Madam Chair, Vice Chair, and members of the committee. My name is Caroline Doyle, and I'm here speaking on behalf of the Maryland Emergency Nurses Association in opposition to House Bill 624. I am a frontline nurse. I have been a frontline nurse since 1989. I'm also a house supervisor, so I think I have a very unique perspective of how the flow goes on the front end and in the back end. I work in a very busy Baltimore City Hospital that serves a remarkably diverse patient population across the spectrum from well-insured to uninsured vulnerable populations. There is a constant flow of patients from multiple jurisdictions seeking emergency and medical care as well as planned surgical procedures. Patient volume changes quickly and acutely in any given minute on any given day. Staffing needs are impacted by multiple barriers, including volume, acuity, and available trained staff for specialty units. And let me tell you, our patients are sicker than ever. Part of that is because of the lack of primary care, preventive care, and that people then come seeking in at the worst times. Please know that clinical unit leaders, including charge nurses, nursing managers, directors, the CNO, and the nursing supervisors are acutely aware of the dynamics of the staffing needs and necessary resources and spend most of their days involved in ongoing conversations to ensure and maintain a safe quality care. And that involves all units of the hospital. It's not very easy for the ICU to tell the medical surgical unit how to care for their patients, or for the ER to tell the ICU or the medical surge units how to staff each division's needs are unique and diverse, and they can speak to what they need individually for staffing, and they do on an ongoing basis. While HB 624's intent is well-meaning, it is redundant to existing professional nursing and hospital staffing guidelines. I will ask for an unfavorable vote on this bill. Thank you very much.
Thank you. And before you continue, I realized I missed one person on this panel, so I don't want them to have to come by themselves. Is it Tulu Lope Akinyemi? Yeah, if you can also join this panel. Thank you for your patience, and you can begin your testimony when you're ready.
Hello, Madam Chair and member of the committee. Thank you for the opportunity. My name is Ni Nguyen, and I have been staff nurse as a frontline for more than 10 years. I worked at Johns Hopkins Howard County Medical Centers. My role as a frontline staff member, I would like to oppose the bills because I think that is like redundant. Staffing, I also think the staffing issue alone will not solve our patient, health care in general. There's a lot of area that me as a frontline to provide our best care for our patient care. So as a frontline, as a charge nurse, as a bedside nurse, my priority would be the best quality of care that I will provide to our patient and the best experience that I will provide for them during their hospital stay. Staffing is, appropriate staffing is, yes, important, but at the same time, when I flash back and when I look back at my 11 years of nursing as a frontline, and I have never been forced to take care of more than what I have been contracted to work for, like no more than 6 patients. And I do know that when I was applying for my job, and I already know that these are the patient ratios that you have to take care of. I do believe that it's not just staffing. I think it's complexity of our patient care nowadays. And also like other factors that involve in, waiting. Yeah, I will favor more focus on our frontline staff education, or more not appropriate staff, appropriate space for our patient in ER. Like those coordinated care. Our CNO are also like open door policy. I have never been not included. Like, we have our president of Howard County Medical Center. I'm sorry, thank you. Yeah. Okay, so our president also had an open door policy, not just like every monthly meeting. Our CNO like will come visit us and check on us. For example, like recent snowstorm, me as a frontline, I have little 3 kids that I have to spend the full day in the hospital, and which is my terrifying. Then I have to make sure and coordinate with my family for, as a frontline. So, but I have never been like stressed out or having an issue or taking care of our patient at the hospital. Is because when I saw our CNO is on site along with us, giving us a place to sleep, food, and some like other minor stuff, I feel like I have met the appropriate, need that I supposed to get. My priority as a frontline is that, like, our leadership, our management, do they listen? And do they hear our voice for our patient safety? My focus as a nurse is for the quality of patient care, and I want to practice safely for our patient and no harm, or myself or the patient.
Thank you very much. Thank you for your testimony.
Madam Chair, Madam Vice Chair, and other members of the committee, thank you so much for the opportunity to testify today. My name is Tolulokpe Akiyemi, and I've been an RN for 3 years, and I am here to urge an unfavorable report on HB 624. Working in the surgical trauma ICU at Johns Hopkins Bayview, I have seen firsthand the importance of patient safety and how we as nurses have been able to stay committed and innovative in achieving this goal. One way that we've been able to achieve this specifically on my unit is through shared governance. And I have seen several safety initiatives come directly from bedside nurses. One of the most recent implementation on my unit was the addition of a resource nurse. We, as bedside nurses, discovered that we needed more help on the unit. We spoke to our management about it and brought up the idea of having an extra hand on the unit to help us on the unit, and they listened to us, and now we have a resource nurse that helps us on the unit. This was implemented to specifically tackle the specialized needs of our ICU. Teamwork is very essential to us, and we continue to rely on clear communication to achieve our shared goals, and our constant meetings and evaluations of specialized concerns really help us reduce errors and improve our outcomes. From the front lines, I have learned that different units have their different specialized needs and challenges, and how you tackle them is to focus on what each needs requires. Therefore, I urge an unfavorable report on HB 624. Thank you.
Thank you very much for your testimony and for your good work. I'm going to open it up to the members. I have a question from Delegate White Holland.
Yes, thank you, Madam Chair, and thank you all so much for being here and for your testimony and the work that you do. For Andrew, my question wants to go back to, you mentioned state hospitals. And so isn't it true that state hospitals already have labor management committees in place due to collective bargaining agreements? Is that true?
I have no idea. But I do know that the reasons cited by the state for why they should be exempt was not because they have labor management agreements already in place. Many of our hospitals, some of our hospitals have labor management agreements in place as well. So again, that would apply. If that was the exception, that should apply equally, but the reasons cited by the department for why they should be exempted are because of the exact same regulations that govern our hospitals.
Okay. No foul.
All right, thank you very much. Seeing no further questions, sorry, Delegate Hutchinson.
Thank you, Madam Chair. Andrew, I just need you to go back to the past 2 years, I think you said the first year, state hospitals were exempt. I need to hear that again, and I don't understand why we're exempting them and what that was all about.
So I'm not sure, I know in 2024, they were included in the bill. They were not exempted. And then since then, in the course of that year and then every year since, they have been exempted. And the point I'm simply trying to make is that the reasons that MDH cited for justifying state hospital exemption is that they are governed by Joint Commission and CMS regulations, and those exact same regulations govern our hospitals as well.
So there's no difference, state hospital or whether
Correct.
it's a nonprofit hospital, member of MHA?
Absolutely, correct.
Thank you.
Thank you.
All right, seeing no further questions, that ends the testimony for this panel. We have one more favorable panel.
Thank you, Madam Chair.
Thank you very much. So if I can bring up Jada Norford, Robin Elliott, Peyton McDonald, Gregory Palmerton, and Rachel Crockett. And when you're ready, you can begin your testimony.
All right, y'all, I can start. Good evening, Chair Bagnall, Vice Chair Collison, and members of the House Health Committee. My name is Jada Norford, and I'm a registered nurse in the state of Maryland for the past 5 years. And while working as a nurse in this state, I urge you for the position of both nurses and patients we serve to have a favorable report of HB 624, the Safe Staffing Act of 2026. In my work, I provided patient care in a myriad of settings, from medical, surgical settings to post-anesthesia care. And this experience has provided me with an understanding of safe and causally efficacious staffing for unit success across the care continuum. Providing competent care throughout the hospital has always been dependent on adequate nurse staffing, regardless of the level of care. Staffing shortages significantly impacted the amount of critical unit functions nurses could perform to benefit their practice and their patients. Currently, 1 in 4 nursing vacancies are open in the state of Maryland. This significant vacancy rate denotes how much extra is placed on each nursing position to account for the care that must be done, regardless of the 25% vacancy. I have felt this strain in each department I have worked in as patient assignments have increased in nursing labor, while many nurses also struggle to balance necessary unit initiatives and increase in patient care needs. The moral and physical weight is physically palpable every day in our practice. The American Nursing Association notes that for each additional patient added to a nurse's workload, the 30-day mortality risk increases by 16%. Staffing shortages have increased demand on caregivers and increased patient care needs per nurse. HB 624 would provide a means to promote safe and consistent staffing levels through a clinical staffing committee between management and hospital employees. Staffing requirements derive from multifaceted care metrics such as patient acuity, nurse experience, and unit layout promoted by the American Nurses Association and Critical Care Nurses Association can allow for better and more consistent patient safety and nurse retention. Consistent communication from nurses working at the patient care level and management via committees will allow for more consistent understanding of staffing needs. And in creating these committees, we can allow for providing consistent, transparent, and nurse-driven staffing. And for these reasons, I again call on the committee to issue a favorable report of HB 624. Thank you for your time.
Good evening, everyone. My name is Rachel Crockett. I am a registered nurse in the state of Maryland. I ask for a favorable report to House Bill 624, Safe Staffing Act of 2026. I have worked in an ICU in Maryland for almost 7 years. I am not a nurse leader. I am simply a staff nurse who is occasionally charge nurse. I have been charge nurse leading my staff through emergencies that end up saving lives, and I have been alone at the bedside holding someone's hand as they passed away. I've worked shifts with a fully staffed, well-experienced team by my side, as well as with a skeleton crew during the darkest days of the COVID-19 pandemic. Every shift I work in the ICU, staffing plays a huge role in my ability to provide care for patients, safe care specifically. A specific example would be, I give a lot of medications that are very dangerous, such as various forms of adrenaline, chemotherapy, and sedation. Every shift, I take time to monitor my patients' potential side effects, looking at clinical references. I ask other nurses to verify weight-based doses. When we have minimal staffing, this process is rushed, leading to risk for our patients of medication errors and injury. When administration dictates how many nurses should staff a unit on a given day, it's based on numbers and costs. It's not based on the nurse's experiences or input. Whether that applies to every hospital based on the various statements from other people in this room, that does not apply to every hospital. Not every nurse in every hospital in Maryland has the same opportunities. House Bill 624 can help nurses have a say when it comes to staffing. Nurses have the experience to know exactly what we need. Our motivation is simple. We just want to keep patients safe. Any opposition to this bill demonstrates the troubling thought, who would want to ignore us when we just want to keep our patients safe?
Good evening, Robin Elliott. I'm here on behalf of the American College of Nurse Midwives. We are at Me Too, and also just want to let you know that Peyton McDonald had to leave. So thank you so much. Peyton McDonald, I think she was called on the panel.
Good evening, Chair Bagnall, Vice Chair Carlson, members of the House Health Committee. My name is Greg Palmerton. I'm a staff nurse at a large university teaching hospital in the state of Maryland. I've held my professional license and worked in the acute care setting for 8 years now, and for both my coworkers and patients we serve, I ask for a favorable report to House Bill 624. So I had written testimony prepared. I want to tell you guys all about the cool stuff I get to do day in, day out, talking about the patients we see in a cardiac ICU, how these patients require life-saving and heroic measures. We're titrating medications that you have minutes, just minutes where your patient's pressures could tank. These machines are keeping our patients alive, literally keeping their cardiac output and cardiac functioning going. But I decided to change up a little bit of what I wanted to speak about, because today we're hearing a lot of things, and why this bill is so important. We're hearing things about innovation and flexibility, experience. The reality of healthcare now is experience is gone. Nursing, as far as nursing goes, experience is leaving. You can look at the data, the meta-analysis, but nurses, there's an exodus, and the projections for staffing shortages are terrible. And this is not disputable, information. So when we talk about innovation, flexibility, the importance of this bill is it solidifies and ensures that we don't have to put innovation and flexibility on 1 to 2 year nurses who are taking on the roles of charge and needing to lead these units and work with management and admin to come up with safe staffing assignments. It's just not realistic. These are nurses who are just learning the trade, the profession, and the last thing they need to be focusing on is to be flexible. All the credit due to nurses who have been in the profession for 20 to 30 years and have that experience, can handle these assignments and know where to place these patients with what nurse. But the reality is that this doesn't exist anymore. It will not exist in the next 10 to 20 years. If we don't enact something, if we don't have standardized measures to make sure hospital administration and staff coordinate and make coalitions to ensure safe staffing, the standard and precedent will be terrible. That's all I have to say. I hope that we can, the committee can issue a favorable report for House Bill 624, and thank you for your time.
Thank you for your testimony tonight. Are there any questions from the members for this panel? Seeing none, I just want to thank you and also say that Mr. Palmerton, you make this sound like something we want to do, like a ride-along, when your description of the cardiac unit is just really incredible. Thank you so much. This concludes this hearing on House Bill 624. We are now going to go to House Bill 679. This is Health Occupations Cross-Sex Hormone Therapy for Minors. Delegate Ericon, if you want to come to the table and bring your panel, and you can get started when you're ready. And I do see that you have 4 virtual witnesses on your sponsor panel. Is that correct?
I'm so sorry, I can't hear you. It's too noisy.
That's all right. I see that you have 4 virtual witnesses on your sponsor panel as well. Is that correct?
We have some virtual witnesses and some in-person folks as well.
Perfect.
Yeah.
So we'll bring up your virtual witnesses as part of this panel.
That would be awesome. Thank you.
You can start
so
whenever
much.
you're ready.
All right. Yeah, anybody here in person is, yeah, wherever you choose to sit works for me. Okay. Thank you so much. Madam Chair, I'll get started if you're ready. Awesome. Okay. First, congratulations. Excited to be in the new HGO with our new Madam Chair and Madam Vice Chair and my friends of the Health Committee. Glad you were able to get rid of that very, very, very extra stuff that was keeping you here late at night like the judiciary. Although here you are again. So, for the record, Delegate Lauren Arkin, Harford County, here for HB 679. I am going to share with you a couple of thoughts, and then I will let my panel of experts speak after that. Quote, allow children to transition or they will kill themselves. For more than a decade, this has been the strongest argument in favor of youth gender medicine, a scenario so awful that it stifled any doubts or questions about puberty blockers or cross-sex hormones. Quote, we often ask parents, would you rather have a dead son or a live daughter, says Joanna Olson Kennedy of Children's Hospital of Los Angeles in an explanation to ABC News. There's a huge problem with this emotive formulation. It isn't true. When Justice Samuel Alito challenged the ACLU lawyer Chase Strangio on such claims during oral arguments, Strangio made a startling admission. He conceded that there is no evidence to support the idea that medical transition reduces adolescent suicide rates. Quote, there is no evidence in these studies that this treatment reduces completed suicide, he said. After England restricted the use of puberty blockers in 2020, the government asked an expert psychologist, Lois Appleby, to investigate whether the suicide rate for patients at the country's youth gender clinic rose dramatically as a result. It did not. He did not find any increase in suicides at all. WPATH has known for some time that the evidence base for adolescent transition is thin. Quote, all of us are painfully aware that there are many gaps in research to back up our recommendations, said Eli Coleman, the psychologist who chaired the team revising their standards of care in 2023. Despite concerted efforts to suppress evidence, however, the picture on youth gender medicine has become clear over the past decade. It's no humiliation to update our beliefs as a result. Quote, I regularly used to write medical transition was life-saving before I saw how limited the evidence on suicide was. And it took another court case brought by the British detransitioner Keira Bell for me to realize fully that puberty blockers were not what they were sold to us as, a, quote, safe and reversible treatment that gave patients, quote, time to think, but instead a one-way ticket to full transition with physical changes that cannot be undone. Those, body, are not my words. These are the words of Helen Lewis in an Atlantic article, not a conservative bastion of thought. I want to share with you some of the changes that has been happening in the last few months or weeks. On February the 3rd, some of you may have heard that the American Society of Plastic Surgeons recommended that surgeons delay gender-related breast, chest, genital, and facial surgeries until a patient is at least 19 years old. Quickly following that, the American Medical Association also echoed the concerns of the American Society of Plastic Surgeons. And their comments were, quote, available evidence suggests that a substantial portion of children with pre-pubertal onset gender dysphoria experience resolution or significant reduction of distress by the time they reach adulthood, absent medical or surgical interventions. And finally, I want to bring to your attention that lawsuits are just starting to come out. In New York State, Fox Varian detransitioner was just awarded $2 million in damages for what happened to her at the hands of bad medicine. I know that this is an emotional issue for folks, and I believe that both sides have a very emotional investment in the positive outcomes for these children. I don't for a second think that the folks that have been originally pushing this did not think this was in the best interest of children. But the data comes out more and more every year, and I'm going to come back more and more each year with the new data and the new medical opinions. the tide is in fact turning, just as the latest Atlantic article said, on this type of treatment for children. And eventually, I am absolutely confident it will not be the standard medical care. And folks who are on the wrong side of this are going to feel some deep regret that they didn't act sooner to protect these children in a really vulnerable time in their lives. So with that, Madam Chair, I will pass it along to my panel. Jamie is already off mute. Let's have Jamie go.
Good evening. My name is Jamie Reed, and I am a clinical researcher, a lesbian, a lifelong Democrat, and the co-executive director of the LGB Courage Coalition. I am also a whistleblower from within the pediatric gender medicine industry. I worked inside a pediatric gender clinic for nearly 5 years. First, I want to say how impressed I am by this committee. I listened to the testimony throughout this day, and I heard thoughtful questions. I believe that we are all prepared to sincerely consider the medical evidence tonight above politics. We support a favorable report on HB 0679 because children deserve care grounded in evidence, caution, and long-term medical protection, not irreversible treatments based on uncertain science. Every area of pediatric medicine follows a simple ethical principle. When the evidence is weak and the risks are high, it is imperative that we slow down. Yet with youth gender medicine, that standard was set aside, and puberty blockers, cross-sex hormones, and surgeries, which carry permanent consequences, including infertility, the loss of sexual function, and lifelong medicalization, were pushed, including in states like yours. Many countries at the forefront of these treatments, including Sweden, Finland, and the United Kingdom, have now restricted them, citing the lack of reliable evidence and the potential for harm. It is time to ensure that vulnerable young people receive psychological support and time to mature rather than being placed on a medical pathway they may not fully understand. I want to quote Ross Douthat from the New York Times this evening. Of course, this is also a theory of conflict avoidance, shading into cowardice. So to end more straightforwardly, I will make a prediction. Within not too short of a span of time, not only conservatives, but most liberals will recognize that we have been running a national experiment on trans-identifying youth without good or certain evidence, inspired by ideological motives rather than scientific rigor, in a way that future generations will regard as one of the gravest medical political scandals of our time. Which means that if you are a liberal who believe as much already, but don't feel comfortable saying it, your silence will soon become your regret. Our responsibility today is to protect children, follow the evidence, and act with honesty. I beg you as a Democrat, and I respectfully urge this committee to issue a favorable report.
Thank you for your testimony.
Thank you.
Who would you want to do the
and then
virtual
just go
first?
to the,
Okay.
that makes the most sense,
All
I
right.
think.
How about Prisha Mosley? Can you unmute and begin your testimony?
Hi, thank you for having me. My name is Prisha Mosley. I was born in the state of Maryland at Johns Hopkins University. When I was a teenager, like many young people who identify as trans, I was depressed, had low self-esteem, and was dealing with trauma. I needed help with my struggles and time to grow into myself when doctors affirmed my delusions that I was really a boy trapped in a girl's body. They fed me pseudoscience and fantastical promises that I didn't understand were just advertisements. They referred to the amputation of both of my healthy breasts as top surgery, a euphemism meant to market the surgery to a suicidal teenager who needed ethical care. I was given no warning of the way it feels to have scar tissue across your chest or nerve damage, or that I would be facing complications in the future. They called it hormone replacement therapy when they destroyed my endocrine system with high doses of anabolic steroids. They told me that I could change sex, not that I was simply being drugged up and rearranged. I was still a teenager when it began, and it took me years to untangle the lies and come to terms with the betrayal that I was put through. I am suffering lifelong medical damage as a result of falling for the lies of medical professionals I should have been able to trust. My body cannot regulate my hormones on its own anymore, making me dependent on the pharmacy for prescriptions for the rest of my life. I have insulin resistance, an enlarged liver, hair loss, chronic pain, and more as a result of testosterone use, none of which my doctors warned me about. Testosterone use greatly impacted my behavior and mood, worsening my delusional state and causing my self-harming episodes to become much worse and more dangerous. I continue to suffer with side effects even years after stopping the hormones, including things that impact my daily living like pelvic and vaginal atrophy and urinary issues. My chest is scarred and numb and also in pain. I have nerve damage and scar tissue where my healthy breasts used to be. Nothing was wrong with them when they were cut off. My double mastectomy led to severe complications after I gave birth, which my doctors did not warn me were possible. Breast tissue was left behind by my surgeon, but my nipples were grafted and have no remaining function, which led to milk being trapped inside my chest. I urge lawmakers to protect children from the medical fraud and malpractice that happened to me when I needed help. Identifying as trans does not give anyone's doctor the right to experiment on them. Everyone deserves ethical and evidence-based care. My body tells the truth. Thank you.
Thank you for your testimony, and thank you for sharing your very personal story. Claire Abernathy.
Hello, thank you for the opportunity to speak today. My name is Claire Abernathy. I'm an IWF ambassador and a resident of Allegheny County, Maryland. I'm also a detransitioner. I began identifying as transgender at 12 years old following a traumatic sexual assault and a years-long battle with anorexia. My parents were hesitant and did not socially affirm me for the first year of my trans identification. In September of 2018, when I was 13 years old, they took me to a therapist who specialized in gender identity issues in children. This therapist ignored my history of sexual abuse and anorexia and gave me a diagnosis of gender dysphoria in the first appointment I had with her. She told my mother that I was a textbook case of pediatric gender dysphoria, that things like trauma and mental illness do not make children believe that they are trans, and despite me never having been suicidal prior to medicalized gender transition, presented her with biased and since falsified statistics about suicide among trans-identified children, and asked her if she would rather have a dead daughter or a transgender son. In November of 2018, 2 months after first seeing this therapist and a week after my 14th birthday, I was put on testosterone. I'd like to stress this point. If you take anything from my testimony, let it be this. None of this was against the standards of care my providers were operating under, and it would not be against the current clinical guidelines. I was diagnosed and treated under WPATH Standards of Care 7, which provide no minimum age recommendation or duration of therapy that a patient must undergo before the prescription of cross-sex hormones is clinically indicated. WPATH has repeatedly opted to loosen their clinical guidelines despite growing evidence of harm, and most recently removed all minimum age recommendations for all medical interventions, including genital surgeries. These recommendations are treated as the go-to standards by which children who are distressed by their sex like I was are treated, despite WPATH themselves not considering them to be actual standards of care, according to its president-elect in his testimony in the recent Varian v. Einhorn case. I stress this point to emphasize the fact that nobody is flying the plane. These doctors are looking to WPATH standards for guidance, and WPATH does not even consider them to be valid standards of care. This is not how responsible evidence-based medicine works. You have the opportunity to side with science, reason, and what is objectively morally right. Children cannot consent to the chemical disfigurement of their genitals. They cannot comprehend the lifelong implications of being incontinent and sterile.
Please wrap up your testimony.
Maryland's children deserve better than to be used as guinea pigs. Listen to my voice. It hurts me to speak. I'll never have my voice back, and I'll never be able to speak without pain. I'm real. I'm not a statistic or a political talking point. I'm a real woman suffering a dire fate you have the opportunity to spare other children from. I urge you to take it and pass HB 769. Thank you.
Thank you for your testimony, and thank you again for sharing your very personal story. Simon Amaya Price.
Good evening, committee. Thank you for letting me speak in favor of Bill HB 679. My name is Simon Amaya Price, and when I was 14 years old, I told my therapist that I was really a girl inside. She immediately affirmed me, telling me that I was brave, and gave me a list of ways to get access to cross-sex hormones, including encouraging me to go behind my parents' backs to a transgender support group. This was after years of bullying, being sexually assaulted by a man, and being taught about the gender unicorn in sex ed instead of learning about my own reproductive system. I joined what was then called the Gay Straight Alliance, looking for support coming to terms with the homophobic bullying I had received in middle school. But I was instead met with videos by transgender YouTubers who told me that the discomfort I felt was evidence that, despite my male sex, I was truly a girl in the inside. I still remember how However, on my 15th birthday, my pediatrician asked my father, while I was in the room, would you like a dead son or a living daughter? This is emotional manipulation and malpractice in itself. And I'm not just saying that. This specific line was found to be malpractice in the recent Varian versus Einhorn case in New York. Again, we're hearing about this for the third time, I think, from me. It was awarded $2 million in damages, which is almost double the typical maximum malpractice damages in New York. In no other situation is it permitted for a doctor to use a child's life as a bargaining chip to push an ideology. My friend Elle Palmer, a detransitioner, was able to get testosterone as a minor from Planned Parenthood without even talking to a doctor. They ignored her history of sexual abuse, self-harm, and crippling anxiety. Her parents were only in the room to sign the paperwork at the end. This is not an isolated case. A 2025 investigation by Live Action found that at least 7 Planned Parenthood locations across the country were willing to prescribe hormones to a 16-year-old girl on the first visit. Many didn't even require going in person or talking to a doctor. There is no objective way to diagnose gender dysphoria. There is no blood test or brain scan. I was diagnosed with gender dysphoria at 14 just because I said I had it. That's enough to be prescribed cross-sex hormones, which would have likely, as a wealth of peer-reviewed studies have found, sterilized me, increased my risk of a heart attack, given
Can
me
you please wrap up your
osteoporosis, and
testimony?
increased my risk of testicular cancer, the same amount that smoking 1 pack of cigarettes per day increases the risk of lung cancer. I would have been sent down a pseudo-medical pathway, which would have led to irreversible surgeries that too many of my friends have been
Can you
permanently
finish your
scarred
thought and wrap up your testimony, please?
Absolutely. While I hated him for it at the time, my dad did not affirm my transgender identity due to a combination of his persistence and a good heaping of luck. I'm one of the lucky ones. I'm the best case scenario for a kid who got stuck in transgender ideology. I urge you to pass this bill and protect the kids who are less lucky than I was. I'm happy to answer any and all questions. Thank you very much.
Thank you for your testimony, and I'm going to ask all of our virtual witnesses to stay with us till we finish this panel for any questions. And thank you for being here tonight. I know it's late, and these are very personal. We'll let Dr. Kelly start, and then we'll just roll through.
Good evening. I'm Dr. James Kelly. I'm a Maryland physician and a board-certified adult, child, and adolescent psychiatrist. I'm representing the Nationwide Association of American Physicians and Surgeons in support of House Bill 679. 9 out of 10 gender-confused kids will recover from gender confusion naturally with no treatment at all. There is no FDA-approved drugs or surgery for gender-confused kids. Cross-sex hormones cause problems with the fertility, mind, depression in the bones, blood pressure, endocrine system, cardiovascular system, blood clots, embolisms, heart attacks, strokes, and death. Cross-sex hormones cause sterility and chemical castration. So this is why they are used in 9 states on convicted sex predators, not in Maryland. Maryland protects sex predators from cross-sex hormones and doesn't permit them to have them. But we do not protect our children from cross-sex hormones. Research is showing the truth. Many are reversing courses. The AMA, the American Society of Plastic Surgeons, do not recommend surgery. The UK, Sweden, Finland, Denmark, Norway were the most liberal in prescribing cross-sex hormones and puberty blockers. They've reversed course. They do not recommend it and they restrict it. 27 states now protect children and restrict the use of cross-sex hormones. Maryland should be the next state. Please protect children and return a favorable report. Thank you. I'm happy to answer any questions.
Good afternoon, Madam Chair, or good evening, and delegates. My name is Deborah Bricado. I'm a retired nurse and mother of 4. I am strongly in favor of House Bill 679. Everyone is born with primary sex characteristics and sex chromosomes. Having a Y chromosome means that you are a male. No Y chromosome means you're female. Gender-altering care involves puberty blockers, then cross hormones and surgery. Puberty blockers stop the natural, healthy development of children into adults. Once puberty is blocked, all or most of that process is irreversible. Cross hormones make girls more masculine and boys more feminine in appearance. Surgeries permanently alter the body. Drugs and surgeries are a lifelong dependency to maintain the appearance of the opposite sex. Fertility is destroyed. A normal sex life is destroyed. No one can actually change their sex. These drugs fight the body's natural operation and only mimic the opposite sex. Complications include depression and psychosis, decreased cancer or increased cancer risk, cardiovascular disease, and death. Detransitioners are revealing the devastating realities of complications and irreversible damage to their bodies. One of those detransitioners, as Lauren has mentioned, Delegate Erickson, has won a $2 million verdict. Chloe Cole is now also taking Kaiser to court for the damage that was done to her body. The medical community is shifting away from providing these gender-destroying drugs and surgeries to minors, saying the permanent changes and serious health risks outweigh the unproven possible benefits. Children must not be able to consent to this, and parents must be prohibited from harming their children and preventing them from natural, healthy development. This will go down in history as one of the worst medical scandals of all time. Children deserve therapy that discovers why they are uncomfortable with their bodies and a plan to help them love their biological reality. I urge you to give a favorable report on House Bill 679 and protect our children.
Chair Bagnall and members of the committee, my name is Ismail Royer, and I am Director of Islam and Religious Freedom at the Religious Freedom Institute, a Washington, D.C. nonprofit that is committed to achieving broad acceptance of religious liberty as a fundamental human right. As RFI's Director of Islam and Religious Freedom, I explore religious freedom and Islamic tradition and also provide a Muslim perspective on issues bearing on religion and public life. I respectfully submit this testimony in favor of HB 679, and although I am speaking from a Muslim perspective, I'm appealing to universal principles and empirical reality. We find that this bill rejects harmful ideology and embraces truth and reason. Specifically, we find that this bill is grounded in the truth that it is the duty of the physician to heal and not harm the patient. The Prophet Muhammad said, "Let there be no harm nor returning of harm." This is the most fundamental legal principle of Islam, and in this vein, the 9th century Arab physician Ishaq al-Ruhawi wrote in a commentary on Hippocrates, "And 2 things are incumbent upon you, physician. The first is to benefit the patient, and the second is not to harm him." And the second premise that we find that this legislation is grounded in is that medical intervention to disrupt puberty in healthy children is harmful. An individual human being's sex is a created and thus inherent trait. It's self-evidently not a disease. So when physicians prescribe drugs that interrupt the natural process of sexual maturity, they do not heal patients, they harm them, as we heard this evening. And finally, the mental health benefits of such procedures are, again, as we've heard, far from empirically certain. And even if such benefits could be demonstrated, the destruction of a child's healthy body can never rightly serve as the treatment for a disorder that is psychological in its nature and origin. And for these reasons, we urge a favorable report on this bill. Thank you.
Thank you all very much for your testimony tonight. I'm going to open it up to our committee for questions. Delegate Morgan.
Thank you, Madam Chair. I want to thank you for the bill and your witness panels. Very moving testimony. I've served on this committee for 12 years, and we've had experts come in here before that tell us that when person transitions, no one ever detransition, and your panel proved that that was wrong. The doctor said there was 27 states that have banned this. I looked it up real quick. It's between 20 to 25, I guess, depending on court challenges. But more interesting, European countries have banned this for minors. United Kingdom, Sweden, Finland, Norway, Denmark, all the Nordic countries. Is Maryland the question is for the delegate, is Maryland really an outlier on this policy right now? And two, can you give a little bit more information on the W path?
Sure. I'll probably toss the WPATH question to Jamie because she's an expert on that. But I'll just say, on the issue of are we an outlier, I think we definitely will be very soon. I think the more that folks are able to look at this and remove the emotional lens that we've been looking at it at, the more states are going to start changing policies, and the more countries internationally are going to continue to change the policies because the risks outweigh the benefits, and I think that will continue to be bared out in the research. So for your second question, Jamie is definitely an expert on WPATH.
Thank you. If I can, Representative Morgan.
Yeah, best follow. Yeah, if you could provide some information before that. I wasn't familiar with that term.
Absolutely,
WPATH.
and I do want to apologize, being an expert sitting in the children's room. It is evening here, and I'm a mom of 5 kids, so I had to hide out for a minute. The World Professional Association of Transgender Health is what WPATH stands for. It is an activist organization that began around 1979. What we know is that they put out a document called the Standard of Care. That document was just discussed under oath in the detransitioner lawsuit in upstate New York, where the incoming president of WPATH stated, and I quote, "This is not to be used as a standard of care." This is a document that was created by a group of activists, people who often are trans-identified themselves, and it is not based on evidence, but it's rather based on a consensus process called the Delphi process, where essentially that they keep whittling down until they get to a point that all of the activists in the room will agree upon. What we've learned in the last 3 to 5 years is that this document, which has been used by every single hospital in your state to provide this care to children, was not only not based on evidence, but they paid for an evidence-based review to Johns Hopkins. You should be very well aware of Johns Hopkins. They requested and paid for evidence-based studies to prove whether or not these interventions help or harm children. When they started to get the results back, they went back to their contract and began quickly to change the outcome of those studies. Johns Hopkins said, "We will do this study for you, understanding that any results we come up with must be published." That is how true rigor works in science. When the results started to come in, WPATH rescinded that agreement and forced Johns Hopkins to no longer publish any of the systematic reviews of evidence that they had commissioned from Johns Hopkins. So you right now have hospitals and doctors' offices within your state providing a care model to children that was based on fraudulent evidence that will no longer hold up in court. We will see detransitioner lawsuit after detransitioner lawsuit come forward. You are going to have in your state children, child after child, family after family sue because there is no longer any set consensus of a standard of care for these interventions. We are right now witnessing the complete international collapse of consensus around this treatment model, and therefore it must not continue for any further child within this state.
Delegate Shalega.
Thank you, Madam Chair. This question would be for either Prisha or Claire. if you could give us a little bit, and I guess one of you, because our rule is one question, one answer. So give us a little more information about your health care. And maybe it would be Prisha, because I think you said you had received some pretty intense treatment to, transgender treatments. If you could tell us how your recovery is going, or, what your future looks like.
Hi, thank you for asking me the question. So, very luckily for me, I'm working with an ethical practitioner. And the truth is, I'm being experimented on again, because what happened to me originally was an experiment. The data hasn't been fully collected, and it's ongoing. So this doctor that I'm seeing now is continuing the experiment, but with the goal this time of healing my health and bringing it into balance rather than making cosmetic alterations to my appearance to make me feel better mentally. So I am taking hormones. I have high androgens, not just high testosterone, but like all of my androgen, when I get my blood done, they're all high. I have to be on progesterone and estrogen supplementally because mine is low. I suffered with infertility for years, but I was, thankfully, I wasn't on puberty blockers, and I was able to conceive after being treated for the infertility, but I was not able to deliver naturally. I had to have a C-section because the testosterone caused, during puberty, caused my hips to not fully finish developing. I'm trying to manage chronic pain and chronic fatigue. I have really bad insulin resistance. So my doctor, as far as this experiment, is basically just treating me like a woman who has really bad PCOS, because that's basically what the testosterone does. I have cysts on my ovaries, which causes other types of hormonal imbalance, like the insulin resistance, and it affects my liver and so on and so forth. So we're basically just trying to deal with the effects of a body that was overloaded with the wrong hormones. And that's what we're doing at this time.
Thank you.
Thank you very much. Seeing no further questions, I just want to say thank you to all the witnesses tonight. I know this is, this is very challenging, and to all of our witnesses, we hope you are well and healthy, and to be balanced, because we do have a number of unfavorables as well. We're going to go to an unfavorable panel, and then we've got a favorable virtual panel. So let me go to Charlotte Hoffman, Dr. Helene Hedian, Harley Walker, and do I have Zhang Sun Brown or Zosia Zaks? And you can get started when you're ready.
Thank you, Chair, Vice Chair, members of the committee. Charlotte Persephone Hoffman, again, third time for the day. Again, on behalf of Trans Maryland. I want to start by noting that a lot of the testimony we heard just now talked repeatedly about surgical interventions. This bill does not have any language about surgery in it. It is only about cross-sex hormones and puberty blockers. So all of the testimony we heard about whether surgery is appropriate for minors, whether it's something that we should be worried about in this state, it is irrelevant to this bill. In addition, what we have seen over the past 2 years under the second Trump administration is extended attacks on the access to healthcare for transgender minors, specifically around surgery, but also much more generally. So we have seen every provider of transition-related care for minors either say we are no longer providing this care, or look to find ways that they can do it without potentially accepting Medicaid funding. There is currently, or actually as of yesterday, the public comment on a rule closed that would have prohibited any hospital that provides any sort of transition-related care for minors to receive a single cent of Medicare or Medicaid funding. This is an attack on our community, and I ask you to please understand that when we say that there is evidence that supports us, that we are not lying. I understand my time is up, but I am happy to answer any questions that you have. Thank you.
Good morning, or good evening, sorry. My name is Harley Walker. I am a current freshman at the University of Maryland College Park, but I am originally from Alabama. I'm here today to tell you all a success story with affirming care. Around 11 years old, I came out to my parents as transgender. No one forced me to choose this because being transgender is not a choice, it is simply who I am. I wanted to come to clear up some misinformation spread about the care that trans youth receive. Proponents of this legislation claim these doctors pressure or rush you and immediately start filling you full of hormones, puberty blockers, and performing surgeries, and that is simply not the case. When I first met with gender-affirming care specialists, they spent time getting to know me, understanding my specific case, and how to best care for me as a patient. They wouldn't even begin to talk about hormones till several meetings after and until I was of age. HB 679 is being flaunted as protecting kids, but it is doing the exact opposite. I went through my teenage years in fear of losing access to gender-affirming healthcare, severely damaging my mental health and well-being. This treatment has been life-saving as it has enabled me to express myself in my fullest capacity and not be trapped in a prison of self-loathing that comes with being born in the wrong body. I would not be alive today if it were not for gender-affirming care. In my teenage years specifically. Trans people are often painted as miserable and mentally ill, but that could not be further from the truth. I am sitting here today as a very happy 18-year-old woman. I'm able to live my life and express myself authentically every single day, and I've been able to become pretty successful, speaking in front of the United States Senate and House, maintaining a 4.0 GPA and extracurricular commitments, and living my life as a young adult in its fullest capacity. None of that would have been possible without being afforded gender-affirming care as a teenager. It is your responsibility as legislators to ensure the pursuit of happiness and success for all of your constituents, including transgender youth. Let these kids be just like me and be able to live their life to the fullest, and I strongly urge you to oppose HB 679. The lives and well-being of thousands of kids are counting on it. Thank you for your time.
Good evening, although I think it is morning, and it is any time at which other people are awake. My name is Lee Sin-jen Chung Sun Brown. I'm a resident of Baltimore County. I am proudly and openly both autistic and transgender. And I'm here tonight to talk to you from my position of expertise as an attorney, as a public policy expert, as a college professor, as well as someone whose work for nearly 20 years has focused specifically on developmental disabilities. That is the area that I have come from. That is the community that I know the best. For informational purposes only, I am also a commissioner on the Maryland Commission on LGBTQIA Affairs, and I'm an appointee to the Department of Disabilities Advisory Stakeholder Group on Autism-Related Needs. Like many transgender people, I knew from a very young age, as young as 4 years old, that I did not fit into the category of girl, even though I was assigned female at birth. I was not a tomboy, I was not a jock, I was not some kind of reactionary who hated all things feminine or prissy or princessy or pink. I was just somebody who knew I was not a girl, that word felt wrong, just as I also knew that I was not a boy. I wanted to grow up and wear gorgeous ball gowns and dashing tuxedos, and I also wanted to avoid stereotypically feminine and masculine activities because I wanted to read books. That's all I wanted to do. In fact, one of my bullies once told me, "Your favorite color is book," which did not make sense as an insult, unless you were in 4th grade. I did not have access to gender-affirming care as a child. I wish that I did. Instead, I had to watch with horror as my body grew parts and gained functions that made me feel like a monstrous alien instead of myself. As an adult, I know who I am. I know what kind of body I want to live in. And I have faced barriers to accessing care, despite having a graduate degree, working as a policy expert, and being an advocate for many years. I have faced barriers that required me to consult with 2 different mental health professionals for an extended evaluation before I could be approved for that care. I know that being autistic in no way whatsoever undermines my ability to understand my body or my identity. I urge you to give an unfavorable report on this bill.
Thank you for your testimony. Dr. Hedian.
Thank you for allowing me to speak in opposition to House Bill 679. My name is Dr. Hedian. I'm an internal medicine physician who provides primary care in the Baltimore area. I completed my medical school and training in Maryland, and I have been in practice for over a decade, and the views I'm sharing here today are my own. I provide gender-affirming care, including hormone prescribing, and in doing so, I have met and cared for hundreds of transgender people. I have many concerns about this bill. First, this bill, which proposes to criminalize the prescription of gender-affirming hormone therapy to minors, is attempting to block a theoretical threat. But in doing so, it will cause real harm. Patients who have already been through a comprehensive diagnostic evaluation, been deemed appropriate for treatment, and perhaps been stable on their medications would have to be taken off. What is the transition plan for these patients? What supports would be offered to these patients and their families whose lives and medical care have been completely upended by this decision? Second, and this is perhaps a smaller concern, but the term minors is not defined in the bill. I am assuming that it refers to people under the age of 18, but threats to care across the country have recently seen a more flexible definition of the word minor, and it seems at least possible that such legislation could later be modified and leveraged to remove the ability of consenting adults to access medically necessary care. Third, it should concern everyone in this room that this is an attempt to legislate the scope of medical care. Please let doctors practice medicine. Let us assess and evaluate the patient in front of us and develop a treatment plan that is right for them as an individual. I would like to believe that this bill comes from a place of honest concern, but to pass such a sweeping ban is reckless. I invite the bill sponsors to listen and take in the testimony which is offered today. I offer myself as a resource. I would be happy to discuss this subject and answer any of your questions which I'm able to. And most importantly, I urge the committee to issue an unfavorable report on House Bill 679. Thank you for your time.
Thank you for your testimony. Are there any questions for this panel from our members? Vice Chair Cullison.
Thank you, Madam Chair. Dr. Hedian?
Hedian, yes.
Hedian, thank you. Can you tell me what's the rate, or do you have a concept of what the rate of detransitioning is? Because we know that it does happen. But do you have a rate, a concept of that?
I do. It's 1%.
1%, yeah, that's what I thought. And so we heard from 3 individuals, if you had been hearing, that there were clearly struggles with what happened to them. What could you attribute their struggles with? Do you have a sense of that, or an opinion in terms of, clearly it was not right for them?
Yeah, my heart goes out to them, and I really hope that they get the care that they need and that is most beneficial for them. I think, unfortunately, that focusing on regret and using that, or detransition, the rates of which are incredibly low, focusing on that and using that as justification is not consistent with the rest of the practice of medicine. An unrelated example, knee replacement surgeries, there's a regret rate of about 20%. And yet the General Assembly does not have a bill before it to outlaw knee surgeries, right? This is a complex issue, and again, my heart goes out to the people who shared their stories, and I'm grateful that they did, and I hope they get the help they need.
Thank you very much.
Thank you. Oh, Delegate Morgan.
Madam Chair, my question is for Dr. Hedian. How are you? You've testified in front of this committee. I'm sorry, I missed that. Say what?
I think I sent everybody the wrong way. It's Hedian.
You've testified in front of this committee numerous times. I remember from years past. One time in your testimony, you said that you actually prescribed hormone blockers, I guess puberty blockers, for kids as young as like 9. Is there any type of repercussions to these puberty blockers for young children to take them, and then if a person chose to detransition?
So I'd like
What's the long-term effects?
Yeah, I'd like to correct one misunderstanding.
Okay.
I do not care. I care. I'm an internal medicine physician, so I prescribe and take care of patients who are 18 and up according to my licensure.
Okay.
But I am familiar with puberty blockers and can answer that question for you.
Okay. I appreciate that. Thank you for correcting the record, too.
Puberty blockers are reversible. So we use them as a way to sort of put the brakes or put the pause on a body's own puberty to allow a trans teen or somebody who's exploring their gender to have time to meet with mental health therapists, to meet with their doctors, to talk with their parents and their family, and really come to a better understanding of who they are and what they want. If after a period of time they stop the blockers, the body's own puberty reasserts itself. There are no permanent long-term health effects from puberty blockers alone.
Okay. So, I mean, we just had follow-up. I'm sorry. Thank you, Madam Chair. So we just had several people testify that they had issues with that. What would you say to them? I mean, is that just their imagination?
I would say my best interpretation of their experience is that they're attributing the effects of the cross-sex hormone therapy itself, which they took after puberty blockers. But puberty blockers themselves as an entity are completely reversible.
Okay. Well, thank you for your testimony. Thank you, Madam.
Thank you. Delegate Riley.
Thank you, Madam Chair. I guess it is for the doctor as well. I won't butcher your name like, because I'm sure I will. So anyway, so I'm assuming you've had your medical license for a while, so I'm not sure if the diagnosis of gender dysphoria was part of your studies, your medical studies, or certification or whatever. So could you tell me what you're using now or what you used to base the treatments that you're actually giving to the transgender population, and what was the medical science behind that program that you're now using to actually practice in this area?
Yeah, I think there's two pieces to this question. The diagnostic criteria for gender dysphoria are in the DSM, right? The Diagnostic and Statistical Manual, which is separate and distinct from WPATH. WPATH puts forth the international guidelines for the care of transgender people. There are also guidelines from the Endocrine Society, which tell us sort of dosing and medications and levels and safety monitoring, what to look for. And I'm sorry, there was a second part to your question. Could you repeat it, please?
Yeah, basically, so this wasn't around when you went to medical school, correct? Or fairly new?
No, I mean, gender affirming care
So it's
has
been, okay.
Yeah.
Okay,
for a
I
while.
stand corrected then. Yeah, you answered the other question of what science you're looking at. So you said you're not using the WPATH, but you're using endocrine, what'd you call it?
The Endocrine Society guidelines.
Endocrine
and
Society
WPATH.
guidelines, okay.
And
All right.
WPATH, yeah.
Thank you.
Of course. Delegate Shalega.
Thank you. Just a quick question for the doctor. Did you tell us that you don't treat children?
That's correct. According to my licensure, I treat patients 18 and up.
Okay. So this bill doesn't really affect your scope of practice because this bill is just about kids under 18. Is that right?
This bill is about minors, which isn't defined in the bill, but yes, to your point, yes.
Thank you.
I'm looking left and right, seeing no further questions. I just had one question for Charlotte, because I was looking at your written testimony, and I noticed that there's a lot of testimony that is anonymous.
Yes.
So can you speak to the anonymous testimony? It's different than it has been in years past, that anonymity.
Yeah, thank you for asking that question. And also, this goes a little bit to what Delegate Shalega was asking just a moment ago. Because of the situation that we're facing with the federal government at the moment, There are a lot of parents of trans kids who are absolutely terrified to come out and say, I have a trans kid, and they're scared that if they come here and they testify and they state that they are fighting for this care for their kids, that they are going to be investigated by the federal government, that they are going to have their children taken away from them. And we are also hearing the same thing from many of the providers who offer this care. They are terrified of coming in here because they are worried that if they were to testify, that the federal government would go after their medical licenses, would revoke their DEA clearance to prescribe medications, would attack their ability to receive reimbursements under Medicare or Medicaid, and would extend those attacks to the institutions that they work for. This has been happening on a national level, and we are seeing so many, I wish that I could tell providers and parents that they aren't being unreasonable when they express these fears to me. But unfortunately, this is the situation. So it is very rare that any of us are willing to step up and say, I actually have a trans kid, and I do. I have a trans kid. He is 15. When he moved out here from Indiana, one of the first things he asked me was, how are Maryland's laws on trans people? And I said, they're much better than Maryland. I said, they're much better than Indiana's. And I talked through all of it with them, and he's like, what about health care? And I'm not gonna get into the details of his health care because that's private. That's between myself as his parent, him as a patient, and his medical provider. But I did have the joy of telling him, you have one of the two people in this state who understands this issue more than anyone else as your parent. And he looked at me and he paused for a second and he said, who's the other one? And I said, Lee, my boss. And he was like, oh, cool, okay. But so many parents have talked to us about their fear, and they want to be here. They're texting me as we speak about, thanks for being there, thanks for speaking up for us. But they are terrified that if they were to say that in a public forum, that they would be doxxed, they would be investigated by the federal government. The FBI would say that they're terrorists because the FBI has now released guidance that says that trans activists should be investigated as terrorists. So it's a terrifying environment right now, and this bill is adding to that terror that we are feeling. So I think I've answered your question, and so I will let you go.
Thank you very much. And I see that we have spurred a question from Delegate Hill.
Thank you, Charlotte. And if you're not comfortable answering the question, please just say so. We heard a lot about the Varian case in New York and the verdict. And everything that I've read about it, including the plastic surgeons who commented and Dr. Schechter, who's the president of WPATH, have said this was really a malpractice case. It had nothing really to do with the gender affirming. The obligate work that needed to be done to determine was this a medically indicated procedure had not been done, and that was the basis of it. In fact, the quote, I think Dr. Schechter, there was allusion made to it, said the quote that I see is that the statement Dr. Schechter made was the case was a medical malpractice case, not a referendum on gender affirming care, when care is delivered ethically and responsibly within the guidelines, the WPATH guidelines, the integrity of the field is strengthened, and that he actually did not say that they're not guidelines. Is that your understanding?
That is my understanding.
Okay, thank you.
Thank you very much. Seeing no further questions from the members, thank you for your testimony. We do have another favorable panel. I believe this one is virtual. Can we bring up Alice Bullard and Jill Capper?
All right, Ms. Bullard, if you want to unmute and go ahead and begin your testimony.
Hi, can you hear me?
Yes, we can.
Hello. Thank you for having me. It was a surprise. I wasn't notified in advance that I was on the list.
Bullard, if you want to unmute and go ahead and begin your testimony. Ms. Bullard, can you go ahead and turn off your live stream? That's why you're getting that feedback loop.
Yeah. Hello. Thank you for having me. Okay, is that better?
That's perfect. Go ahead and start your testimony.
I'm sorry about that. Thank you, and good evening. My name is Alice Bullard. I'm a lawyer and a historian of medicine, and I'm a supporter of DIAG, which stands for Democrats for an Informed Approach to Gender. The Democratic Party has been lockstep on supporting gender-affirming care, which I will abbreviate as GAC, if I refer to it again, gender-affirming care, which normally includes affirmation only in the schools. Maryland teaches gender identity in its schools. Affirmation, social transition, puberty blockers, cross-sex hormones, and eventually surgeries. Now, I've submitted a written testimony, which I hope that you can all read. It gives many reasons to support HB 679. This is a political arena here now, and I'm happy to participate in this politics, but neither am I naive about how these politics will play out. Maryland is a deep blue state, and it has real heart and soul. The sad truth is that GAC, which Maryland currently endorses, has been discredited widely. WayPath has been discredited widely and repeatedly. Maryland writes WayPath into its law in the 2023 Trans Equity Bill. WayPath is designated as the standard of care in medicine in Maryland. But WayPath has been discredited. It's time for Maryland to move on. I'll conclude my testimony there with a strong recommendation to pursue 679 positively. Thank you.
Thank you for your testimony and for your patience. And if you can stay on till the end of this panel, if there are any questions. Ms. Capper, if you can unmute and begin your testimony.
Hi, yes, thank you. Good evening. My name is Jill Capper, and I'm a lifelong resident of Maryland. I'm testifying today to request your support for HB 679. Minors are not developmentally or legally capable of consenting to irreversible medical interventions such as cross-sex hormone therapy. The bill provides necessary safeguards to protect children from permanent harm. Cross-sex hormone therapy can have irreversible effects, including impacts on our fertility and long-term health. I still remember when my daughter wanted to be a cat when she was younger. Her nickname for an entire year was Cat-Thrin, while she crawled on the floor and looked silly. Instead of gathering litter boxes and taking her to be neutered, I supported her while insisting she'd grow out of it. We still laugh about it now, and she continues to tell the story. Adolescence is a period of rapid psychological and physical development. Parents should not be pressured into making permanent medical decisions for children experiencing mental health distress. Safeguarding children from irreversible medical interventions is a legitimate and appropriate role for the legislator. I support HB 679 because minors are not old enough to consent to irreversible medical interventions. What we want continues to change as we grow and get older. The detransitioning wave is here, and I believe we'll see it for years to come. These stories are sad and deserve to be highlighted. They are more likely to be censored so the abuse can easily continue. Medical treatments that permanently alter a child's body should not be administered based on mental health struggles during adolescence. Protecting children from long-term medical harm is an appropriate role for the state law. This bill provides a necessary safeguard while children mature into adulthood. As a parent in Baltimore County, I believe safeguard while children mature into adulthood. As a parent in Baltimore County, I believe children deserve protection from irreversible medical decisions they are likely to later regret. Thank you for your attention to this matter. And again, I ask for your support for HB 679.
Thank you for your testimony. Are there any questions from the members for this panel? Seeing none, thank you very much for your testimony this evening. We are going to turn to our next unfavorable panel. So if I can ask Jeremy Browning, do we have Zosia Zaks, Robin Elliott, and, oh, wait, I've lost my, and Lee Blinder.
I'll yield my time. Everyone has
Then do I have Elizabeth Pinolini? And thank you very much, Lee. That's very kind of you. And you can get started on your testimony when you're ready.
Good evening. My name is Jeremy Browning. I use he, him pronouns, and I'm the director of the Maryland Commission on LGBTQIA+ affairs. I'm here on behalf of the commission to strongly oppose House Bill 679, which is dangerous and an unnecessary attack on transgender youth and their families. This bill is not based on science, medicine, or the well-being of children. It's based on fear and misinformation. This bill contradicts the overwhelming consensus of major medical organizations, including the American Medical Association, the American Academy of Pediatrics, the American Psychiatric Association, the Endocrine Society, and many others, all of which recognizing gender-affirming care as safe, evidence-based, essential, and often life-saving care. And my written testimony has more information and citations on those. Denying transgender youth access to healthcare will not change who they are, but it will put their lives at risk. The data is clear. Restricting access to gender-affirming care increases depression, anxiety, and suicidality among transgender youth. This bill undermines parental rights and physician expertise, interfering with the ability of parents to make informed medical decisions for their children, despite research affirming that supportive families and access to gender-affirming care significantly improve long-term health outcomes. These are deeply personal medical decisions that should be made between a patient, their parents, and their doctors. For these reasons, the commission strongly urges an unfavorable report on this bill.
Good evening, Robin Elliott. I'm here tonight on behalf of the American College of Nurse Midwives in opposition to this bill. Just wanted to underscore that this bill creates a felony penalty with up to life imprisonment for providers that violate this. As we heard from a previous panel, providers are already afraid. Even the introduction of this bill creates confusion about what is legal and what is not. And with the provider community being afraid, we're really concerned that there will not be care for transgender youth or anybody else needing this type of care. So with that, we would ask for an unfavorable report.
Good evening. My name is Elizabeth Pinolini, and I thank the committee for allowing me to testify in opposition to House Bill 679 regarding hormone therapy for minors and to share my own experiences in pursuing gender-affirming care as a trans person. Today, I am before you as a 33-year-old person, but I've known since I was about 12 or 13 that I'm queer. I didn't have the words for it back then when I was growing up, but I knew who I was and I knew what I wanted for myself and for my body. I was designated male at birth, and I knew that going through puberty was mentally excruciating. I knew that every day brought more and more unwanted changes to my body, and there was nothing that I could do about it other than to suffer and cry and wonder so many times why I couldn't have been born with a different body. You've heard testimony today suggesting that teens are too young to know what they want from themselves, but I wasn't. 2 decades later, I still think about how much happier I could have been had hormone replacement therapy been available to me as a teenager. We've also talked about detransitioning, but the empirical data strongly shows that people are more satisfied when they have access to gender-affirming care. In a 2022 U.S. trans survey of nearly 93,000 trans and non-binary individuals, 98% reported more satisfaction with life after beginning hormone replacement therapy, and of those individuals, only 0.36% of those who medically transitioned went back to living as their sex assigned at birth because transitioning wasn't right for them. That's less than 0.5%. I am, however, one of those very few people. But the thing is, I didn't regret transitioning or beginning hormone replacement therapy. I lamented that I didn't get to start transitioning until I was already 24. Because I was forced to wait so long and forced to endure puberty that I vehemently did not want, I didn't get the results that I had hoped for from HRT. And the 10 years between knowing who I was and being able to do something about it made all the difference. Being able to access gender-affirming care as a minor would have made all the difference. And so I come to you today and ask you to please report unfavorably on this bill. Do not take away those options from trans youth. I desperately would have wanted those options myself growing up. Please do not take it away from children today. Thank you.
Thank you for your time. My name is Osha Zaks. I'm transgender and I'm autistic. I earned my doctorate in human development. I'm also a certified rehabilitation counselor, and I have worked with hundreds and hundreds of gender divergent and neurodivergent teenagers and young adults for over 2 decades. And what I can say unequivocally, and that I can support myself with tons of research as well as personal and professional experience, is that gender-affirming care saves lives. Let me repeat that, it saves lives. I know that it saved my life. It hasn't been banned. What we're seeing is safety protocols put in place, which leads to my first point, which is that when we become professionals, whether that's doctors of physical medicine or in mental health, we spend years training. We have to take exams. We have to get licensed and certified, and we continue our education for our entire careers. We also follow ethical standards for each of our professions. And we take those ethical standards very, very seriously. Those ethical standards are in place to protect our patients, and we are mandated to do no harm. In my case, transitioning took several years. I was required to see a therapist. She made sure that I understood the risks and benefits before anything could happen. The decisions around gender-affirming care are made very carefully and delivered ethically among the professionals, the patient, and in the case of my nurse, their parents. What kills people is living in a society that doesn't accept you. What kills people is living in a society where no one believes you. What kills people is not being able to get the medicine and the medical care that you need to take care of yourself. What we do know is that gender-affirming care, like I said earlier, saves lives. So if you want to protect the children that we all love and care about dearly, please vote no on this bill. Thank you.
Thank you for your testimony, and thank you for sharing your very personal stories as well. I'm going to open it up to the members for any questions. Seeing none, thank you to this panel. We do have another unfavorable panel. So if I can call up Evan West, Emily Shaw, Teresa Kramer, C.A., and Chloe Kastner. And when you're ready, you can start your testimony. Who wants to start? No.
Good evening, Madam Chair, Vice Chair, esteemed members of the panel. I want to thank you all for staying this evening to hear our testimony. I know it's a late night for everyone. My name is Chloe Kastner. I am a student at the University of Maryland, Baltimore School of Social Work and trans adult that has lived in Maryland my entire life. One thing that's become evident listening to this testimony tonight is that everyone in this room on both sides really cares about protecting children. And we've heard some really tragic stories from the folks in support of this bill, and I really empathize with that, and I know those were hard to listen to, and I don't think anybody up here wants that experience for anyone. But what I'll add to that is I went through male puberty, and what those folks experienced is what I experienced. I listened to my voice deepen. I watched hair grow on my face, my legs, all of these things because I didn't have access to gender-affirming care at that time. And on the opening panel, we heard statistics like there's no increase in suicides, but that doesn't reflect the increase in suicidality and self-harm. We heard that a significant number of folks experience a reduction in distress in adulthood, but that's not everybody. We've heard these are irreversible changes, but so is going through opposite puberty. So this medical care is important. It saves lives. I will tell you, in my 20s, I tried half a dozen different mental health medications to try to treat my depression, my anxiety, and nothing worked. The day that I started gender-affirming care, my suicidality decreased. And over the course of months, my depression went away completely and has been gone for years. For these reasons, I do urge an unfavorable report on this bill. Thank you.
Excuse me, Madam Chair, members of the committee, thank you for the opportunity to testify in front of you tonight. My name is Evan West. I'm from Cumberland, Maryland. My pronouns are he, him. I am also a cisgender heterosexual male. I come in front of you tonight to urge an unfavorable report on HB 679 as someone who helped to organize the original Cumberland Pride celebration and who is currently an organizer and an advocate on behalf of LGBTQIA folks in the western part of the state. What I've heard tonight has so much less to do with science than it has to do with politics. The science is clear that gender-affirming care is beneficial. What we've seen across the world and in this country is not a change really in the scientific understanding of what gender-affirming care amounts to, as much as it is political winds blowing in a direction that has empowered people to seize an opportunity to try to weaponize this issue as a political issue. And they've seen that it's been successful, and they want to give it a try here. What I would say to you is that in Western Maryland, as someone who has advocated for LGBTQIA folks in that part of the state, we witnessed the actual effects of the removal of gender-affirming care at UPMC in Pittsburgh. And there were folks in our community there that received gender-affirming care in at that facility. And I urge you to look at my written testimony. There's one link there to a really comprehensive set of anecdotes and stories about folks who were receiving gender-affirming care at UPMC in Pittsburgh at their adolescent gender-affirming care clinic there, and what the loss of that care actually meant in real terms, how it actually affected their lives. And ask yourself at that point if you're okay with that happening here in this state. Because if you're not, then the smart and courageous thing to do is to stand up for those people who need that care and who depend on it day in and day out. So I urge an unfavorable report on this bill. Thank you.
Hi, my name is Teresa Kramer, and I reside in Baltimore County, and I am one of the petrified parents that Charlotte talked about, but I decided to come down anyway because I think it's important for you to hear the story of a parent. And so I am asking you to oppose House Bill 679 because I want you to respect the relationship between patients and practitioners, healthcare practitioners. And when we're talking about minors, that means parents. And so I just feel that parents understand their kids more than anybody else could ever. And I know from my own personal experience of, we've been able to access healthcare providers that were very experienced and very knowledgeable. And, you know, my heart goes out to the people who talked today who didn't seem to have those kind of healthcare practitioners, because mine was so opposite of that. So for my child, you know, it was years and years. It wasn't just an overnight thing. It was years. We knew from the time when my child was very young that they were different. And so when it came time to adolescence, we were able to access healthcare, and we had somebody who was able to explain the challenges and choices and risks and benefits and took the time and were able to stall for a while with puberty blockers. But in the end, we decided that cross hormones were what was the right choice for my child. And so it's not for everybody, but it was right for mine, and I really don't want that to be taken away from me as a parent or from other parents who are in the situation that, that we were in. So I thank you for your time tonight. Thank you for staying late. And I just ask you to vote unfavorably for Bill 679.
Chair Bagnall and members of the Health Committee. Hello, my name is Emily Shaw. I live in Montgomery County. In a previous life, I used my doctorate in political science to teach state and local government at a small college in Maine, so it's pretty neat to be engaging in the work from the constituent advocate side too. But more importantly for this room at this moment, I am also the mother of a transgender child. My daughter went through the Montgomery County school system. She did it very well. She was very successful. She graduated with 4 years of all A's and got a 1570 on her SATs first try. You'll forgive me for bragging. There are so few opportunities. And she's currently a freshman in college. My daughter came to my husband and me in 10th grade and let us know she was not a boy. I asked her if she'd like to see someone to discuss it, and she said she did. At the end of a period of therapy, her therapist called us in and confirmed with us that she was transgender. At her request, we then took her to get further screening for the appropriateness of hormone therapy, and after a series of assessments with other medical providers, she was started on a medication. While my daughter was always a very good student, she truly blossomed in adolescence only after coming out to us and her community at school. She was formerly someone who basically shunned extracurriculars, but she seemed to relax and open up, joined an out-of-school singing group. She started acting, writing for the school lit mag. She took classes in improv. She watched the changes in her body with a lot of joy. It was really evident. And I'm so happy that we had the ability to support her in starting medical care that was so clearly right for her and set her up for success in life. The ability to engage with the world, to be fully yourself in it, to not be scared of yourself. Taking this care away from people like our family threatens to snuff out not just joy, but life. You're threatening people's lives with this bill. Gender-affirming care is life-saving care. Recent information coming out from the UK from the Good Law Project, FOIAing the NHS in the period after the end of hormone blocker, puberty blockers were installed, led to the death of 22 transgender children who killed themselves, a huge 6-time increase from the year before. So taking a similar decision would be really devastating for our state. I urge you to take an unfavorable report on this bill.
Hi, everybody. Dear Chair Bagnall and members of the Health Committee, my name is Kola, and I'm a community organizer and leader of the Bridges Coalition for Overdose Prevention Centers. I'm also a trans woman who has been on hormone replacement therapy for over 10 years, and it has completely saved and changed my life. Access to this kind of care as a minor would have changed my life for the better then and now. I was finally able to access gender-affirming care in my 20s. I was told by doctors that it was too late to prevent some of the irreversible effects of puberty on my anatomy. This time, prior to HRT, was the most uncomfortable, gender dysphoric, and suicidal period of my life. Before I had access to hormone replacement therapy, I was deeply oppressed and depressed. I grew up facing relentless teasing, bullying, and assault, which ultimately led to me dropping out of high school. I was never seen as myself and missed out on normal experiences like dating. I wish I had been able to take hormones earlier on in life. In this trans-violent society, passing a cyst can equate to safety. Giving minors access to HRT could help them live a safer, happier, and more liberated life later on as adults. Protecting access to gender-affirming treatment is a community harm reduction strategy supported by public health research. Without access to these essential services, our state risks pushing vulnerable trans and gender-diverse Marylanders further into the margins, exposing them to unemployment, housing discrimination, harassment, and interpersonal violence. This is an emergency, and we urge you to act now. I ask that the Health Committee give HB 679 an unfavorable report. Thank you.
Thank you all very much for your testimony and for sharing your personal stories. Do we have any questions from the members? Oh, Delegate Johnson.
Thank you, Madam Chair, and thanks for coming and sharing your stories. So for me, it was good to hear from parents and some perspectives of what you went through with your children. So I know how the parent to my right, how her daughter's doing and how old she is. So if you wouldn't mind, the parent on the left end, if you could tell us how old is your child and how are they doing?
Sure. Thanks for asking. My child is also 18 and a freshman in college, and is doing very well. Very, very pleased, very happy with themselves. And I'm so thankful that we were able to access the medical care that we were able to get, because I don't believe they would be that way if we were not able to.
Thank you, Madam Chair.
Thank you. Seeing no further questions, thank you for your testimony. We have one more unfavorable panel. So if I can call John Jason, Lee Blinder. It's all right. We're at the end, so you don't have to give up your time. Catherine Hill.
It's really just me up here?
I get to go too.
Oh, okay.
I'm very short.
Sorry about that.
And thank you all for your patience. I know this is a late night, but this is important, so thank you.
Okay. Sorry, I'm old. I now need these. All right, Chair, Vice Chair, and members of the House Health Committee, thank you for your time. I ask that this evil be brought to an unfavorable vote as soon as possible. This viciousness against trans children, it's not new. During the time of the Weimar Republic, the Institute for Sexual Science was formed. They birthed the modern movement where we now use terms like transgender, non-binary, and gender fluid. They broke new ground in hormone treatments and in gender-affirming surgery. The bigotry we face in this proposed legislation today, it's not new. The Institute was targeted as the Nazi progenitors of the modern MAGA movement grew in power. Members were slated for assassination. The Nazi propaganda machine ruthlessly slandered them, lied about them, and sent them death threats, and they feared for their lives. When the Nazis took control, they criminalized this research and destroyed all the science they could get their hands on. Scientists, researchers, practitioners, and patients who could not escape, their future were the concentration camps. The Nazis destroyed the Institute. I suppose we should feel thankful that this current attempt only seeks life in prison. This malice is not new. The lie about how this is to protect children is also old. The Nazis claimed controlling the Jews was necessary, in order to protect the children in a dark era of history known as blood libel. It remains our duty at all times to fight for good. Vote down this child of right-wing Nazi gender ideology. Thank you.
My name is Catherine Hill, and I want to start by saying that may sound overstated, but if any of you have taken a look at the news and what we see today outside, I see the kind of brutality and hostility and racism and dislike and inability to sort of deal with people who are different. So I think that talking about fascism is unfortunately very pertinent today. I just want to make 2 points. First, my name is Catherine Hill, and I'm a longtime Maryland resident. I have worked for many, many years, about 30 years, in the women's community, and worked including leadership positions with the American Association of University Women, with the Institute for Women's Policy Research, for the Women's Bureau in the U.S. Department of Labor. And currently I'm teaching at George Washington University in the Women's Studies, Women's Gender and Sexuality Studies program. So I've worked on this issue for a long time, and I will say without any hesitation that we've now learned as a community that gender is not simple, it's not binary, and it's not obvious at birth. There's many, many, many women's organizations that you can look to. I recommend people take a look at some of the publications of the National Women's Law Association would be one. The National Women's Law Center, and then also the National Women's Studies Association. There's been a great deal of research that I think is out there already, so I won't bore you with that. I will suggest that those of you who referred to some of the European studies, particularly the CAST report, take a look at that report, because that report actually is very favorable in looking at this as a very real medical concern. They simply are looking for more research, so they have not reduced. This is not a claim. Those studies did not say, let's not have any gender-affirming care. It said, let's do so and let's study it harder. Other point I want to make today, I know we're all ready to go home, but parental rights is something I'm here not because it affects me personally, but because I see so much that we are not listening to these parents and treating these parents in the same way we think about other parents. Parental rights are extremely important, and I think that who better? Should I make the decision? No. Should legislators make this decision? No. The parents who know and love their children, we should assume the best. They have access to great medical advice and care. We started today with some examples of malpractice. Now I think we know plenty of practices that are not malpractice.
Thank you so much. Before I open it up to questions, I just wanted to make sure I didn't miss anyone. Is there anyone who is here to testify on this bill that I did not call? Okay. Delegate Morgan.
Thank you, Madam Chair. Question for the gentleman or person on the right. Are you comparing the people that support this bill to Nazis and fascists?
Yes.
Okay, so comparing this bill in a difference of opinion to a regime that killed 6 million people is not only insulting and inciting violence, it's also historically illiterate. So, thank you.
There's nothing historically illiterate about my testimony, especially with people who are intending to harm trans children.
Are there any other questions from the members? Seeing none, we know that this is a very, this is a very complex issue, and it is a very emotional. I think that one of our speakers spoke to the fact that it's very clear that everyone here who is here tonight is concerned about the well-being of our children. And through that lens, we will continue to consider this legislation. This does conclude the bill hearing on House Bill 679, and it concludes our bill hearings for today. Thank you all very much for your patience and for staying with us. Please let us know when we're down.